ಎಲ್ಲಿದೆ ಕವರ್ ಅದು ಮತ್ತೇನ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಮೇಡಮ್? stay ಇದೆ. There is no notice. It is issued and come back. All these things are incorrect. Find out from the court records what has happened. Pass over. It is pending since 2021. Pass over. Afrit. ಏನಾಗಿದೆ ಅದು? ನೋಟಿಸ್ ಟು ದಿ ಪೆಟಿಷನರ್ ಏನಾಯ್ತು? ಅವೈಟ್ ಅಂದ್ರೆ ಎಲ್ಲಿಗೆ ಹೋಗಿದೆ? ಥ್ರೂ ಜೈಲರ್ ಅಂತ ಹೋಗಿರ್ಬೇಕು. ಪಾಸ್ ಓವರ್ ಏನಾಗಿದೆ ಕೇಳಿ. ಸುಮ್ನೆ ಹಂಗೆ ಇಟ್ಕೊಂಡು ಕೂತ್ಕೊಂಡಿದ್ರೆ ಏನರ್ಥ? 34 BT Venkatesh. Pass over.
35 36 Chandra Kumaregowda.
Pass over.
37 Karnataka.
Pass over.
38 Harish Kumar SC.
Pass over.
39 Pradeep Kumar SC.
ಹೇಳಿ.
Recently location to bring this the compliant came to number 2 came and check this banners and taking this banners completely
Right.
The EF number 122 also handed over to the that petitioner only today said channels, but the present account number 2 and 7 were started and taken away. Okay, it is not required for any. Going something for the person of yes, what is what are you found out guys? Are you guys what are you found out?
ಯಾರು?
How can I recovery now?
ಫೋನ್ ಮಾಡಿದ್ಯಾರು? ಯಾಕೆ ಬುಕ್ ಮಾಡಿದ್ರಿ? ಏನ್ ಹೇಳ್ತಾನೆ ಸೆಂದಿಲ್ಲು? ಏನ್ ಮಾಡಿದ್ರು ರೀ? ರಿಕವರಿ ಆದಾಗ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನಿದೆ ರೀ? ಅದನ್ನ ಬಿಟ್ಟಿನೆಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ನೀವು. ಅದೊಂದು ಬಿಟ್ಟು ಇನ್ನೆಲ್ಲ ಹೇಳಿದ್ರಿ ನೋಡಿ ನೀವು. ಓ ಗೋ ಅಂಡ್ ಅಪಿಯರ್ ಬಿಫೋರ್ ದಿ ಐಒ. ಮಾಡೇನ್ ಮಾಡ್ಬೇಕು ಮುಂದೆ ಒಳಗಿರಿ ಹೇಳ್ತಾರೆ ಎಷ್ಟು ಜನಕ್ಕೆ ಈ ತರ ಟೋಪಿ ಹಾಕಿದಿರೋ. ನೀವು ಹೊಡಿತೀರಾ ಅಂತ ಅವರು ಬಂದಿಲ್ಲ. ನೀವು ಹೊಡಿತೀರಾ ಅಂತ ಬಂದಿಲ್ಲ. You use third degree methods. She is a lady, therefore she is feared. ಚಿನ್ನದ ಬಳೆ ಆಸೆಗೋಸ್ಕರ ಅವೆಲ್ಲ ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ. ವಜ್ರ ಕೂಡಿಸಿರೋ ಚಿನ್ನದ ಬಳೆ. Yes, heard. Question under section 438 CRPC. With the following prayer, three facts of the case are as under. Petitioner herein contacted Balaji, who is having a shop wherein diamond and gold ornaments would be sold and it would be graded as per the requirement of the hallmark poster. He has a assistant by name Satish and Sendil poster. Complainant received a call from the petitioner through Sendil on 15/11/2020 stating that she is in need of the petitioner is in need of a pair of gold bangles poster. Accordingly, the complainant sent the gold bangles through Satish worth 10 lakhs poster. However, Satish has carried the bangles and later on the bangles were taken away by Satish and Sendal in active collusion with the petitioner. Poster. Based on the said complaint, Sampigehalli police registered a case in crime number 168 of 2020 for the offence pursuant under section 420 IPC against the petitioners and two others. Poster. After registering the case, investigation agency is able to arrest Senthil and Satish. Senthil and Imran and were able to recover the gold ornaments, poster, gold bangles, poster. The voluntary statement given by the accused specifically revealed that they had taken away the bangles at the behest of the petitioner herein. Poster. The petitioner is absconding and she has approached the district court for grant of bail in criminal miscellaneous number 10/401 of 2021. Poster. The learned district judge on contest rejected the said bail application by order dated 1st December 2021. Poster. Next para. Thereafter, petitioner is before this court. Next para. That counsel for the petitioner vehemently contended that petitioner is innocent of the offences alleged against her and based on the voluntary statement given by Senthil, arrest present petitioner and sought for grant of anticipatory bail. Poster. They also contended that the gold bangles taken away by Senthil and Imran is seized by the investigation agency and therefore custodial investigation of the petitioner is not warranted in the case on hand and thus sought for grant of anticipatory bail. First, Parkan HGP opposes the bail petition, contending that the voluntary statement given by Imran and Sandil clearly shows that the petitioner had an active role.
Come Guru Swan.
ಆಫ್ ಮಾಡ್ರಿ ರಿಯಲ್ಮಿ ಅವ್ರು ಯಾರು ತೆಗೆದ ಪಕ್ಕಕ್ಕೆ ಹಾಕ್ರಿ ಅವ್ರನ್ನ ಯಾವ ಕೇಸ್ ನೋಡ್ರಿ ಅವ್ರು ಆಮೇಲೆ ಪ್ರಜ್ಞೆ ಇರ್ಬೇಕು. ಆಯ್ತು. In the incident, and it is her behest that Senthil and Imran had taken away the gold bangles belonging to the complainant and therefore sought for rejection of the bail petition. First, next paragraph. In the rival contentions, this court heard the parties and this court produced the material on record meticulously. First, next paragraph. The gold bangles of the complainant is seized by the police and is also produced before the current magistrate. First, the same is seized in pursuance to the voluntary statement given by Senthil and Imran. First, since the gold bangles are already seized by the police, to that extent, investigation agency is successful in investigating the matter. First, however, from the date of registration of the case, the petitioner is absconding. First, the statement given by the co-accused persons would point out finger towards the petitioner herein. First, further, she has not been available for the investigation even after dismissal of her petition. Her petition seeking grant of anticipatory bail on 1st December 2021. First, abscondence of the accused has crippled the investigation. First, therefore, necessity has arisen for this court to balance the right of the petitioner as well as the need of the prosecution. Accordingly, following order is passed, petition allowed. Petitioner is directed to join the investigation by appearing before the investigation officer on 23/3/2022 at 10 a.m. First, investigation officer shall take the petitioner to custody and complete the custodial investigation on the same day before 6 p.m. and thereafter Mikidalaku. Again, relaxation. ಮಾಡಿ ಸರಿಯಾಗಿರೋದೇನಾರ ಇಲ್ಲೆಲ್ಲ ಬೇಡ, ಆಫೀಸ್ ಇದೆ ಅದಕ್ಕೆ, ಅಲ್ಲಿ ಹೋಗಿ ಕ್ಲೀನ್ ಆಗಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ ಮಾಡ್ತೀವಿ. ಯಾಕಂದ್ರೆ ಅದರ್ವೈಸ್ ಇಟ್ ಗಿವ್ಸ್ ಎ ರಾಂಗ್ ಸಿಗ್ನಲ್ ಫಾರ್ ಅದರ್ಸ್. ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಹಾಕ್ಬಿಡಿ ಕೇಳಿ ನಿಮ್ ಕೊಲಿಗಿದ್ದು ಹಾಕಿ ಪಾಸವರ್ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಹಾಕ್ಬಿಡಿ. Lakshminarayan Shetty, pass out. Trivikrama.
Please, my lords, this case, my lords, the senior advocate, Mr. Murthy Naik is engaged, my lords. I see him logged in, my lords. May I request for a passover, my lords?
Passover.
Please, obliged.
Vinaya. Passover. ಏನದು ರಿಗಾರ್ಡಿಂಗ್ ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಅಷ್ಟೇ ತಾನೆ. ಅರೆಸ್ಟ್ ಆಗಿದ್ದಾರೆ ಅಂತ ನೀವು ಮೆಮೊ ಹಾಕ್ಬಿಟ್ರೆ ನಂಗೆ ಸಾಕು. ಅಯ್ಯೋಗ್ ಫೋನ್ ಮಾಡಿ ಕೇಳ್ಕೊಳ್ಳಿ. 45 ಏನಾಯ್ತು? 46. Serial number 46, 47,
48, Bharat Kumar. Number 49, SPP.
just ಕೊಡಿ ಹೇಳಿ ಏನದು ಅಂತ. $49, Mohammed Azam. Why do you want cancellation, PP? All right, serious allegation is the court has taken into your objection and passed the order. Kindly see where the court has not considered your case. Injury ಏನು attempt ಗೆಲ್ಲ ಏನ್ ಮಾಡಕ್ ಬರುತ್ತ್ರಿ ಒಳ್ಳೆ ಚೆನ್ನಾಗಾಗಿದೆ. Third, Lord SPP, Lord HGP, first respondents 1 to 14, those served remained absent. The petition filed under section 439 subclass 2 CRPC with the following prayer. Three facts of the case are as under. Upon a complaint lodged by Sumaya Tarunum, Women Police Chikmagaluru registered a case against the respondents herein for the offences punishable under section so and so ilide nodkoma 147 so and so ilide page number 33. First, the petitioners, the respondents approached the second additional district and session judge Chikmagaluru for grant of anticipatory bail in semis number 456 of 2021. First, learned district judge, after hearing the prosecution, allowed the petition filed under section 438 CRPC with following conditions. First, ನೋಡಿ page number 10. First, the complaint governments basically reveal that the marriage of the complainant took place with the first respondent on 21st December 2003 in Ajam Shadi Mahal, Chikmagaluru. First, during the marriage, at the time of marriage, 150 grams gold, 45,000 rupees cash, and also household articles worth 15 lakhs were given. First, soon after the marriage, within a month, there was a death in the family. First, taking into account said aspect of the matter, the respondents 1 to 14 started abusing the complainant, stating that her marriage has resulted in the death as she is not having good virtues. First, the harassment continued, and thereafter there was a panchayat convened. First, during the panchayat, another 50,000 rupees was paid by the parents of the complainant. First, thereafter again, the respondents started abusing the complainant, stating that she is ill-fated lady and she is not able to conceive. Posta. Posta. In 2013, her husband had a surgery wherein one kidney of her husband was removed. The respondents blamed the complainant for the same. Posta. Again, in 2017, she had undergone a surgery and got removed ovarian cyst, OVERIAN, ovarian cyst. Posta. In 2019, at about 8 p.m., January 2019, one day at about 8 a.m., her husband, parents-in-law, and others assaulted her and demanded 25 lakhs. ಏನ್ರಿ ಇದು 25 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡ್ಬೇಕಂತೆ as the additional dowry and assaulted her with a plastic chair. Posta. They also told that if the said demand is not met, she would be divorced. Posta. Based on the said complaint, the police registered the case as referred to above. Posta. The learned district judge has taken note of the above factual aspects and used his discretion and granted anticipatory bail to the respondent number 14. Posta. Next para. Learned HGP content reiterating the grounds urged in the petition contended that when there are serious allegations leveled against the respondents 1 to 14, the learned district judge ought not to have granted anticipatory bail to the respondents number 1 to 14. Posta. He further argued that the custodial investigation was very much necessary in order to unearth the truth in the incident and therefore sought for cancellation of the said bail. Posta. Next para. Respondents, those served with the notice, remained absent and therefore this court perused the material on record. Posta. As could be seen from the complaint government itself, the marriage has taken place in the year 2003. Posta. There are series of allegations made right from 2003 till up to 2019 and finally on May 15th of 2021. Posta. The allegations made in the complaint clearly shows that the petitioner, the complainant, withstood certain discomforts in the house. Posta. No attempt is made on behalf of the complainant to lodge the complaint earlier against the alleged harassment. Posta. Except for a panchayat that was convened in the year 2003, no other positive materials are found on record, at least at this stage. Posta. Next para. It is settled principles of law that at the time of considering the rejection of the bail, yardstick applied to be applied by the court is that whether the granting of the bail has prejudiced the investigation agency or the complainant. Posta. In the case on hand, there is no complaint that the respondents 1 to 14 have violated the conditions imposed by the learned session judge while granting the anticipatory bail. Posta. Only on the ground that Section 307 IPC has been invoked by the investigation agency, this court cannot resort to cancel the bail granted by the learned session judge by resorting to the discretionary power vested in the district court, district judge. Posta. Next para. Further, from the grounds in the petition, this court is unable to comprehend that there is a improper exercise of discretionary power in favor of the response number 1 to 14. First, therefore, this court is of the considered opinion that no grounds are made out, much less good grounds, to cancel the bail granted by the learned district judge in series number so and so. Accordingly, following orders. Yan sumna idikella hakondiddiri. Subhash Chandra Bose. ಹೇಳಿ ಬೋಸ್ ಅವರೇ, ಏನಿದು? ಒಬ್ರೇ ಅಕ್ಯೂಸ್ಟಾ? 366 ಹೆಂಗ್ ಬರುತ್ತೆ HGP? ಫೈನಲಿ ರೀಡ್ 366 ನಿಮ್ಮ ಪೊಲೀಸ್ನವ್ರಿಗೆ ಇದನ್ನೆಲ್ಲ ಹೇಳ್ಬೇಕು. ಗೊತ್ತಾಯ್ತಲ್ಲ, ನಮ್ಗೆ ಹೇಳಿ 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 ಗಂಟ್ಲೆಲ್ಲ ಬಿದ್ದೋಗಿ. ರೀಡ್ 366 ಅವ್ರಿಗೆ IPC ಪುಸ್ತಕ ಕೊಡಮ್ಮ. ನೀವು ಅದನ್ನ ಹೇಳೋದ್ ಬಿಟ್ಬಿಟ್ಟು ಆ ಗ್ರೌಂಡೇ ಇಲ್ವಲ್ರಿ ಬೋಸ್? ನಿಮ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಆ ಗ್ರೌಂಡೇ ಇಲ್ಲ. ಏನ್ ಹೇಳ್ತೀರಿ 366A? ಅದ್ ಬೇಡ, IPC ಕೊಟ್ಟು ಓದಿಸ್ಬೇಕು. ಅದು ಓದಿದ್ರೆ ಉಪಯೋಗ ಇಲ್ಲ. ಇರ್ಲಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಯು ಹ್ಯಾವ್ ಲೆಂಟ್ ಯುವರ್ ಸಪೋರ್ಟ್. ಇಟ್ಸ್ ಓಕೆ. ಲೆಟ್ ದಿ HGP ರೀಡ್. ಗಟ್ಟಿಯಾಗಿ ಓದಿ. ವಿತ್ ಅನದರ್ ಪರ್ಸನ್ ಅಂತಿದೆ, ಗೊತ್ತಾಯ್ತಲ್ಲ? ವಿತ್ ಅನದರ್ ಪರ್ಸನ್ ಅಂತಿದೆ. ಒಂದು ಹೆಣ್ಣು ಮಗಳನ್ನು, ಮೈನರ್ ಹೆಣ್ಣು ಮಗಳನ್ನು ಅವರ ಪೋಷಕರ ಅಭಿರಕ್ಷೆಯಿಂದ ಅಪಹರಿಸಿಕೊಂಡು ಹೋಗಿ ಆಗ್ಬೇಕು ಅಂತಿದೆ. ಯಾವ ಕಾರಣಕ್ಕೆ? ಆಕೆಯನ್ನ ಇನ್ನೊಬ್ಬರ ಹತ್ರ ಲೈಂಗಿಕ ಕಿರುಕುಳಕ್ಕೆ ಒಳಪಡಿಸೋದಕ್ಕೋಸ್ಕರ ಅಂತ. ಅವಾಗ 366ಗೆ ಬರೋದು. ಒಬ್ಬೇ ಅಕ್ಯೂಸ್ಡ್ ಯಾರ ಹತ್ರ ಅನದರ್ ಅನ್ನೋದು ಇಲ್ವೇ ಇಲ್ವಲ್ಲ. ಬಡ್ಕೊಂಡ್ ಸಾಕಾಗೋಗಿ ಪೊಲೀಸ್ನವ್ರಿಗೆ ಬುದ್ಧಿ ಬರೋದಿಲ್ಲ. ನೀವು ಅದನ್ನ ಹಂಗೆ ಇಟ್ಕೊಂಡ್ರಿ. ಇದ್ರ ಮೇಲೆ ಅವ್ರಿಗೊಬ್ರು ಪ್ರಾಸಿಕ್ಯೂಟ್ರು ಇದೇ ತರ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಒಬ್ಬ ಸಿಂಗಲ್ ಅಕ್ಯೂಸ್ಡ್ ಮೇಲೆ. ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಇನ್ ಸಮ್ ಕೋರ್ಟ್ಸ್ ದಿ ಚಾರ್ಜರ್ಸ್ ಆಲ್ಸೋ ಫ್ರೇಮ್ ಅಂಡರ್ 366ಗೆ. ನಾವೆಲ್ಲೋ ಟ್ರಯಲ್ ನಡೆಸಿ ಫೈನಲ್ ಬಂದಾಗ ನೋಡ್ಬಿಟ್ಟು ಈ ಚಾರ್ಜ್ ನ ಆಲ್ಟ್ರೇಷನ್ ಕೇಳ್ಬೇಕು. ಅರ್ಥವಾಯ್ತೆ? ಎಲ್ಲಿ ನಿಮ್ ಗ್ರೌಂಡು? ಇವತ್ತೇ ಸರ್ ನಾನು ನೋಡಿದ್ದು 366 ಏನಲ್ಲಿ ಅನದರ್ ಅನ್ನೋದನ್ನ. ಹೌದಾ? ಏನ್ ಮಾಡೋದು ಮಿಸ್ಟರ್ ಬೋಸ್? ಎಸ್, ಅದ್ ಬಿಟ್ಬಿಡಿ. 366 ಬಿಟ್ಬಿಡಿ. ಟೆಲ್ ಮಿ ಅಬೌಟ್ POCSO. ವಾಟ್ ಇಸ್ ದಿ ಏಜ್ ಆಫ್ ದಿ ವಿಕ್ಟಿಮ್? 14. ಏನ್ ಮಾಡೋದು ಮತ್ತೆ? ಆರ್ಡರ್ ಮಾಡೋದಾ? ಅದೇನಾದ್ರು ಮಾಡಿರ್ಲಿ, ಆರ್ಡರ್ ಮಾಡೋದ ಅಂತ ಕೇಳಿದೆ ಅಷ್ಟೇ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮುಗಿದೆ. ಆಮೇಲೆ ತಾವೇನ್ ಬರ್ದಿದ್ದೀರಿ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ? ಓದ್ತೀರಾ? ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಏನ್ ಬರ್ದಿದ್ದೀರಿ ನೋಡಿ, ಏನ್ ಬರ್ದಿದ್ದೀರಿ ನೋಡಿ. ಪೆಟಿಷನರ್ ಇಸ್ ಇನ್ನೋಸೆಂಟ್ ಅಂತ ಬರ್ದಿದ್ದೀರಿ ಮೊದಲನೇ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ. ಹೌದಾ? POCSO ಆಕ್ಟ್ ಇದೆಯಾ ಪುಸ್ತಕ? ಕೊಡಮ್ಮ ಅವ್ರಿಗೆ. ಸೆಕ್ಷನ್ 29 ಓದಕ್ಕೆ ಹೇಳೋರು. (29, 30) ಎರಡನ್ನೂ ಸ್ವಲ್ಪ ಗಟ್ಟಿಯಾಗಿ ಓದ್ಬಿಟ್ರೆ ಅನುಕೂಲ ಆಗುತ್ತೆ. ಅಲ್ಲ, ನನಗ್ ಕೇಳುತ್ತೆ, ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ಲೈವ್ ಇದೆ.
A person is prosecuted for committing or abetting or attempting to commit any offence under section 3, 5, 7 and section 9 of the Act. The special court shall presume that
ಅಲ್ಲೇ ಸ್ವಲ್ಪ shall presume what? Shall presume what?
that such person has committed or abetted or attempted to commit an offence. That is the case may be. Unless
One second. ಅಲ್ಲಿಗೆ ಏನಾಯ್ತು? ಈ ಗ್ರೌಂಡ್ ಹೋಯ್ತು ಇನ್ನೋಸೆಂಟ್ ಅನ್ನೋದು. See, a person who is charged with the offence under section 302 IPC, most heinous, entitled for the capital punishment, he is having the benefit of innocence. Follow me, but not a POCSO, not an accused with charge under section 4 or 6 of the POCSO. ಓದಿ ಮುಂದೆ. ಯಾವ್ಯಾವ ಸೆಕ್ಷನ್ ಅಂತ ಇತ್ತಲ್ಲ ಮೇಲೆ.
section 5, 7, section 9 of the Act.
ಅಲ್ಲಿಗೆ ಏನಾಯ್ತು? 5 ಅಂದ್ರೆ 5 ಪನಿಷ್ಮೆಂಟ್ ಸೆಕ್ಷನ್ ಫಾರ್ 4, 7 ಪನಿಷ್ಮೆಂಟ್ ಸೆಕ್ಷನ್ ಫಾರ್ 6, 9 is punishment section for 8. So 4, 6 ಮತ್ತು 8 ಈ 3 ಸೆಕ್ಷನ್ ಗಳಲ್ಲಿ ಒಬ್ಬ ವ್ಯಕ್ತಿ ವಿರುದ್ಧ ಪೋಕ್ಸೋ ಕಾಯ್ದೆ ಅಡಿ ಆರೋಪ ಹೊರಿಸಿದ್ದಾರೆ ಅಂದ್ರೆ ಅವನು ಮುಗ್ಧನಲ್ಲ ಎಂದು ಪರಿಭಾವಿಸಬೇಕು ಕೋರ್ಟ್. ಅರ್ಥವಾಯ್ತಾ? ಸೊ ನಿಮ್ಮ ಫಸ್ಟ್ ಗ್ರೌಂಡ್ ಹೋಯ್ತು, ಐ ಆಮ್ ಇನ್ನೋಸೆಂಟ್ ಅಂತ. ಶಾಲ್ ಪ್ರಿಸ್ಯೂಮ್ ಇರೋದು ಮೇ ಅಲ್ಲ ಅದು ಶಾಲ್ ಪ್ರಿಸ್ಯೂಮ್. ನನಗ್ ಬೇರೆ ದಾರಿನೇ ಇಲ್ಲ. ಇವನು ಕಳ್ಳನೇ ಎಂದು ಅಲ್ಲಿಂದ ಶುರು ಆಗ್ಬೇಕು. ಇವನು ಮುಗ್ಧ ಅನ್ನೋದ್ರಿಂದ ಶುರುವಾಗಲ್ಲ. ಗೊತ್ತಾಯ್ತಲ್ಲ? ಆಟ ಶುರುವಾಗೋದೇ ನೀವು ಮುಗ್ಧರಲ್ಲ ಅಂತ. ಮುಂದೆ 30 ಓದ್ಬಿಡಿ ಸೆಕ್ಷನ್ ಏನಾಗುತ್ತೆ ಅಂತ.
Description of culpable mental state in any prosecution for any offence under the Act, which reflects culpable mental state on the part of the accused. The special court shall presume the existence of such mental state, but it shall be a defense for the accused to prove the fact that he had no such mental state with respect to act that has the offence in the prosecution.
ಆಯ್ತಲ್ಲ? ಈಗ ಇಂಡಿಪೆಂಡೆಂಟ್ ಥಾಟ್ ಡಿಸಿಷನ್ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. ನೀವ್ ಹಿಂಗ್ ಹೇಳ್ತೀರಾ ಅಂತಲೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರು ನಮ್ಗೆ ಹಿಂಗ್ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದು ಓದಿ, ಕೆಳಗಡೆ ಇದೆ ಹೆಡ್ ನೋಟ್. ಕೊಡ್ತೀರಾ? ತೆಗೆಸ್ಕೊಟ್ಬಿಡ್ತೀನಿ, ಟೈಮ್ ಎಷ್ಟಾಗುತ್ತೆ. ಅಲ್ಲಿ ಬಲಗಡೆ ಸೈಡ್ ಹೆಡ್ ನೋಟ್ ಕೆಳಗಡೆ ಇದೆ ನೋಡಿ, ಅದು ಓದಿ ಗಟ್ಟಿಯಾಗಿ. ಮದ್ವೆ ಮಾಡ್ಕೊಂಡಿದ್ರು ಹಂಗಾಗೋಗ್ಬಿಡುತ್ತದು ಅಂತ. ಆಯ್ತಾ? ಸೊ ಮದ್ವೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಆಕೆ. ಮದುವೆ ಮಾಡ್ಕೊಂಡಿದ್ರು ಕೂಡ 18 ವರ್ಷ ತುಂಬಿಲ್ದೆ ಹೋದ್ರೆ ನನ್ನ ಹೆಂಡತಿ ಅಂತ ಹೇಳಿ ಆಕೆ ಜೊತೆಗೆ ಆ ರೀತಿ ನಡ್ಕೊಳ್ಳಕ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸೊ ಪೋಕ್ಸೋದೊಳಗಡೆಗೆ ಇದನ್ನ ಈಗ 375 6th ಜೊತೆ ಓದಿ. ಐಪಿಸಿ ತೆಗೆದು 370 ಅದ್ರಲ್ಲಿಲ್ಲ. ಐಪಿಸಿ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. 375 6th ಓದಿ ಮೇಲ್ಗಡೆ ಪೇಜಲ್ಲಿ 375 6th ನೆಕ್ಸ್ಟ್ ಪೇಜ್.
Explanation. The definition is substantial to contribute to the sexual or
375 6 ಅಂದ್ರೆ ನೀವ್ ಯಾವ್ದೋ ಓದ್ತಾ ಇದೀರಿ? ಹಳೆ ಪುಸ್ತಕ ಕೊಟ್ಬಿಟ್ಟಿದ್ರಿ ಏನ್ರಿ ಅವ್ರಿಗೆ? 375 6th.
Then she is under 18 years of age.
ಏನಾಯ್ತು? ನೀವು ಮುಂಚೆ ಓದಿದ್ರಲ್ಲ 16 years ಅಂತ, ಆ 16 years ಅನ್ನೋದು IPC ಅಮೆಂಡ್ ಆಗೋದಕ್ಕೆ ಮುಂಚಿತವಾಗಿನ ಭಾಗ. ಗೊತ್ತಾಯ್ತಲ್ಲ? 16 ವರ್ಷದ ಒಳಗಿನ ಹೆಣ್ಣು ಮಗಳು ನನ್ನ ಸಮ್ಮತಿಯ ಮೇರೆಗೆ ಈ ಕ್ರಿಯೆ ನಡೆಯಿತು ಅಂತ ಹೇಳಿದ್ರೆ ಆವಾಗ ಏಜ್ ಆಫ್ ಡಿಸ್ಕ್ರಿಷನ್ ಅಂತ ಒಂದಿತ್ತು. ವಿವೇಚನಾ ಶಕ್ತಿ ಇರ್ತಿತ್ತು. ವಿವೇಚನಾ ಶಕ್ತಿ ಇದ್ದು ಆ ಕ್ರಿಯೆಯಿಂದ ಉಂಟಾಗಬಹುದಾದ ಸಾಧಕ ಬಾಧಕಗಳ ವಿಚಾರ ಬಗ್ಗೆ ತಿಳ್ಕೊಳ್ಳತಕ್ಕಂತ ಶಕ್ತಿ ಇರ್ತಿತ್ತು. ಹಾಗಾಗಿ ಅಂತ ಪ್ರಕರಣಗಳಲ್ಲಿ ಕೋರ್ಟ್ನವರು ಯಾವ ಮಾನದಂಡವನ್ನು ಅನುಸರಿಸಬೇಕು ಅಂತ ಹೇಳಿದ್ರು, ಫಾರ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ ಗ್ರಾಂಟ್ ಆಫ್ ಬೇಲ್ ಆರ್ ಅದರ್ವೈಸ್. ಬಟ್ ಪೋಕ್ಸೋ ಆಕ್ಟ್ 2012 ಬಂದ್ಮೇಲೆ 2013 ಇದು ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ, ಇನ್ ಕಾಂಪ್ಲಿಮೆಂಟರಿ ಟು ದಿ ಪೋಕ್ಸೋ ಆಕ್ಟ್. ಗೊತ್ತಾಯ್ತಲ್ಲ? ಅದಕ್ಕೆ ಪೂರಕವಾಗಿ, ಯಾವ್ದಕ್ಕೆ ಪೂರಕವಾಗಿ? ಪೋಕ್ಸೋ ಆಕ್ಟ್ ಗೆ ಪೂರಕವಾಗಿ IPC ನಲ್ಲಿ 375 6th ಲೀನದಲ್ಲಿ ಕೊಡುವಾಗ ವಿತ್ ಆರ್ ವಿತೌಟ್ ಕನ್ಸೆಂಟ್ ವೆನ್ ಶಿ ಈಸ್ ಅಂಡರ್ ದಿ ಏಜ್ ಆಫ್ 18 years ಅಂತ. 18 ವರ್ಷದ ಕೆಳಗಿನ ಹೆಣ್ಣು ಮಗಳಿಗೆ ಆಕೆ ಸಮ್ಮತಿ ಹೊಂದಿದ್ದಳು ಈ ಕ್ರಿಯೆಗೆ ಅಂತಂದ್ರೆ ಅದು ನಮ್ಗೆ ಉಪಯೋಗಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಆದ್ರೂ ಕೂಡ ಅದು ಅತ್ಯಾಚಾರ ಎಂದು ಪರಿಗಣಿಸ್ಬೇಕು ಅಂತ ಸೆಕ್ಷನ್ನೇ ಹೇಳುತ್ತೆ. ಹೀಗಿದ್ಮೇಲೆ ಏನ್ ಮಾಡೋದು? ತಿಳಿತಲ್ಲ? ಎಸ್, ಬರ್ಕೊಳ್ಳಿ. ಹರ್ಡ್ ಸುಭಾಷ್ ಚಂದ್ರ ಬೋಸ್ ಅಂಡ್ ಲರ್ನಡ್ HGP. The present petition is filed under section 439 CRPC with the following prayer. First, brief facts of the case are as under. A complaint came to be lodged by Srimati Chandrakala, wife of Shankar, stating that her husband is eking out livelihood by doing centering work, and she has a daughter. They have a daughter by name. They have a daughter aged 14 years. They have two daughters aged 14 years and 12 years. First, the first daughter is the victim girl. First, on 31/5/2021, on inquiry, victim girl revealed that neighbor, bracketal accused and neighbor by name Raghu, bracketal accused and happily, had forcibly took the victim girl with him, and in the guise of love affair, and also with a promise to marry her, he had physical relationship with her. First, based on the complaint, Rajagopal Nagara Police Station registered a case in crime number 189/2021 for the offences punishable under section 366 capital A, 376 and section 6 of the POCSO Act, and filed charge sheet against the accused inter alia, arrested the accused and sent him to judicial custody. First, next para, attempt made by the petitioner to get him enlarged on bail was turned down by the learned special judge by order dated 26th October 2021 in semis number 7797 of 2021. First, thereafter, petitioner has approached this court. First, that counsel for the petitioner vehemently contended that the accused is innocent of the offences alleged against him. First, he further contended that accused is in custody since 8 months, and since the charge sheet is filed, continuation of the accused in judicial custody is no longer warranted. First, he also contended that the case of a love affair has been turned down, has been blown out of proportion by the parents of the victim girl, and a false case has been lodged against the petitioner herein and sought for grant of bail. First, per control and HGP opposes the bail grounds vehemently. First, he contended that even assuming that there is a love affair between the victim girl and the accused, the forcible sexual intercourse would attract offence under section 6 of the POCSO Act, inasmuch as the alleged consent by the victim girl is no consent in the eye of law and sought for rejection of the bail petition. First, next para. In view of the rival contentions, this court heard the parties in view of the rival contentions, this court perused the material on record meticulously. First, admittedly, the victim girl is aged 14 years. First, following the dictum of the Honorable Apex Court in the case of independent thought versus so and so, the consent, if any, of the victim girl is immaterial, as the same is no consent in the eye of law. First, the provisions of section 29 and 30 of the POCSO Act cannot be lost sight of while appreciating the rival contentions of the parties. First, therefore, this court is of the considered opinion that the grounds urged in the petition are not having merit so as to enlarge the accused petitioner on bail. First, next para. However, having regard to the definite timeline prescribed under the POCSO Act, the trial needs to be expedited. First, therefore, this court is of the considered opinion that no grounds are that the petitioner is not entitled for grant of bail by resorting to the special powers vested in this court under section 439 CRPC. Accordingly, following order, petition dismissed. First, the trial court is directed to expedite the trial in view of the timeline prescribed under the POCSO Act. Hmm. 385 ಇದೆ. Let him file objection. Objection ಸಾಕ್ಲಿ ಅವ್ರು. Correct, but let them file objections if the 167 is to be looked into. ಅದು ನಮ್ಗೆ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ, ಯಾವತ್ತು ಅರೆಸ್ಟ್ ಏನಾಗಿದೆ, ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರೋ ಹಾಕಿಲ್ವೋ, ಮಧ್ಯಾಹ್ನ ಹೇಳಿ ಅವರು. ನೋಡ್ರಿ ಅದೇನೋ 167(2) ಇದೆ ಅಂತ ನೋಡಿ. Let us see. I don't know when was the date of arrest. We don't know whether the charge sheet is filed or not. We don't know. Page 30. Custody on 8th will not accrue to your benefit. Yes. Good. We are on the same page. 10th, if he has been produced, then arrest yavattu. Arrest memo ಎಲ್ಲಿ? Arrest. ಅರೆಸ್ಟ್ ಮೆಮೋ ಎಲ್ಲಿದೆ? 10th ಅವ್ರು ಕೇಳಿ, ಅವ್ರು ಹೇಳಿ. ಕೀಪ್ ದಿ ಐಒ ಪ್ರೆಸೆಂಟ್ ಮಿಸ್ಟರ್. 10th ಆಯ್ತು, ಅಲ್ಲಿಂದ 60 ದಿವಸ ಆಯ್ತು, ಇವತ್ತು 61ನೇ ದಿವಸ. ನಾನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ. No, I am permitting you appear before the trial court and then take at 2:30. Pass over 2:30. ಆಯ್ತು, ನೋಡೋಣ ಅದನ್ನ 2:30 ನೋಡೋಣ. We will see at 2:30. I am aware of that position. There need not be a formal bail application as could be seen by the 167(2) wordings. What is to be told there is, if the accused is ready to offer the bond. That's all the thing that is available. Let him say at 2:30. We do not know whether the charge sheet is filed or not. That is the point. ನಿಮ್ ಮಿಕ್ಕಿದೆಲ್ಲ ಇದೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಬಗ್ಗೆ ನಮ್ಗೆ ನಿಲ್ವಲ್ಲ ಇನ್ಫಾರ್ಮೇಶನ್. What has happened there we don't know. Let him consult and then come back. 2:30. ಏನ್ರಿ, ವಾಟ್ ಈಸ್ ಹ್ಯಾಪನಿಂಗ್? ವೈ 167(2) ತನಕ ಬಿಡ್ತಾರೆ? ಅಲ್ಲ, ಅವ್ರಿಗೇನ್ ಪ್ರಜ್ಞೆ ಇರೋದಿಲ್ವಾ ಇನ್ನು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್? ಹಾಕಿರ್ಬೋದು, ನಾನು ಹೇಳಿದ್ಮೇಲೆ ನೀವ್ ಹೇಳೋದಲ್ಲ. ನೀವು ಇಷ್ಟೊತ್ತಿಗೆ ವಿಚಾರಿಸ್ಕೊಂಡು ಬಂದಿರ್ಬೇಕು ಅದನ್ನ. We'll see. Nagamani.
And he is working for the
ಕರೆಕ್ಟ್ ಅಮ್ಮ, ನೀವು ಹಾಕಿದ ಕೇಸ್ ಮೊದಲು, ಅವ್ರು ಹಾಕಿದ ಕೇಸ್ ನಂತರನಾ? ವಿಚಾರಿಸಿ ಹೇಳಿ, ಅವರು ವಿಚಾರಿಸಿ ಹೇಳಿ. ಇನ್ಫಾರ್ಮೇಶನ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ?
page number 46, that is, we have had the case before the appellate.
ಅವ್ರು ಹಾಕದ್ಮೇಲೆ ಇವ್ರು ಹಾಕ್ತಿದಾರಲ್ರಿ. As a counterblast to the proceedings that they have initiated, you have filed the complaint. ಅದನ್ನೇ ವಿಚಾರಿಸಿ ಹೇಳಕ್ ಹೇಳಿದ್ದು. 2:30. ಏನ್ ನಿಮ್ಮಿಂದ ರಿಕವರಿ? ಏನು ಗೋಲ್ಡ್? ಎಲ್ಲಿತ್ತದು? You don't claim ownership. You don't claim ownership over the ornaments. Then offense is complete. No? Stolen property recovered from your house on the basis of the voluntary statement given by you, and when you don't claim the ownership for those articles, offense is complete. ನಿಮ್ಮ ಹತ್ರ ಹೆಂಗ್ ಬಂತು ಮತ್ತೆ ಅದು? ದಟ್ ಈಸ್ ಅಲ್ಲ, ನೀವ್ ಹೇಳ್ಬೇಕು. ಅವನ್ ಕದ್ದವನು ನಿಮ್ಮನೇಲಿ ತಗೊಂಬಂದಿಟ್ನಾ? ಅದಕ್ಕೇನೆ ಟ್ರಯಲ್ಗೆ ಆಗ್ಲಿ ಬಿಡಿ. ಕಳ್ಳನ್ಗೆಲ್ಲ ಏನ್ ಕೊಡೋದು ಬೇಲು?
The case itself is A4, A5, A6 and A7 are standing somewhere outside. They are not even participants, they are not even entering the house. And thereafter, these students even need to agree.
Or standing outside the house only to give you the signal if somebody comes from there. ಆಯ್ತು, 8 ಸಿಗ್ನಲ್ ನೀವ್ ಯಾರು ಬಂದ್ರೆ ಅವ್ರನ್ನ ಅಲ್ಲೇ ಹೊಡೆದು ಮುಗಿಸಕ್ಕೆ. ಸರಿ, ನೀವು ಹಾಗಾದ್ರೆ ಸುಮ್ನೆ ಬೀದಿನಲ್ಲಿ ನಿಂತಿರೋರಾದ್ರೆ ನಿಮ್ಗೆ ಯಾಕೆ 1000 ಗ್ರಾಮ್ ಚಿನ್ನ ಕೊಟ್ಟ, 1 kg ಚಿನ್ನ ಕೊಟ್ಟ ಅವನು? ಅಲ್ಲ, ಕರೆಕ್ಟ್ ಅಲ್ದ್ರೆ then you are out of the court. If you say correct. ನಿಮ್ ಮನೆಯಲ್ಲಿ ಏನ್ ಸಿಕ್ತು ಅದ್ ಹೇಳಿ. 1 kg ಚಿನ್ನ ಸಿಕ್ಕಿದೆ ಅಲ್ಲ, ಇದೊಂದೇ. ಅದಕ್ಕೆ ಅವಾಗ that's all the more necessary that you are involved in many cases. That's why vakilre, that's why I asked you one question. Do you claim ownership over that? ಇಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ಮಲ್ಲೂ ಇತ್ತು ಬೇಕಾದಷ್ಟು. ನಾವು ಆಗರ್ಭ ಶ್ರೀಮಂತರು. 1 kg ಚಿನ್ನ ನಮ್ಮಲ್ಲಿ ಇರೋದೇನ್ ಮಹಾನದು, ನಮ್ಮಲ್ಲಿ ಚಿನ್ನದ ಸಿಂಹಾಸನನೇ ಇದೆ ಅಂತ ನೀವು ಹೇಳಿದ್ದಿದ್ರೆ ಆವತ್ತಿನ ದಿವಸ ಒಪ್ಕೋಬಹುದು. Who are you? What is your avocation? Who are you? What is your avocation? ಎಲ್ಲಿ? ಅಲ್ಲಪ್ಪ, ಏನು ವರ್ಕರ್ ಅಂದ್ರೆ ಕೆಲಸ ಮಾಡೋರು. ಮತ್ತೆ ಅಷ್ಟೊಂದು ಪ್ರಮಾಣದ ಚಿನ್ನ ನಿಮ್ಮನ್ನಲ್ಲಿ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ? ಮಾಡ್ತಾರೆ. ನೀವೆಲ್ಲ ಗೂರ್ಖ ಅಲ್ಲಿಂದ ಬಂದು ಮನೆ ಕಾಯಿರೋ ಅಂತಂದ್ರೆ ಮನೆಯನ್ನ ಖಾಲಿ ಮಾಡಾಕ್ ಬಿಟ್ಟಿದ್ದೀರಿ. You are from Nepal. If we grant bail, you will not be available for the trial. Yes, Parkoli heard. ಇವರು ಕರ್ನಾಟಕದಲ್ಲಿದ್ದಾರೆ, ಅವ್ರು ನೇಪಾಳದಲ್ಲಿದ್ದಾರೆ, ಅಷ್ಟೇ ಪ್ಯಾರಿಟಿ.
ಅಲ್ಲೇ ಕೆಲಸ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ, ಅಲ್ಲೇ ಕೆಲಸ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ. ನಮ್ದು ಡೇಟಾ ಪ್ರೊಡ್ಯೂಸರ್ and prosecution story also says that the complaint itself was completely achieved me. ನಾನು ರಜೆಯಲ್ಲಿ ಇದ್ದೀನಿ, ಫೋನ್ ಮಾಡಿದ ನನಗೆ ಅಂತ ಹೇಳಿದರು.
ಟ್ರಯಲ್ ಮುಗಿಸಿ ನಿಮ್ ಮನೆಯಲ್ಲಿ 1 kg ಚಿನ್ನ ಗೂರ್ಖನ್ ಮನೆಯಲ್ಲಿ ನೇಪಾಳದಿಂದ ಬಂದು ಹೆಂಗ್ ಸಿಗುತ್ತೆ? ಬರ್ಕೊಳ್ಳಿ. ಯಾರು ಅದ್ರ ಮೇಲೆ? ಅವರೆಲ್ಲ ನೇಪಾಳದವ್ರನ್ನೇ, ಎಲ್ಲರೂ ಯಾರನ್ನೇ. ಬರ್ಕೊಳ್ಳಿ. Heard counsel for the petitioner and learned HGP. Present petition is filed under section 439 CRPC. ಅಲ್ಲಿಂದ ಬಂದು ಊಟ ಮಾಡ್ರು ಅಂತಂದ್ರೆ ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಕಣ್ಕಂಡವ್ರ ಮನೆನೆಲ್ಲ ದೋಚ್ತೀರಿ. Yes, no. These people don't deserve any mercy from the court. ಓದಿ, ಅದೇನ್ ಸಂಬಂಧ ಕಾಣೋದಿಲ್ವ ಹೇಳೋಣ. ಓದಿ. No, you whatever you want to read. You want the court to just hear you and then pass orders.
ಸಾಕ್ಷಿ ಒಂದರ ಮನೆ ಕೆಲಸ ಸಂದರ್ಭದಲ್ಲಿ ಸೇರಿಕೊಂಡಿದ್ದ ಏಳು ಸಾಕ್ಷಿ ಮತ್ತು ಇವರ ಮನೆಯಲ್ಲಿ ಸಾಕ್ಷಿಯನ್ನು ಮನೆಯಲ್ಲಿ ಎಲ್ಲೋ ಆರೋಪಿಗಳಾದ 2ರಿಂದ 7 ಆರೋಪಿಗಳು ಪರಿಹಾರ ಕರೆಸಿಕೊಂಡು ಬಾಕಿ ಎದುರಿನ ರಸ್ತೆಯಲ್ಲಿ ನಿಂತು ಹೊರಭಾಗದಲ್ಲಿ ಮಾಡಿಕೊಂಡಿದ್ದು ಈ 8 ಆರೋಪಿ ಇತರ ಆರೋಪಿಗಳು ನೀಡುತ್ತಿದ್ದು ಸಾಕ್ಷಿ ನಂತರ
ದುಷ್ಪ್ರೇರಣೆ ನೀಡುತ್ತಿದ್ದು ಅದು ನನಗೆ ಕಾಣ್ತಿದೆ. ದುಷ್ಪ್ರೇರಣೆ ನೀಡುತ್ತಿದ್ದು ಹೋಗಿದ್ದ A2 A3 ರವರಿಗೆ
ಮನೆಯ ಕಿಟಕಿ ಪ್ರವೇಶಿಸಿ ಮನೆಯಲ್ಲಿದ್ದ ಹಣವನ್ನು ಅದನ್ನ ಆರೋಪಿಗಳಲ್ಲಿ ಈ ಅವರು ಹೊರಗ ಇದ್ದಾರೆ ಆಮೇಲಿಂದ ಅವ್ರು A1 A2 A3 ನೇಪಾಳ ಅಂತ ಇದ್ದಾರೆ. ವರ್ಕಿಂಗ್ working in their own places.
ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಓದಿ.
A1 A2 A3 and AE.
ನಿಮ್ಮ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಓದಿ.
Yes, voluntary statement I have not stated these words that 77. 77 third paragraph. ನಂತರ ಎಲ್ಲವೂ
ಅದು ಮಿಥುನ್ದ ಆಯ್ತು ಇವ್ರೆ, ಮಿಥುನ್ದ ಆಯ್ತು. ಮಿಥುನ್ದು 3 ಜನದ್ದು ಓದ್ಬೇಕು ನೀವು. ಬರೇ ಮಿಥುನ್ದು ಒಬ್ಬದ್ರೆ ಓದಿದ್ರೆ ಹೆಂಗಾಗತ್ತೆ? 72ನೇ ಪೇಜು 72.
ಅದರಲ್ಲಿ ಇಲ್ಲಿ 74 ಥರ್ಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಸೇಮ್ ಅದೇ ಎಲ್ಲರೂ ಐಡೆಂಟಿಟಿ ಇರುತ್ತೆ. ನಂತರ ಎಲ್ಲರೂ ಸೇರಿ ಥರ್ಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂತರ ಎಲ್ಲರೂ ಸೇರಿ ಮೆಜೆಸ್ಟಿಕ್ ವಲ್ಲಿಂದ ಸವಿತಾ ಬೆಂಗಳೂರಿನಿಂದ ಪೊಲೀಸರ ಮುಖ್ಯ ಸವಿತಾ ಸೂರತ್ ವಿಸ್ತಾರ ಅವರು ಮುಂಬೈಲಿ ಹೋಗಿ ವಿನೋದನ ಅಲ್ಲಿಂದ ತದನಂತರ ನಾವು ಕ್ರಮೇಣ ಒಬ್ಬೊಬ್ಬರಾಗಿ ಅವರನ್ನು ಕಳಿಸಿ ಮರುದಿನವೇ ನಮ್ಮ ಮನೆಯ ಮಾಡಿ ಹೋಗುವ ಬಗ್ಗೆ ನನ್ನ ಮೇಲೆ ಕೈ ಮಾಡಿ ವಿಚಾರ ಮಾಡಿದರು. ನಾನು ನನಗೆ ಅವಳು ಹೀಗೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ ಎಂದು ತಿಳಿಸಿದರು. ನಂತರ ನಾನು ಇಲ್ಲಿ ಇದ್ದರೆ ಕಷ್ಟ ಎಂದು ನಮ್ಮ ಮಾಲೀಕರಿಗೆ ಕರೆ ಮಾಡಿ ನನ್ನ ತಾಯಿಯವರ ಇದೆ ಅರ್ಜೆಂಟ್ ಆಗಿ ಹೋಗಬೇಕು ಎಂದು ತಿಳಿಸಿ ಇಲ್ಲಿಂದ ಹೊರಟು ಪೊಲೀಸರು ಪ್ರಕಾರ ನನ್ನ ಮಾನಸವಾಡಿಗೆ ಹೋಗಿ ವಾಪಸ್ ಕಳಿಸಿದರು. ನಂತರ ಅಲ್ಲಿಂದ ನಾವೆಲ್ಲರೂ ಸೇರಿ ಒಳಗೆ ಬಿಟ್ಟು ಮಾಡಿಕೊಂಡು ಬಾಣಸ್ವಾಡಿ ಮಹೇಂದ್ರ ಅವರನ್ನು ಮದುವಿದ್ದೆವು. ಇನ್ನು ಸಂಜೆ ಸಮಯದಲ್ಲಿ ನಾನು ಬಾಣಸ್ವಾಡಿ ಅಡ್ಡ ಮನೆಯಲ್ಲಿ ಪೊಲೀಸ್ ನಾನು ಕರೆದುಕೊಂಡುಕೊಂಡ್ರೆ ನಾವೆಲ್ಲ ಸೇರಿ ಕಳ್ಳತನ ಮಾಡಿರುವ ನಮ್ಮ ಮಾಲೀಕರ ಮನೆಯನ್ನು ತೋರಿಸುತ್ತೇನೆ. ನಿಮ್ಮ ಜೊತೆ ದೊಡ್ಡದಲ್ಲಿ ಭಾಗಿಯಾಗಿದ್ದ ಮಕ್ಕಳ ಸೌಭಾಗ್ಯ ಕಮಂಚರಿ ಕಾವೂರವರು ಬೆಂಗಳೂರಿನ ಸಚಿತಾ ಮತ್ತು ಸೂರತ್ ವಿಸ್ತಾರ ಅವರು ರಿಕವರಿ
ದಿನಾಂಕ 31/8/21 ಓದ್ತೀರಾ? 73ನೇ ಪೇಜ್.
ದಿನಾಂಕ 31/8/21 ರಾತ್ರಿ ನಾನು ಕಾಲು ಮಂಗಳ ಸೇರಿ ಕಬ್ಬಿಣದ ಮಾಲೀಕರ ಮನೆಯಲ್ಲಿಯೇ ಇದ್ದರು. ನಮ್ಮ ಪ್ಲಾನ್ ಪ್ರಕಾರ ರಾತ್ರಿ ನಾವು ಸುಮಾರು 12 ಆ ದಿನ ವಿನೋದ್ ನಮಗೆ
Exactly what I said. Exactly what I said. ನೀವು ಹೊರಗಡೆ ಯಾರು ಬರ್ತಾರ ಅಂತ ನೋಡ್ತಾ ಕಾಯ್ತಾ ನಿಂತಿದ್ರಿ ಅಂತ. ಆಯ್ತು ಮುಂದೆ ಓದಿ. ಗೋರ್ಖನ್ ಡ್ರೆಸ್ ಅಲ್ಲಿ ಇದ್ರೆ ಯಾರು ಕೇಳ್ತಾರೆ? ಪಾಪ ಯಾರೋ ಗೋರ್ಖಾ ಓಡಾಡ್ತಿದ್ದಾನೆ, ಯಾರೋ ಬಂದು ನೋಡಕ್ಕೆ. ಎಸ್, ರೀಡ್. ಸೌಭಾಗ್ಯ ಎಲ್ಲರೂ ಹೊರ ಬರಬಹುದೆಂದು ವಾಚ್ ಮಾಡಿಕೊಂಡು ಅವರು ಒಳಗೆ ಬರಲು ಕರೆದರೆ ಹೋಗಲು ರೆಡಿಯಾಗಿದ್ದೆವು. ಡೋರ್ ಹೊಡೆಯುವುದು ಕಷ್ಟ ಎಂದು ಸಬಿತಾ ಹೇಳಿದ್ದರಿಂದ
ಅದೇ ರೀತಿ ಆಯುಧಗಳನ್ನು ರೂಮ್ ಒಳಗೆ ಪ್ರವೇಶ ಮಾಡಿ
ಮುಂದೆ
ನಂತರ ಸುಮಾರು 4 ಗಂಟೆಯಲ್ಲಿ ಸಬಿತಾ ಅವರು ಮಾಲೀಕರಾದ ರಾಜ್ಕುಮಾರ್ ನಂತರ ಎಲ್ಲರೂ ಸೇರಿ ತದನಂತರ ನಾವು ಕ್ರಮೇಣ ಒಬ್ಬೊಬ್ಬರಾಗಿ ಹೇಳಿ ಅವರನ್ನು ಕಳುಹಿಸಿ ನಾವೆಲ್ಲರೂ ನಮ್ಮ ಮನೆಗಳಿಗೆ 3 ದಿನದಲ್ಲಿ ನಮ್ಮ ಮನೆಯ ಮಾಲೀಕರು ಸಬಿತಾ ಮನೆಯಲ್ಲಿ ಕಳವು ಮಾಡಿಕೊಂಡು ಹೋಗಿರುವ ಬಗ್ಗೆ ನನ್ನ ಮನೆ ಕರೆ ಮಾಡಿ ವಿಚಾರ ಮಾಡಿದರು. ಆಗ ನಾನು ನನಗೆ ಅವಳು ಹೀಗೆ ಮಾಡಿದ್ವಿ ಹೀಗೆ ಎಂದು ತಿಳಿದಳು. ನಂತರ ನಾನು ಇಲ್ಲಿ ಇದ್ದರೆ ಕಷ್ಟ ಎಂದು ನಮ್ಮ ಮಾಲೀಕರಿಗೆ ಕರೆ ಮಾಡಿ ತಾಯಿಯವರ ಸ್ಥಿತಿ ಇದೆ ಅಲ್ಲಿಂದ ಹೊರಟ ಪೊಲೀಸರು ನನ್ನ ಮಾಡಿಸಿ ವಾಪಸ್ ಕೆಲಸಕ್ಕೆ ಬರಲಿಲ್ಲ. ನಂತರ ಅಲ್ಲಿಂದ ನಾವೆಲ್ಲರೂ ಬಾಣಸ್ವಾಡಿ ಮಾಡಿ ನಮ್ಮ ಅಣ್ಣ ಮಹೇಂದ್ರರವರ ಮನೆಗೆ ಈ ದಿವಸ ಸಂಜೆ ಸಮಯದಲ್ಲಿ ನಾನು ಬಾಣಸ್ವಾಡಿ ಅಣ್ಣ ಮನೆಯ ಬಳಿ ಹೆಸರನ್ನು ಹಿಡಿದುಕೊಂಡು ಪೊಲೀಸ್ ಕರೆದುಕೊಂಡು ಹೋದರೆ ನಾವೆಲ್ಲರೂ ಸರಿ ಮನೆಯನ್ನು ಮಾಡಿರೋ ನಮ್ಮ ಮಾಲೀಕರ ಮನೆಯ ನನ್ನ ಜೊತೆ ಕೃತ್ಯದಲ್ಲಿ ಭಾಗಿಯಾಗಿದ್ದು ಅವರು ಬೆಂಗಳೂರಿನ ಸಮೇತ ನಡೆಯಲಿದ್ದು ಹಾಗೂ ಸಮೇತ ಒಂದು ಸೂರತ್ ಅವರ ಬಗ್ಗೆ ಮಾಹಿತಿ ನೀಡಿ ಅವರ
ನಿಮ್ಮ ಪಂಚನಾಮೆ ಓದಿ, ನಿಮ್ದು ರಿಕವರಿ ಪಂಚನಾಮೆ ಓದಿ. ನಿಮ್ಮಿಂದ ರಿಕವರಿ ಪಂಚನಾಮೆ ಓದಿ.
ದಿನಾಂಕ 12 ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಕಾಯಂ ವಿಳಾಸ ಅಭಿಷೇಕಿರುವ ತೀರಕ್ಷೆಯಲ್ಲಿರುವ ಸೇರಿಕೊಂಡು 1 ದಿನ ಮಧ್ಯಾಹ್ನ ಸಮಯದಲ್ಲಿ ಮಾಲೀಕರ ಈ ಚಿನ್ನದ ಪ್ರದರ್ಶನ ಮಾಡಿದ ತೋರಿಸಿ ಹಾಜರುಪಡಿಸಿದ ಆದ್ದರಿಂದ ಆರೋಪಿ ತೋರಿಸಿ ಹಾಜರುಪಡಿಸಿರುವ ಕಳವು ಮಾಲನ್ನು ಪಡೆದು ಬಿಸಿ ಪಂಚನಾಮ ಪೊಲೀಸ್ ಅವರ ಸಿಬ್ಬಂದಿಗಳ ಪ್ರಚಾರದಲ್ಲಿ ಆರೋಪಿ ಇದನ್ನು ಹಾಗೂ ಬೆಳಗ್ಗೆ 9:45 ಗಂಟೆಯಿಂದ 9:45 ಗಂಟೆಗೆ ಠಾಣೆಯಿಂದ ಇಲಾಖಾ ಅವರು ತೋರಿಸಿದ ಮಾರ್ಗದರ್ಶನ 2 ಗಂಟೆ ಅವಾಗಿ ಪೊಲೀಸರು ಚಿನ್ನದ ಆಭರಣಗಳನ್ನು ಆ ಎಂದು ತೋರಿಸಿ ಭದ್ರಪಡಿಸಿದ್ದು This person has taken is
ಅವರೆಲ್ಲ ಇತ್ತಲ್ಲ ಇವನ ಹತ್ರ ಹೇಳ್ಬೇಕಲ್ಲ ಇಷ್ಟೆಲ್ಲ ಹೆಂಗ್ ಬಂದಿದೆ ಅಂತ. ಅವರೇ ಎರಡನೇ ಪೆಟಿಷನರು, ಫಸ್ಟ್ ಪೆಟಿಷನರು ಇದೆ, ಸೆಕೆಂಡ್ ಪೆಟಿಷನರು ಇದೆ. ಬರ್ಕೊಳ್ಳಿ ಬರ್ಕೊಳ್ಳಿ.
Nikam Singh is the petitioner number. Only with regard to him, Milord's recovery. From the other petitions, no statement is also there, no recovery. Like not in the bill has been granted with regard to the AC. Similar knowledge practice for the others.
ಆಯ್ತಾ? Heard Sri so and so and learned HGP. Present petition is filed and imported in CRPC. With the following prayer. The brief facts of the case are as under. Upon the complaint lodged by Ranjini Rajkumar, wife of Rajkumar, Banashankari police have registered a case in crime number 203/2021 for the offence punishable under section 381 of the IPC on 31/8/2021. In the complaint, it is contended that the complainant is resident of a house bearing number 1 Ashwatha Layout, 6th Cross, JP Nagar, 7th Phase, Puttenalli, Bangalore. She had visited her mother's house, and when she returned to the house, the maid servant by name Sabita was missing. On verification of the CCTV footage, she has noticed that Sabita had allowed two unknown persons to break through the bedroom in the house and stolen away jewelry worth 4 crores and between 12:47 AM to 3:55 AM on 31/8/2021. Sabita was introduced by Kamal, who has been employed with them. There has been no tampering of the locks. Based on the said complaint, police registered the case as above and investigated the matter. During such investigation, petitioners herein were accused number 4, 5, and 6 were apprehended by the police and inquired. They have given the voluntary statement, and based on the voluntary statement, the investigation agency is able to recover gold ornaments weighing 1140 grams. 1140 grams from the house of the second petitioner, who is the fifth accused. Next para voluntary statement of first petitioner, accused number 4, and third petitioner, Saubhagya alias Sunita, accused number 7, clearly show that the gold ornament recovered from the house of the accused number 5, Mithun, was the gold ornaments, which are the subject matter of the theft. First, next para. Subsequently, comma, the accused persons were produced before the jurisdictional magistrate and they are remanded to custody. First, next para. The attempt made by the petitioners herein to seek for grant of bail is turned down by the learned district judge in CMIS number 11,217 of 2021 by order dated 22nd December 2021. Full stop. Next para. Thereafter, petitioners are before this court. Full stop. Land counsel for the petitioner, Shri so and so vehemently contended, Shri Pradeep Patil vehemently contended that petitioners are innocent of the offences alleged against them and therefore they are entitled for grant of bail. First, next para. He also contended charge sheet is now filed and co-accused by name Kamal Shahi alias Kalu has been enlarged on bail by this court by order dated 1st February 2022 in criminal petition number 535 of 2022 and therefore on the ground of parity the present petitioners are also entitled to be enlarged on bail. First, next para. Per contra, Laird HCGP opposes the bail petition, stating that petitioners are all residents of Nepal, and once they are enlarged on bail, there is every possibility that they would flee away from the trial, and therefore, comma sought for rejection of the bail. First, he also pointed out that the present petitioners do not stand on the same footing that of the persons who have that of co-accused Kamal Shahi, who has been granted bail, inasmuch as the role assigned to the present petitioners and Kamal Shahi are altogether different. First, and sought for rejection of the bail. First, in view of the rival contentions, comma, this court perused the material on record meticulously. First, next para. Admittedly, there are voluntary statements of these petitioners after their arrest. First, pursuant to the voluntary statement given by these petitioners, comma, the investigation agency is able to recover 1,140 grams of gold from the house of second petitioner, bracket accused number 5. First, next para. Admittedly, the petitioners are working as petitioner number 1 is working as a security personnel. Petitioner number 1 and 2 are working as security personnel, and petitioner number 3 is working as a maid servant. First, possession of 1,140 grams gold in the house of accused number 5 is unexplained by accused number 5. First, voluntary statement given by the accused persons and subsequent recovery and discovery of the gold ornaments resulting in the discovery of the fact of alleged theft by the investigation agency is a matter that cannot be lost sight of by this court while entertaining the request made by the petitioners for grant of bail. First, next para. Prima facie materials on record, especially the recovery of 1140 grams of gold from the custody of the second petitioner, bracket accused number 5, at the instance of the voluntary statement given by all the petitioners, comma, is a factor, is a relevant factor, and receiver and recovery of the stolen property in a matter of this nature assumes a great importance. First, next para. Further, comma, the ground of parity is also not available for the petitioners inasmuch as there is no voluntary statement given by the accused Kamal Shahi, and pursuant to that, there is no recovery. First, as could be seen from the complaint governments, as could be seen from the voluntary statement, Kamal Shahi was standing outside watching for any public movement so as to caution the persons inside the house. First, this court, while granting the bail, has taken note of the said fact and has enlarged the Kamal Shahi on bail. First, but the voluntary statement of these petitioners and pursuant to the same comma recovery of 1140 grams of gold would be a relevant factor while considering the case of the petitioners on parity. First, Therefore, this court is of the considered opinion that the material on record, insofar as these petitioners are not sufficient enough to hold that they are in parity with the Kamal Shahi who has been granted by this court. Accordingly, this court is of the considered opinion. Further, all the petitioners are permanent residents of Nepal, whereas Kamal Shahi is the resident of Karnataka. If taking note of these facts, this court is of the considered opinion. This court is of the considered opinion that if the petitioners are enlarged on bail, there is every possibility of they fleeing away from the trial. Accordingly, this court is of the considered opinion that no grounds are made out for grant of bail by resorting to the special powers vested in this court under section 439 CRPC. However, if the accused persons are in custody, the trial needs to be expedited. Accordingly, following order is passed, bail petition rejected. Having regard to the fact that the accused petitioner, including the petitioner number 3 being the lady, the trial court is directed to expedite the trial and conclude the same honor before 31/12/2022. Observation made by this court during the course of this order shall not influence the trial judge while disposing of the case on merits. ಅಲ್ಲಿಂದನೂ ಅನ್ನ ತಿನ್ನಕ್ ಬಂದು ನಮ್ಮನೆ ಕನ್ನ ಹಾಕ್ತಾರೆ ಅಂದ್ರೆ ವಕೀಲ್ರೆ ಬಹಳ ಕಷ್ಟ. ನಾವು ಅದನ್ನ ಗಮನದಲ್ಲಿ ಇಟ್ಕೋಬೇಕು, ತಪ್ಪು ತಿಳಿಬೇಡಿ. ನಾವು ಒಬ್ಬರನ್ನ ನಂಬಿ ಮನೆಯಲ್ಲಿ ಬಿಟ್ಕೊಳ್ತೀವಿ, ಅದು ಅವರು ಅದೆಲ್ಲ ಫಾರ್ಮ್ ಹೌಸ್ ಅಲ್ಲಿ 10 ದಿವಸ ಇಟ್ಟು ಆಮೇಲಿಂದ ಮನೆಗೆ ಸೇರಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಸಭೆ. The crime started much earlier, not on 31/12. ಎಲ್ಲ ಪ್ರೀ ಪ್ಲಾನ್ಡ್. ಮನೇಲಿ ಎಷ್ಟಿದೆ ದುಡ್ಡು ನೋಡ್ಕೊಂಡು ಅವ್ರದ್ದು ಮನೆಯವ್ರದ್ದೆಲ್ಲಾರ್ದು ಪ್ರೀತಿ ವಿಶ್ವಾಸನ ಗಳಿಸಿ ಮಾಡ್ಲಿ ಬಿಡಿ. 1140 ಗ್ರಾಮ್ ಗೋಲ್ಡ್ ಒಬ್ಬರ ಮನೆಯಲ್ಲಿ ಸಿಗುತ್ತೆ ಅಂತಂದ್ರೆ ಪೊಲೀಸ್ನವರು 1140 ಗ್ರಾಮ್ನ ಇಂಪ್ಲಾಂಟ್ ಮಾಡಿ ನಿಮ್ 4 ಜನನ ಸಿಕ್ಕಾಕ್ಸಲ್ಲ. 10 ಗ್ರಾಮು 20 ಗ್ರಾಮು ಓಕೆ, 1140 ಗ್ರಾಮ್. ಅವರು A1 ಸಿಕ್ಲಿಲ್ಲ. ಈಗ ಏನಾಗತ್ತೆ ಅಂತಂದ್ರೆ ವಕೀಲ್ರೆ, ತಾವ್ ಹೇಳೋ ಪಾಯಿಂಟ್ ಚೆನ್ನಾಗಿದೆ, ನಾನು ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ. That as you rightly said it, that's a matter for the trial. We may not be in a position to express any opinion at this point of time. But unfortunately, that is called negative parity. Negative equality. ಆ ಬಿಲ್ಡಿಂಗು ಅಕ್ರಮವಾಗಿ ಕಟ್ಟಿದ್ದಾನೆ, ಅದಕ್ಕೆ ಕಟ್ತೀನಿ, ನನ್ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೋಬೇಡಿ, ಅವನ್ ಮೊದ್ಲು ಹೊಡೆದಾಕ್ ಕೊಟ್ಟು ನನ್ನ ಹತ್ರ ಬನ್ನಿ ಅಂತ ನೀವು ಕೇಳಕ್ ಆಗಲ್ಲ ಕಾನೂನಲ್ಲಿ. ಅಷ್ಟೇ, ದಟ್ ಇಸ್ ದಿ ಪಾಯಿಂಟ್. ಇದೆಯಲ್ಲ, ಪಂಚನಾಮೆ ಇದೆ, ಫೋಟೋ ಇದೆ, ತಾವಿದೆ, ಅವ್ರ ಮನೆಯಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದೀರಿ, ಫೋಟೋ ಇದೆ. ಪ್ಲಾಸ್ಟಿಕ್ ಗ್ಯಾಸ್ ಸಿಲಿಂಡರ್ ಪಕ್ಕ ಅಂತ ಟ್ರಯಲ್ಗೆ ಇಟ್ಕೊಳ್ಳಿ ಅವೆಲ್ಲ. ಇನ್ನೋಸೆಂಟ್ ಅಲ್ಲ ಅವ್ರು. ಇನ್ನೋಸೆಂಟ್ ಆಗಿದ್ದಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡೋದು. ಇನ್ನೋಸೆಂಟ್ ಅಲ್ಲ, ದೂರದ ದೇಶದಿಂದ ಬಂದು ಊಟಕ್ಕೆ ಅಂತ ಬಂದು ಕನ್ನ ಹಾಕೋದು ಸರಿ ಹೋಗೋದಲ್ಲ. ಎಸ್ ಪ್ಲೀಸ್. ಹರೀಶ್ ಭಂಡಾರಿ. ಎಸ್, ವಾಟ್ ಈಸ್ ದಿಸ್? ಹೇಳಿ. ಸೋಲ್ ಅಕ್ಯೂಸ್ಟಾ? ಗುರು ಕಿರಣ್. All right. Hmm. Hmm.
This is farming and the farming and other things of water. Therefore, just taken the video to water and it's coming.
Hmm. 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 ಇದ್ರಲ್ಲೇ ನಾನು ಚಾರ್ಜ್ ಶೀಟ್ ಬರುತ್ತೆ ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದು ಹಾಕಿದಿರಲ್ಲ ಬರೇ ಓನ್ಲಿ ಪೋರ್ಷನ್ ಇದೆ ಅಷ್ಟೇ. ಎಸ್ ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ, ನೋ ಪ್ರಾಬ್ಲಮ್, ಹೇಳಿ. There is an eyewitness. He is also injured. Yes, he is an injured eyewitness, Balaji. ಅದೇ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರನೇ ನಾನು ನೋಡಿದ್ದು. ನೀವು ಅದಕ್ಕೆ ನಾನು ನಿಮ್ಮನ್ನು ಕೇಳಿದ್ದು. ಕಾಲಮ್ ನಂಬರ್ 17 ಅಲ್ಲಿ there is a clear mention that Balaji, when he tried to rescue the deceased from the assault to be made by the accused number 1 with a dragger, the present accused petitioner has also assaulted Balaji with the same dragger and he is injured. No. 48ನೇ ಪೇಜ್ ಓದಿ, ಕೊಡಿ ಅವ್ರಿಗೆ. ಓದಿ. ಮತ್ತೆ ಇನ್ನೇನು ಅವ್ರ ಹತ್ರ ಏನೋ ಕೇಳ್ತಾ ಇದ್ರು. ಹಾಕ್ತಿರೇನು ಇದ್ರೆ ನೋಡ್ಲಿ ಅವ್ರು. ಓದಿ. That's all right. We are not here to find out the merits of the case. There's an eyewitness who says that Guru Kiran, that is the present petitioner, has assaulted with dagger to the deceased. Yes, Barkoli, heard. Want an order? Want an order? I leave it to you. Barkoli, heard. Sri Harish Bandari and learned HGP, present petitioner is accused number 1 in now you can see Naiga in SC number 5029 of 2021 arising out of Madhugiri PS crime number 530 of 2021. Posta Netpara. Brief facts of the case are as under. A complaint came to be lodged by Rudrappa TM, son of late Malai. ಅದು ಬೇರೆ ಪ್ರಶ್ನೆ, ನಿಮ್ಮದು ಬೇರೆ ಪ್ರಶ್ನೆ ನೋಡ್ಬೇಕಲ್ಲ ಯಾರಿಗೆ ಏನಾಗಿದೆ ಅಂತ. ಎಸ್, ಅದನ್ನು ಸೇರಿಸಿ ಬರೆಯೋಣ. ರುದ್ರಪ್ಪ TM, son of late Malaya. First, the complaint arguments reveal that the complainant is the retired headmaster. First, he has 2 daughters and a son. His son R.V. Swami had studied up to 9th standard in Madhugiri SM English School and 10th standard in Siddhganga High School. First, on 11/5/2021 at about 9 AM, his son had taken ₹200 from him and went out of the house. The pretext of viewing the movie, namely Robert. Since he did not return till evening, he was contacted over telephone. First, deceased R.V. Swami informed that he could not get the ticket in Tumkur. Therefore, he had been to Madhugiri. First, when the matter stood thus, at about 9:45 AM on 12/3/2021, complainant received a call from his nephew, Madhu Kumar, stating that he had been to haircutting in near, which is situated near TVS showroom, and he had seen R.V. Swami in the shed shop first. When he was getting his hair cut, at about 9:15 AM, Guru Kiran and others held R.V. Swami and assaulted R.V. Swami mercilessly all over his body with deadly weapons. First, Guru Kiran stabbed R.V. Swami and he fell down. When himself and others tried to pacify and rescue R.V. Swami, pacify the quarrel and rescue R.V. Swami, the assailants ran away from the spot on motorbikes. First, thereafter, they brought R.V. Swami to Madhugiri Hospital, and after getting the first aid, he was being shifted to Siddhganga Hospital in an ambulance, and complainant was required to visit to Siddhganga Hospital at Tumkur. First, accordingly, complainant rushed to Siddhganga Hospital at around 11 AM. First, however, while under treatment, Swami succumbed to the injuries. First, next para. Police, after registering the case, apprehended the petitioner and others in the case and completed the investigation and filed charge sheet. First, the case of the prosecution is supported by the testimony of the eyewitness. CW2, Madhu Kumar, nephew of the complainant. First, the attempt made by the petitioner to get him enlarged on bail is turned down by the 4th Additional District and Session Judge, Tumkuru, sitting at Madhugiri, in CMIS number 5010 of 2022. First, thereafter, petitioner is before this court. Lord Counsel for the petitioner, Sri Harish Bhandari, vehemently contended that the entire case of the prosecution is false and fabricated. First, he further contended that there is no nexus between the death of R.V. Swami and present petitioner. First, he also pointed out that the eyewitness testimony does not contain the ಇದೇ ಗುರು ಕಿರಣ್ ಅಂತ ನೀವು ಅದು ಹೇಳಿದ್ರೆ ತಪ್ಪಾಗುತ್ತೆ. ನೀವು ಓದಿದಾಗ ನೀವು ಮರ್ತು ಬಿಟ್ಟಿದ್ರಿ, ನಾನು ಕೇಳಿಸ್ಕೊಳ್ವಾ ಕರೆಕ್ಟ್ ಆಗಿ ಕೇಳಿಸ್ಕೊಂಡಿದ್ದೀನಿ, ಇದೇ ನೇಮು, ಸುಮ್ನೆ ಯಾಕೆ ಎಲ್ಲ ಬೇಡ ಬಿಡಿ. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಹೇಳಿದ್ದಾನೆ, ಅದು ನೀವು ತಪ್ಪು ಬರ್ಸ್ಬಿಟ್ಟಿದ್ದೀರಿ. ಟೈಪ್ಡ್ ಕಾಪಿ ಬರೆಯುವಾಗ ಗುರು ಕಿರಣ್ ಅಂತಿದ್ರೆ ಉರಿ ಕಿರಣ್ ಅಂತ ಬರ್ಸಿದ್ರಿ. ಉರಿನೇ ಇರ್ಬೋದು ಅವರು, ನಿಮ್ಗೇನೋ ನೋಡ್ಲಿಲ್ಲ ನೀವು. ಆಲ್ ರೈಟ್, ಇರ್ಲಿ ಬಿಡಿ. ಏನಾಯ್ತದು? ಸರಿದವ್ರು ಯಾರ ಪಾಪ ಫೋನಲ್ಲೇ ಮಾತಾಡ್ತಿದ್ದಾರು. ಏನಾಯ್ತು?
No nexus between the death of R.V. Swami and present petitioner. He pointed out that eyewitnesses' testimony does not contain.
A point. He also contended that even assuming that the entire case of the prosecution is to be accepted as true, all ingredients to attract the offence under section 302 IPC are not available on record, and therefore the gravity of the offence is reduced to considerable extent, and since the charge sheet is filed, continuation of the accused in judicial custody is no longer warranted, and thus sought for grant of bail. First, per contra, Lord HCP. ಅವರಿದಾರ ಯಾಕೆ ಬಂದ್ರು? ತಾವು ಕೋರ್ಟ್ ನಲ್ಲಿ ಇಟ್ಕೊಂಡೇನೆ ಹಾಲು ಹೋಗಿ ಬನ್ನಿ. ಏನಾಯ್ತು? Per contra, Lord HCP opposes the bail petition on the ground that the case of the prosecution is supported by the testimony of the eyewitness and the statement given by the testimony, but a statement of the eyewitness, and eyewitness has specifically narrated the individual overtax of all the accused persons with graphic details as to what happened on the day of incident. First, it is pertinent. He also contended that the eyewitness is a chance witness. Eyewitness is a chance witness, and therefore, his statement at this stage will have to be considered by this court while assessing the prima facie case of the prosecution to proceed against the petitioner herein and sought for dismissal of the bail petition. First, next para. In view of the rival contentions, this court perused the materials on record meticulously. First, ಅಲ್ಲಿ ಇನ್ಯಾರಿಗೋ ಕೊಟ್ರು ಅಂದ್ರಲ್ಲ ಹೇಳಿ. In reply, Shri Bandari contended that in the very same case, accused number 2 and 4 have been enlarged on bail, and therefore on the ground of parity. ಅಲ್ಲೇ ಮೇಲ್ಗಡೆನೆ ಬರೆದ್ಬಿಡಿ. ಸಿ ಹರೀಶ್ ಭಂಡಾರಿ ಆಲ್ಸೋ ಕಂಟೆಂಡೆಡ್ ಅಂತ. ಆಯ್ತಾ? ಗ್ರೌಂಡ್ ಆಫ್ ಪ್ಯಾರಿಟಿ ಪ್ರೆಸೆಂಟ್ ಪಿಟಿಷನರ್ ಇಸ್ ಎಂಟೈಟಲ್ಡ್. ತನ್ನ ಪರ್ಕಾಂಟ್ರ ಬರೆಯುವಾಗ ಪಿಪಿ ಇದಕ್ಕೆ ಬರೀರಿ. ಆಯ್ತಾ? ಮೂರನೇ ಗ್ರೌಂಡ್. ಗ್ರಾಂಟ್ ಆಫ್ ಬೇಲ್ ಟು ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 and 4 would not be of any avail to the petitioner in as much as the overtax alleged against A2 and A4 are altogether different from the overtax alleged against the present petitioner by the eyewitness. First, and therefore, the ground of parity is not available to the present petitioner. First, meticulous ella bantala. Next para. Enanta bantiga last line. ಅದಾಯ್ತು, ಮುಗೀತಲ್ಲ, ಇದೆಲ್ಲ ಮುಗೀತು. ನಮ್ಮ ಇದು ಮೆಟಿಕ್ಯುಲಸ್ಲಿ ಮೆಟಲ್ ಆನ್ ರೆಕಾರ್ಡ್ ಮೆಟಿಕ್ಯುಲಸ್ಲಿ. ಬೇಡ, ರಿಪ್ಲೈ ಎಲ್ಲ ಬೇಡ, ಸಾಕು. ದಿ ಕೇಸ್ ಆಫ್ ದಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್ clearly shows that on the day of incident, when the eyewitness was having a haircut in a saloon, he has witnessed the deceased being assaulted by the present petitioner and others. First, immediately he identified the deceased and rushed to the spot and tried to rescue the deceased from the clutches of the petitioner. In the very same incident, he also got injured. First, it is settled principle. Shop owner, the eyewitness has seen. First, the shop owner has also rushed to the spot and tried to rescue the deceased. First, in the process, he is also injured. First, it is settled principle of law that whenever the prosecution is supported by the statements of the eyewitnesses, prima facie, the case of the prosecution is strong. First, offence alleged against the petitioner herein is under section 302 IPC and there is a specific overtake that he took out dagger and stabbed the deceased near the navel region. Poster. The postmortem report also lends support to the overtake alleged against the petitioner herein. Poster. It is settled next para. It is equally settled principles of law that at the stage of deciding the bail petition, this court is not required to hold a mini trial to assess the merits or demerits of the case. Poster. Suffice as the same prejudice is the case of the parties during the trial one way or the other. Next para. Suffice to say that the material on record, especially the statement of the eyewitnesses, clearly show the role played by the present petitioner in the incident resulting in the death of Sri R.V. Swami. Poster. Next para. It is for the trial court to find out what exactly made the petitioner to assault the deceased. Poster. This court at this stage cannot decide on the said aspect of the matter to reduce the gravity of the offense. Poster. Further, next para. Further, grant of bail to accused number 2 and 4 would not be of much avail to the present petitioner inasmuch as the overtake alleged against the present petitioner is altogether different from the overtake alleged against accused number 2 and 4. Poster. Accordingly, on the ground of parity also, the petitioner has not made out any grounds, any good ground to enlarge him on bail by resorting to the special powers vested in this court under section 439 CRP. Accordingly, following order is passed. Section dismissed. Observations made by this court in this order shall not influence the trial judge while deciding the case on merits. Yes. Kumar. ಇದು ಓದ್ಸತ್ತಿದ್ದೇನಾ? What is the role for you? ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರೆ ಅವ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರೆ CGP ಅವ್ರು ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಹಾಕಿಲ್ಲ ಅಂತ ಬರ್ಕೊಂಡ್ರೆ ಆಯ್ತು. ಇನ್ನೇನು ಏನು ಇವ್ರೆ ಇದ್ರಲ್ಲಿ ಏನ್ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದಕ್ಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ವಾ? ಹೌದ್ರಿ ನೋಡಿ, time was granted for you to file objections on 11th February 2022. Thereafter, on 24th February, you have stated before the court that you are processing the information as to the total amount of the fraud that has been committed by this particular petitioner. ಆಮೇಲೆ ಏನಿಲ್ಲ, ಅದಾದ್ಮೇಲೆ ನಾನ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ಲ. 2:30 ಕರೀತೀನಿ. 2:30. If he is willing to file objections, let him file. Otherwise, objections not filed ಅಂತ ಬರ್ಕೊಡ್ತೀವಿ. ಕಸ್ಟಡಿಯಲ್ಲಿ ಬಂತ್ರಿ 438 ಅಲ್ಲಿ ನೀವು ಸರಿ ಅದು ಹೇಳಿದಿರಿ. ನನಗೆ ನೆನಪಿದೆ. ನೀವು ಕೂಡ ಮೋಸ ಹೋದವರು ಅಂತ ಹೇಳಿದಿರಿ, ಒಂದ್ಸತಿ ಹೇಳಿದಿರಿ. ಹರಿಕೃಷ್ಣ. ಮಧ್ಯಾಹ್ನ 2:30 ನೋಡೋಣ ಅವ್ರ ಏನಾಗ್ತಾರೆ. ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹಾಕ್ಲಿಲ್ಲ ಅಂತ ತಗೊಂಡು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ. ಹೇಳಿ. ಹರಿಕೃಷ್ಣನ್ ಬದಲು ನಾಯಕ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಏನ್ ಮಾಡೋದು? ನೀವು ಇದ್ದೀರಾ? ಇರ್ಲಿ. ಎಸ್ ಹೇಳಿ. ಅಲ್ಲ ಇದೇನಿದು, ಇದು ಬಾಡಿ ವಾರೆಂಟಾ? ಅಲ್ಲ, were you arrested in this? ಅಲ್ಲ, ಇದೇನೋ ನೆನ್ನೆ ತರದ್ದು, ನೆನ್ನೆದ್ ಯಾವ್ದೋ ಅದ್ರ ಜೊತೆಗೆ ಬಂದ್ಬಿಟ್ಟಿದೆ ಅದು. ಏನಾಗ್ಬಿಡುತ್ತೆ, ಹಿಂಗಾಗ್ಬಿಡುತ್ತೆ ಅದು, ನೋಡ್ಕೊಳ್ಳಿ. ಆಯ್ತು ಬಿಡಿ ಅದನ್ನು. ಎಸ್, ಹೇಳಿ.
Yes, given supporting to article number 1 and 2 to the father. For the reason that he has developed some illicit relations. And they also gas agency. All the properties are sold. And the gas agency and here that and for this illicit relation.
ಅಲ್ಲ ರೀ, ಅವ್ರ ಅಪ್ಪನ್ನೇ ಕಲಿಸ್ತೀರಿ ಏನ್ರಿ? ಸಿ, ನೀನ್ ಹಿಂಗೆ ಇತ್ತು ಅಂತಂದ್ರೆ ಎಲ್ಲಾ ಮಾರಾಟ ಮಾಡ್ಬಿಡ್ತೀನಿ, ನಾನು ನಿಂಗೇನು ಉಳಿಸಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ನೀನ್ ಇದ್ರೆ ತಾನೆ ಅಂತ ಎತ್ತಾಕ್ಸ್ಬಿಟ್ರೆ ಏನಂತ ನೋಡಿ. ಎಲ್ಲಾ ಘಟನೆಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ 3ನೇ ಆರೋಪಿ ಶ್ರೀನಿವಾಸ್ ಅವರ ಮೂರ್ತಿ ಮಧ್ಯೆ ಹಲವಾರು ಬಾರಿ ಗಲಾಟೆಗಳಾಗಿದ್ದು, ಗಲಾಟೆಗಳ ಸಮಯದಲ್ಲಿ ಕೊಲೆಯಾದ BN ಶ್ರೀನಿವಾಸ್ ಮೂರ್ತಿರವರು ತಮ್ಮ ಎಲ್ಲಾ ಆಸ್ತಿಗಳನ್ನು ಮಾರಾಟ ಮಾಡಿ ನಿನಗೆ ಏನೂ ಇಲ್ಲದಂತೆ ಬಿಕಾರಿಯಾಗಿ ಮಾಡುತ್ತೇನೆಂದು ಬೆದರಿಸಿದ ಕಾರಣ ಆಪಾದಿತ 3 ಅಂದ್ರೆ ನೀವೇ, ಆಯ್ತಾ, ಅವರ ತಂದೆ ಅಂದ್ರೆ ಶ್ರೀನಿವಾಸ್ ಮೂರ್ತಿಗೆ ಗೊತ್ತಾಯ್ತಲ್ಲ, ಆಲದ ಮರದ ಬಳಿ ಕರೆಸಿಕೊಂಡು ನನ್ನ ತಂದೆ ಎಲ್ಲ ಆಸ್ತಿಗಳನ್ನು ಮಾರಾಟ ಮಾಡಿ ಏನ್ ಮಾಡುತ್ತಾನೆ, ತಮ್ಮ ತಂದೆಯನ್ನು ಕೊಲೆ ಮಾಡಲು ಮಾತುಕತೆ ಮಾಡಿ 1 ಲಕ್ಷ ರೂಪಾಯಿಗಳಿಗೆ ಸುಪಾರಿ ನೀಡಿ 19/5/21 ಆಪಾದಿತ 3ರವರು ಅಪಾದಿತ 2ರವರಿಗೆ ತನ್ನ ATM ಕಾರ್ಡ್ ಅನ್ನು ನೀಡಿ ಮುಂಗಡವಾಗಿ ಹಣ ಡ್ರಾ ಮಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದ. ಅದೇ ದಿನ ದೊಡ್ಡಬಳ್ಳಾಪುರದ ಕ್ರಾಸ್ ನಲ್ಲಿ 16,000 ರೂಪಾಯಿ ಡ್ರಾ ಮಾಡಿಕೊಂಡು 28/5/21 ಯಲಹಂಕದ ಕೆನರಾ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ 11,000 ರೂಪಾಯಿ ಡ್ರಾ ಮಾಡಿಕೊಂಡು ಆ ಸಾಕ್ಷಿ 10/11ರವರೆಗೆ ಶ್ರೀನಿವಾಸ್ ಮೂರ್ತಿಯನ್ನು ಕೊಲೆ ಮಾಡಲು ಒಪ್ಪದ ಕಾರಣ ಆಪಾದಿತರೊಂದಿಗೆ ಒಪ್ಪಿಸಿ ATM ಡ್ರಾ ಮಾಡಿದ 5,000 ರೂಪಾಯಿ ಹಣವನ್ನು ಮುಂಗಡವಾಗಿ ನೀಡಿ 13/6/21 1-2-3ರವರು ಆಲ್ದಮರಿ ಬಳಿರುವ ಬಂಡೆಯ ಬಳಿ ಕೊಲೆ ಮಾಡಲು ಸಂಚು ರೂಪಿಸಿ ಶ್ರೀನಿವಾಸ್ ರಾತ್ರಿ ತೋಟದ ಬಳಿ ನೀರು ಬಿಡಲು ಹೋಗಿದ್ದಾಗ 1-2 ಬೋರ್ವೆಲ್ ಪ್ಯಾನೆಲ್ ನ ಬೋರ್ಡ್ ನಲ್ಲಿ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಕಲ್ಪಿಸಿ ವಿಫಲ ಹತ್ಯೆ ಪ್ರಯತ್ನ ನಡೆಸಿರುತ್ತಾರೆ. ಮೊದಲೊಂದು ಅಟೆಂಪ್ಟ್, ಅಯ್ಯೋ ಪಾಪ ಅಂತ ಬಂದು ಹಿಂದಿನಿಂದ ಬಂದು ಹಿಡಿದುಕೊಂಡಾಗ ಆಪಾದಿತ 2ರವರು ಕೆಳಗೆ ತಲೆ ಸಮಯದಲ್ಲಿ 1ಅವರು ತನ್ನ ಕೈಯಲ್ಲಿದ್ದ ಸ್ಟೀಲ್ ಪೈಪ್ ನಿಂದ ಬಲವಾಗಿ ತಲೆಗೆ ಹೊಡೆದ ಕಾರಣ ಶ್ರೀನಿವಾಸ್ ಮೂರ್ತಿ ಬೋರ್ಲಾ ಕೆಳಗೆ ಬಿದ್ದು ಹೋದನು. ಪುನಃ ಎಡಮಾರಿ ಸ್ಟೀಲ್ ಪೈಪ್ ನಿಂದ ತಲೆಗೆ ಹೊಡೆದು ಮಾರಣಾಂತಿಕ ಹಲ್ಲೆ ನಡೆಸಿ ಕಾಲಿನಿಂದ ಒದ್ದು ಕುತ್ತಿಗೆ ಮೇಲೆ ಮುಖವನ್ನು ನೆಲಕ್ಕೆ ಒತ್ತುವಂತೆ ಬಲವಾಗಿ ತುಳಿದು ಸಾಯಲು ಕಾರಣರಾಗಿದ್ದಾರೆ. ಏನ್ ಕರ್ಣನೇ ಇಲ್ವಾ? ಎತ್ತಪ್ಪನ್ನ ಈ ತರ ಕೊಲಿಸ್ತಿರಲ್ಲ. ಎಸ್, ವಾಟ್ ಯು ವಾಂಟ್ ಅನ್ ಆರ್ಡರ್? ಎಸ್, ಬರ್ಕೊಳ್ಳಿ ಹಾರ್ಡ್. ಶ್ರೀ ಎಂತ ನಾಯಕ್ ನೀವು? ವೆಂಕಟರಮಣ ನಾಯಕ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್, ಅಲ್ಲ ಸಾಕು, ವೆಂಕಟರಮಣ ನಾಯಕ್ ಆನ್ ಫಾರ್ ದಿ ಪೆಟಿಷನರ್ and learned just a petition under section 439 CRPC with the following prayer. ನಾನು ಕೇಳಿದ್ನಪ್ಪ, ಮೆಮೊ ಫೈಲ್ಡ್, ಮೆಮೊ ರೀಡ್ ಸೆಕೆಂಡ್, ಮೆಮೊ petition dismissed as withdrawn. Jay Prakash Rao.
My lord, I am for the petitioner in this case, my lord. On the last occasion, my lord was pleased to direct the government pleader to file objection. I have also filed a memo, my lord, the order copy, my lord, in relation to accused number 2, where my lord was pleased to grant bail. This, my lord, is the order dated 3rd March 2021. I've served the copy to the government pleader, my lord, today in the morning. That was the office objection which was raised. Allegations, my lord, is in the FIR, my lord, section 34 and 420. Now on site Martin, my lord, site number 6. Accused number 2 has sold site number 7. Ega, my lord, the complainant comes to the conclusion that no such site exists, and he goes and gives a complaint.
Adರಲ್ಲಿ second sale ಆಗಿತ್ತು. When I have granted for the other man, it
My lord.
was for the second sale. You are the person now who has sold.
Yes, my lord. I have purchased this site, my lord,
It
from
was the second sale.
Yes, my lord.
It was the second sale. Then there, how can there be any parity?
Yes, my lord. My lord is very much right. My only
ಮತ್ತೆ ಅದನ್ನ
submission,
ಯಾಕೆ ಹೇಳ್ತೀರಿ? ಸುಮ್ನೆ ಟೈಮ್ ವೇಸ್ಟ್.
my lord, my only submission is khata ide, my lord, and also the.
No, that's a different issue.
Yes, my lord. Yes, my lord.
First one is waste.
Yes.
ಏನ್ ಉಪಯೋಗ ಇಲ್ಲ, ಒಂದು ಇಲ್ಲ. ಎಲ್ರಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತಿರೇನ್ರಿ? ಯಾವಾಗ? ಹೋದ್ ಸತಿ ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದು. ಅದೇ ಸೊಸೈಟಿ ಅಂತ ಹಾಕಿದ ಪಕ್ಕದ ಸೈಟು ಅಂತ ತೋರ್ಸೋದು, ಅದು ಅದೇ ಕೇಸ್. HGP press time, release this matter on 18. It will not act as a parity for you.
Yes, my lord. Only
It was a case
submission.
where it was a second sale. So the person who had obtained the bail is the person who had sold it then, not now.
Yes, my lord. The person A to my lord is.
ಮತ್ತೆ ಅವ್ರಿಗೆ
directly
ಅವ್ರದ್ದು
representing-
ಆಗಾದ್ಮೇಲೆ ಅವ್ನು ಎಷ್ಟೋ ವರ್ಷ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಮಾರ್ದವ್ರಿಗೆ ಪೊಲೀಸ್ನವರು ಮೊದಲು ಮಾರ್ದವನ್ ಮೇಲೆ ಹಾಕ್ಬಿಟ್ರೆ ಏನಾಗುತ್ತೆ? ಅದನ್ನ ಕೊಟ್ಟಿದ್ದೆ ಬೇಲು.
My
That is
submission,
not
my
the
lord.
similarity with you.
No, one submission, my lord. A
No,
to
no,
my
that
lord-
is not similarity with you. When
Yes,
that
ma'am.
is not similarity, no parity.
Yes, my lord. Only one
That's
request,
all.
my lord. Short date, if my lord be pleased to grant, my lord, I'll be very obliged. 18th.
That is
my
the
lord.
shortest. Next Friday is the shortest. I have
Great.
100 cases a day.
No, obliged, my lord. Grateful, my lord. Obliged.
Usually I'll be adjourning it to 29, 28, 29. Since
Obliged.
already once time it has come up, 18th, next
Obliged, my
Friday.
lord. Grateful. Grateful.
Darshan. Hmm. 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 ಅದೇ ಕೂಲಿ ಜಾಬ್ ಕಾರ್ಡ್ ನ ನಾಮ ಹಾಕ್ಬಿಟ್ಟಿರೋದು. ಯಾರ್ಯಾರ್ದ್ರಲ್ಲಿ ಏನೇನ್ ದುಡ್ಡುಗಳು ತಿನ್ಬೋದ ಎಲ್ಲ ತಿನ್ಬೋದ್ ನೋಡ್ರಿ. ಯಾವ ಫೋರ್ ಆದ್ರೆ ಏನಂತ್ರಿ? ಇಲ್ದಿರೋರ್ಗೆಲ್ಲಾರ್ಗು ಜಾಬ್ ಕಾರ್ಡ್ ನೆಲ್ಲ ಇರೋ ವ್ಯಕ್ತಿಗಳಿಗೆ ಮಾಡ್ಕೊಡ್ರಿ ಅಂತ NREGA ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಫಿಕ್ಟೇಷಿಯಸ್ ಪರ್ಸನ್ಸ್ ಗೆ ಜಾಬ್ ಕಾರ್ಡ್ ಮಾಡಿದಿರಿ ನೀವು ಜವಾಬ್ದಾರಿ ತಗೊಂಡು. ಅದೇ ನೀವು ಹೆಂಗೆ ನಿಮ್ಗೆ ಆರ್ ಯು ಎಂಟೈಟಲ್ಡ್? ವೆರ್ ಇಸ್ ದಿ ನೆಸರಿ ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ಫಾರ್ ದಟ್? Are you entitled to hold a job card? It's a fake job card. ಏನ್ ಮಾಡ್ತೀರಿ? ಫೇಕ್ ಜಾಬ್ ಕಾರ್ಡ್ ಇಟ್ಕೊಂಡು. Counsel press time to file necessary documents to substantiate his case. Then HGP in the meantime to file objections. ನೋಡ್ರಿ, ಸರ್ಕಾರದ ದುಡ್ಡು ಮೋಸ ಆಗ್ತಾ ಇದೆ. ಗ್ರಾಮ ಪಂಚಾಯತಿಲಿ ₹1 ಬರುತ್ತೆ, ಗೊತ್ತಾಯ್ತಲ್ಲ? ಅಲ್ಲೆಲ್ಲೋ ಏನೋ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಏನ್ ಮಾಡಿದಾರೋ ದೇವ್ರಿಗೆ ಗೊತ್ತು. ಚೆಕ್ ಡ್ಯಾಮ್ ಕಟ್ಟಿದ್ವಿ ಅಂತ, ಅದಕ್ಕೆಲ್ಲ ಇವ್ರದೆಲ್ಲ ಜಾಬ್ ಕಾರ್ಡ್ ತಗೊಂಡು ದುಡ್ಡು ಕೊಟ್ವಿ ಅಂತ. ಮುಂದಿನ ಸರ್ತಿಗೆ ತಿರ್ಗಾ ಚೆಕ್ ಡ್ಯಾಮ್ ಕಟ್ತೀವಿ ಅಂತಾರೆ. ಏನ್ರಿ ಆಯ್ತು ಅಂದ್ರೆ ಹೋದ್ ಸರ್ತಿ ಪ್ರವಾಹ ಜಾಸ್ತಿ ಬಂದು ಚೆಕ್ ಡ್ಯಾಮ್ ಕಟ್ಕೊಂಡು ಹೊಟ್ಟೋಯ್ತು. ಹಳೆ ಕಲ್ಲು ಹೊಸ ಬಿಲ್ಲು ಆಯ್ತಲ್ಲ? ಏನ್ ಮಾಡಿದಿರಿ ಜಾಬ್ ಕಾರ್ಡ್ ಅಂದ್ರೆ? ನೀವು ಮನೆಗೆ ಎಂಟೈಟಲ್ಮೆಂಟ್ ಬೇಕಲ್ಲ, ಎಲ್ರಿಗೂ ಕೊಡೋದಿಲ್ಲ ಅದನ್ನ. ಆ ಗ್ರಾಮದಲ್ಲಿ 100 ದಿವಸಗಳ ಕಾಲ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಸುಮ್ನೆ ನಿರುದ್ಯೋಗನಾಗಿರ್ಬಾರ್ದು. ಅವನು ಕಟಾವು ಗಿಟಾವು ಎಲ್ಲ ಮುಗ್ದೋಗ್ಬಿಟ್ಟಿರುತ್ತೆ. ಅವಾಗ ಕೂತ್ಕೊಂಡು ಅಲ್ಲಿ ಇಲ್ಲಿ ಮಾತಾಡಬಾರ್ದೆಲ್ಲ ಮಾತಾಡ್ಕೊಂಡು ರಷ್ಯಾದಲ್ಲಿ ಉಕ್ರೇನ್ ಯುದ್ಧ ನಿಲ್ಲಿಸ್ಬೇಕೋ ಬೇಡವೋ ಅಂತ ಇವರು ಆ ಪಂಚಾಯತಿ ಕಟ್ಟೆ ಮೇಲೆ ತೀರ್ಮಾನ ಮಾಡ್ತಾರೆ. ಅದು ಆಗ್ಬಾರ್ದು ಅಂತ ಕೆಲಸ ಕೊಡೋದು. ಜಾಬ್ ಕಾರ್ಡ್ ಅಂದ್ರೆ ಅದು. ಅದನ್ನ ಕೊಟ್ಟು ಅವ್ರ ಹೆಸರು ತೋರಿಸಿ ಒಂದು ಅಕೌಂಟ್ ಓಪನ್ ಮಾಡಿ ಆ ಅಕೌಂಟ್ಗೆ ನೇರವಾಗಿ ದುಡ್ಡು ಹಾಕ್ಬೇಕು. ಇಲ್ದರೆ 10 ಬೆಟ್ಟಲ್ಲೂ ಸೈನ್ ಹಾಕಿ ತಗೊಳ್ತಾ ಇದ್ರು ದುಡ್ಡನ್ನ. 20ನೇ ಬೆಟ್ಟಲ್ಲೂ ಹಾಕೋರು ಕಾಲಿಂದು ತಿಮ್ಮಣ್ಣ, ಬೋರಣ್ಣ ಅಂತ. ಅದೆಲ್ಲ ತಪ್ಸೋದಿಕ್ಕೆ ಇದ್ ಮಾಡಿದ್ರು. ಈಗ ಅದ್ರಲ್ಲೇ ಮೋಸ, ಜಾಬ್ ಕಾರ್ಡ್ ಇಶ್ಯೂ ಮಾಡೋದ್ರಲ್ಲೇ ಮೋಸ. ನಿಮ್ ಮನೆಯಲ್ಲಿ ಒಬ್ರಿಗೆ ಕೊಟ್ಟಿದಾರ ಇಲ್ವೋ? ಯು ಆರ್ ದಿ ಸೆಕೆಂಡ್ ಪರ್ಸನ್ ಟು ಹೋಲ್ಡ್ ಇಟ್. ಮನೆಗೆ ಒಂದೇ ಕೊಡ್ಬೇಕಾಗಿರೋದು ಜಾಬ್ ಕಾರ್ಡ್. ಹೆಂಗ್ ಕೊಟ್ರು ಮತ್ ನಿಮ್ಗೆ? ಎಸ್, ಯು ಗಾಟ್ ದಿ ಪಾಯಿಂಟ್. ಫಲಾನುಭವಿಗಳು ಎಲ್ರಿಗೂ ಸಿಕ್ಬೇಕು. ಒಂದೊಂದ್ ಮನೆಗೆ ಒಬ್ಬೊಬ್ಬರು ಕೊಟ್ಟಿರ್ತಾರೆ. ಎಲ್ಲ ನಮ್ಗೆ ಇರ್ಲಿ ಅಂದ್ರೆ ಆ ಇರ್ತಕ್ಕಂಥ ಗ್ರಾಮದಲ್ಲಿ ಎಷ್ಟ್ ಜನ ಇದ್ದಾರೆ ಅಷ್ಟ್ ಜನ ನೋಡಿ ಅಲ್ಲಿ ಮನೆಗೊಬ್ಬರಿಗೆ ಅಂತ ಕೊಟ್ಟು ಅದೇನಿದೆಯೋ ಕೆಲಸ ಮಾಡಿಸಿ ಇವ್ರಿಗೇನೋ ಮಾಡ್ಲಿ ಅಂತೇಳಿ ಘನೋದ್ದೇಶದಿಂದ ಸರ್ಕಾರ ಈ ತರ ಎಲ್ಲ ಯೋಜನೆಯನ್ನು ಜಾರಿಗೆ ತರುತ್ತೆ. ಈ ಯೋಜನೆ ಎಲ್ಲ ಹಳ್ಳ ಹಿಡಿಯೋದು ಹೇಗೆ ಅಂತಂದ್ರೆ ಹಿಂಗೇನೇನೆ. ಈ ಜಾಬ್ ಕಾರ್ಡ್ ಮಾಡಿಸಿದ್ ಯಾಕೆ ಬೇಕು ಅಂತಂದ್ರೆ, ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಆ ಜಾಬ್ ಕಾರ್ಡ್ ಇಲ್ದೇನೆ ಅವನಲ್ಲಿ ಕೆಲ್ಸಕ್ಕೆ ಸೇರಿಸ್ಕೊಂಡೆ ಅನ್ನಕ್ ಆಗಲ್ಲ, ದುಡ್ಡು ಹಾಕ್ಬೇಕು. ಅಲ್ಲಿಂದನೇ ಮೋಸ ಸ್ಟಾರ್ಟ್, ಫ್ರಾಡ್ ಸ್ಟಾರ್ಟ್. What will happen in all such circumstances? The needy will not get. Some person who is well off will get a job card. And that job card is now itself appears to be fake. What will happen then? Nodi. Harish Bandari. Next week annalama 18/3. In the meantime, HCGP to file objections ella banto illo? At least released on 18/3. ಏನಿದು ಭಂಡಾರಿ ಅವರೇ? 438 ಅಫೆನ್ಸ್ ಏನು? 306. ಶಿವಕುಮಾರ್. What is his role in the suicidal death? ಸಾಲದ ಕಿರುಕುಳ ತಾಳಲಾರದೆ ಆತ್ಮಹತ್ಯೆ. ಓದಿ.
ಆತ್ಮಹತ್ಯೆ ಮಾಡಿಕೊಂಡಿರೋ ಬಗ್ಗೆ ಹಾಗೆ ನಾನು ಶ್ರೀನಿವಾಸ ತಂದೆ ವಾಸ ನಮ್ಮಲ್ಲಿ ದೂರು ಏನೆಂದರೆ 26/7/2021 ನಮ್ಮ ತಾಯಿಯವರು ನಮ್ಮ ತಂದೆಯವರಿಗೆ 6 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ನಾವು ರಾತ್ರಿ ಹೋಗುತ್ತಿದ್ದರು. ಹಾಕಿಕೊಂಡಿಗೆ 1 ಲಕ್ಷವನ್ನು ತಿಳಿದುಕೊಂಡು ನಾವು ಊರಿನಲ್ಲಿ ನಡೆದಿರುವ ಸಮಯ ಒಂದು ಗಂಟೆಯಿಂದ ನೀರು ಹಾಕಿಕೊಂಡಿರುತ್ತಾರೆ. ನಮ್ಮ ತಾಯಿ ಏನು ಬೇಕಿತ್ತು ತಕ್ಷಣ ನಾವು ಜೀವ ಹೇಳುವುದನ್ನು ಭಾವಿಸಿದ್ದೇವೆ. ಜೀವ ಹೋಗಿತ್ತು. ನಂತರ ನಮ್ಮ ತಂದೆಯವರ
ನೋಡಿದೆವು.
ಅದರಲ್ಲಿ ಅವರಿಗೆ ಮಂಜುನಾಥ ಕೊಡುತ್ತೇವೆ ಎಂದು ಹೇಳಿ ಹಣ ಮಾಡದ ಉದ್ದೇಶ ಇನ್ನೊಬ್ಬರು BS ಶಿವಕುಮಾರ ಜಯಪ್ರಕಾಶ ಕಾರಣ ಎಂದು ಬರೆದಿರುತ್ತಾರೆ. ಆರೋಗ್ಯಕ್ಕೆ ನನ್ನ ಸಾವಿಗೆ ಸಮಯದಲ್ಲಿ 2 ಬರೆದಿರ್ತಾರೆ. ನಾವು ಓದಿ ತಿಳಿದುಕೊಂಡು 25/2 ಸಮಯ ಬೆಳಿಗ್ಗೆ 6:30ರಲ್ಲಿ ಮಂಜಣ್ಣ ಮತ್ತು ಅವರ ಹೆಂಡತಿ ನಮ್ಮ ಮನೆ ಹತ್ತಿರ ಬಂದು ಸಾಲ ಹಣ ಕೊಡಿ ಎಂದು ಗಲಾಟೆ ಮಾಡಿ ಅವಮಾರ್ಯಾದೆ ಮಾಡಿರುತ್ತಾರೆ. ನಾವು 1 ವಾರದಲ್ಲಿ ಹಣ ಮುಟ್ಟಿಸ್ತೇವೆ ಎಂದು ಹೇಳಿದರು. ಕೇಳದೆ ಮಾನಸಿಕ ಹಿಂಸೆ ಮಾಡಿ ಹಣ ಬರಲಿಲ್ಲ ಎಂದರೆ ಜನಗಳನ್ನು ಕರೆದುಕೊಂಡು ಗಲಾಟೆ ಮಾಡುತ್ತೇವೆ ಎಂದು ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿ ಹೋದರು. ನಂತರ ಇದು ಏನಾದರೂ ಮಾಡಿ ಸಾಲ ತೀರಿಸಬೇಕೆಂದು ತಿಳಿದು ನಮ್ಮ ತಂದೆಯವರು ಕೊಟ್ಟಿದ್ದ 1 ಲಕ್ಷ ರೂಪಾಯಿ ವಾಪಸ್ ಕೊಟ್ಟಿಲ್ಲ. ಯಾವುದೇ ರೀತಿಯಾಗಿ ಹಣ ಕೊಡದೇ ಇರುವುದರಿಂದ 22 ಮಧ್ಯಾಹ್ನ ನಮ್ಮ ತಂದೆಯವರು ಹೊರಗೆ ಕೂಡಲೇ ಹಣ ಕೇಳಿದಾಗ ನನ್ನ ಅಲ್ಲಿ ಹಣ ಇಲ್ಲ ಕೂಡಲೇ ಹೇಳಿದರು. ಆಗ ನಮ್ಮ ತಂದೆಯವರು ಹಣ ಕೊಡೋದಿಲ್ಲ, ನಿನ್ನ ಹೆಸರು ಬರೆದಿಟ್ಟು ಹೇಳಿರ್ತಾರೆ. ಅದಕ್ಕೆ ಅವನು
ಸಾಯಿ ಹೋಗು, ನಾನು ಕೊಡುವುದಿಲ್ಲ ಎಂದು ಉಡಾಫೆ ಉತ್ತರ ಕೊಟ್ಟ. ನೀವೇನ್ ಮಾಡಿದ್ರಿ ನೀವು? ಮತ್ ನಿಮ್ಮ ಹೆಸರು ಯಾಕೆ ಬರ್ದ ಅವನು? ನೀವ್ ಹೇಳ್ಬೇಕು ಯಾಕೆ ಬರ್ದ ಅಂತ. ಸಾಯೋನು ಶಿವಕುಮಾರ್ನ ಹೆಸರು ಯಾಕೆ ಬರ್ದ ಅಂತ ನಿಮ್ಗೂ ಗೊತ್ತಿರುತ್ತಲ್ಲ. ಶಿವಕುಮಾರನ ಹೆಸರು ಸುಮ್ನೆ ಯಾಕೆ ಬರ್ತಾನೆ? ಏನ್ ವಿಷ್ಣು ಸಹಸ್ರನಾಮ ಬರ್ದಿದ್ ಚಟ್ನೆ ಅವನು? ಅಲ್ಲ, ನಿಮ್ಗೂ ಅವ್ರಿಗೂ ಏನೋ ಕನೆಕ್ಷನ್ ಇತ್ತು. ಅಲ್ಲ ಭಂಡಾರಿ ಅವರೇ, ಸರಿಯೇ, ನೀವ್ ಹೇಳೋ ಪಾಯಿಂಟ್ ಚೆನ್ನಾಗಿದೆ. ಆದ್ರೆ ಶಿವಕುಮಾರ ನಿಮ್ ಹೆಸರು ಬರಿಬೇಕಾದ್ರೆ ಏನೋ ಕಾರಣ ಇರ್ಬೇಕು. ಹೌದೌದು, ಅದನ್ನೇ ನಾನ್ ನಿಮ್ಮನ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ನಿಮಗ್ ಗೊತ್ತಿರುತ್ತಲ್ಲ. ಅಲ್ಲ, ನಿಮ್ಮ ಹತ್ರ ಸುಮ್ನೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಏನಾಗಿದೆ ಅಂತ. ಶಿವಕುಮಾರ ಯಾರು, ಜಯಪ್ರಕಾಶ್ ಯಾರು, ಮಂಜಣ್ಣ ಯಾರು ಅಂತ. ಸರಿ, ಯಾವ ಶಿವಕುಮಾರನ ಊರಲ್ಲಿ ನೀವೇ ಹೆಂಗ್ ಬಂದ್ಬಿಟ್ರಿ? ಎಷ್ಟೊಂದ್ ಜನ ಶಿವಕುಮಾರ ಇರ್ಬೋದಲ್ವಾ? ಇರ್ಬೋದಲ್ಲ ಇದೆ ಭಂಡಾರಿ? ಅಲ್ಲ, FIR ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಹೆಸರು? ಅಲ್ಲೇ ಅವರೆಲ್ಲ ಪುರಾಣ ಎಲ್ಲ ಹಾಕಿದಾರೆ ಯಾವ ಶಿವಕುಮಾರ್ ಅಂತ. ಅದೇ ಶಿವಕುಮಾರ್ ನೋಡಿ, ಒಂದ್ ಲಿಂಕ್ ಸಿಕ್ತು. ಅಲ್ಲ, ತಾವು FIR ಅಡ್ರೆಸ್ ನೋಡಿ. ಶಿವಕುಮಾರ್ A2, ದಾವಣಗೆರೆ, ಕರ್ನಾಟಕ, ಇಷ್ಟೇ ಇದೆ. ಯಾವ ಶಿವಕುಮಾರ್ ಅವನು? ನೀವ್ ಯಾಕೆ ಬಂದ್ರಿ? ಯಾರಿಗ್ ಗೊತ್ತು? ಎಲ್ಲಾ ಶಿವಕುಮಾರ್ನು ಶಿವಕುಮಾರ ಅಂತ ಹೋಗ್ತಾ ಇದ್ದಾರೆ. ಹಂಗಲ್ಲ ಶಿವಕುಮಾರ ಅಂತ ಹೋಗ್ತಾರೆ. ದಾವಣಗೆರೆನಲ್ಲಿ ಶಿವಕುಮಾರ್ ಅಂತ ಕೇಳಿದ್ರೆ ಸುಮಾರು ನನ್ನ ಅಂದಾಜಲ್ಲಿ 25,000 ಜನ ಸಿಗ್ಬೋದು. ಯಾವ ಶಿವಕುಮಾರ್ ಅಂತೇನಿಲ್ಲ, ಅಡ್ರೆಸ್ ಇಲ್ಲ, ತಂದೆ ಹೆಸರಿಲ್ಲ, ಮನೆ ಅಡ್ರೆಸ್ ಇಲ್ಲ, ಏನೇನಿಲ್ಲ. ಇವಾಗ ನೀವೇ ಬಂದಿದ್ದೀರಿ ಅಂದ್ರೆ ಆ ಸಾವಿನಿಂದ ನಿಮ್ಗೇನೋ ಒಳಗಡೆ ಭಯ ಆಗಿದೆ. ಇದ್ದಿರೋದಕ್ಕೆ 438. ಎಸ್, ಏನ್ರಿ? mere mentioning of a name in the death note is not sufficient that he has abetted for the suicidal. That is the latest trend. Of course, ಮೊದ್ಲಿಂದನೂ ಹಾಗೆ ಇತ್ತು. ಬರೇ ಹೆಸರುಗಳನ್ನ ಸೇರಿಸಿದ್ರೆ ಸಾಲದು ಅಂತ ಏನಾರು ಒಂದ್ ಬರ್ದಿರ್ಬೇಕು. ನನ್ನ ತರ ಇತ್ತಲ್ಲ ಹಂಗೆ ಉದ್ದಕ್ ಬರ್ದಿರ್ಬೇಕು ಡೆತ್ ನೋಟ್ ಅಲ್ಲಿ. ನನ್ನ ಸಾವಿಗೆ ಇವರೇ ಕಾರಣ ಅಂತ ಹೇಳಿದ್ರೆ ಮೇಡಮ್ 4ನೇ ಕ್ಲಾಸಲ್ಲಿ ಸ್ಕೇಲ್ ತಗೊಂಡು ಹೊಡೆದಿದ್ರು ಅಂತ ಅವ್ರ ಹೆಸರು ಬರೀಬಹುದು ಬೇಕಾದ್ರೆ, ಸಾಯಿವಲ್ಲ. ಏನಾದ್ರು ಹೇಳ್ಬೇಕಲ್ಲ. ಇಡೀ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಶಿವಕುಮಾರನ್ ರೋಲ್ ಹೇಳಲ್ಲ. ಮಂಜುನಾಥನ್ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ, ₹1,00,000 ಸಾಲ ಮಾಡಿದ್ರು, ಅದನ್ನ ವಾಪಸ್ ಕೊಡ್ಲಿಲ್ಲ, ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋಗಿದ್ರು, ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಕೇಳಿದಾಗ ಅವ್ರು ಹಣ ಕೊಡ್ಲಿಲ್ಲ, ಅವ್ರೇನೋ ಪ್ರಯತ್ನ ಮಾಡ್ಲಿಲ್ಲ, ಬಹಳ ಕಷ್ಟ ಆಗಿತ್ತು ಅವ್ರಿಗೆ. ಅದಕ್ಕೆ ತಿರ್ಗಾ ಫೋನ್ ಮಾಡಿ ಕೇಳಿದ್ರು, ಅವ್ನು ಕೊಡ್ಲಿಲ್ಲ. ಏನ್ ಅವ್ರಿಗೆ ಹಣದ ಮುಗ್ಗಟ್ಟಿತ್ತೋ ಗೊತ್ತಿಲ್ಲ, ₹1,00,000 ಒಬ್ಬನ್ಗೆ ತುಂಬಾ ದೊಡ್ಡ ಹಣ ಆಗುತ್ತೆ, ಅದಕ್ಕೋಸ್ಕರ ಅವ್ನು ಕೊಡ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಸತ್ಯ ಅನ್ನೋದು ಓಕೆ. ಬಟ್ ಸುಮ್ನೆ ಶಿವಕುಮಾರ, ಜಯಣ್ಣ ಅಂತ ಯಾರೋ ಹೆಸರು ಬರೆದಿದ್ದಾರೆ. ಏನೇನಿತ್ತು ಅಪಿಯರ್ ಆಗ್ಲಿ ಬಿಡಿ, ನಿಮ್ ಮುಂದೆ ಕೇಳ್ಕೊಳ್ಳಿ. ಎಸ್, ಬರ್ಕೊಳ್ಳಿ. ಹಾರ್ಡ್ ಶ್ರೀ ಭಂಡಾರಿ, ಹರೀಶ್ ಭಂಡಾರಿ ಅಂಡ್ ಲರ್ಡ್ HGP. Present petition is filed under section 438 CRPC with the following prayer. First, next para. Brief facts of the case are as under. Upon the complaint lodged by B. Srinivasa, son of Revappa, Davangere with Vidyanagar PS, Davangere, have registered a case in crime number 25/2021 for the offence punishable under section 506 306-30, read with section 34 IPC. First, present petitioner is shown as accused number 2. First, next para. In the complaint, it is contended that there was a financial transaction between the complainant, between the deceased and the DS Manjunath, who is the first accused in the case. First, Manjunath had borrowed the money and did not return the same, and efforts made by the deceased to recover the money failed, and he got frustrated in the life, and he approached the police, and police were also not able to get the repayment of the money to the deceased. First, thereafter, he has telephoned to Manjunath and demanded the money. First, Manjunath flatly refused to repay the loan amount, and also told him on the phone, stating that he will not return the money. He may do whatever he wants, and he may also die. First, being frustrated with the said answer, deceased committed suicide on 26/2/2021 at about 6:45 AM in his house. First, a death note is found in the body of the death note was found by the complainant and his mother. First, based on the death note, they lodged the complaint. Police registered the case and are investigating. Police, after registering the case, are investigating the matter. First, since the name of the present petitioner is shown in the FIR, petitioner has expressed his apprehension of arrest and approached the district court with a prayer for grant of anticipatory bail, which was turned down by the learned district judge by order dated 21/1/2022 in series number 21 of 2022. Learned counsel, next para. Thereafter, the petitioner is before this court. First, next para. Learned counsel for the petitioner, Sri Harish Bandari, vehemently contended that mere mention of the name of the petitioner in the death note itself would not be sufficient to infer that the petitioner is responsible for the suicidal death of the deceased and thus sought for grant of bail. First, I also pointed out that no other details are forthcoming from the complaint as to why the present petitioner has been shown as accused number 2 in the case and sought for grant of anticipatory bail. Next, per contral and HCP opposes the bail petition, stating that name of the petitioner being found in the death note, police are investigating the matter, and custodial investigation of the petitioner is very much necessary to unearth the truth, and therefore sought for dismissal of the bail petition. First, next para. This court perused the records in view of the rival contentions. First, next para. It is a fact that the death note contains the name of the petitioner. First, however, it is now settled principles of law that mere mentioning the name of a person itself would not be sufficient to infer that the petitioner has also contributed or abetted the deceased to commit suicide. First, next para. Further, no other details are forthcoming in the death note or in the complaint as to the alleged role played by the present petitioner in the incident. First, next para. First, there is some force in the argument put forth on behalf of the prosecution that custodial investigation is necessary. However, mere mentioning of the name would not be sufficient enough to proceed against the petitioner as well. Therefore, a need has arisen for this court to harmoniously balance the right of the petitioner and the need of the prosecution for custodial investigation. Accordingly, following order is passed. Petition allowed. Petitioner directed to join the investigation on 23/3/2022 at about 10 AM by appearing before the investigation officer in Vidyanagar police station. First, the investigation officer is at liberty to take the petitioner to custody and complete the custodial investigation on the same day before 6 PM. First, thereafter, the petitioner be enlarged on bail on taking the bond in a sum of ₹1 lakh with 2 sureties for the like sum. First, next para. Petitioner shall not directly or indirectly hamper the investigation process or tamper the prosecution witnesses. First, he shall mark his attendance before the investigation officer till the final report every alternate Sunday between 10 AM to 2 PM till the final report is filed. He shall attend the court regularly. He shall not leave the jurisdiction of the Davangere district without the prior permission. Violation of any one of the conditions would entitle the prosecution to seek for cancellation of the bail. ಎಲ್ಲಿ ಹುಡುಗಿ ಕೆಂಪರಾಜು ಪಾಸವರ್ ಸುದರ್ಶನ್ ಆಯ್ತಾ ಎಲ್ರಿ ಅದೇನೋ ಚಾರ್ಜ್ ಶೀಟ್ ಅಂದ್ರಲ್ಲ ಏನ್ ಹಾಕಿಲ್ಲ ಯಾವತ್ತಿಂದ ಇದೆ ಕೇಸ್ ಇದು ಪೆಂಡಿಂಗು All right, at request of the council on behalf of the Nanjundegowda time period, release this matter on 18/3. What is this IA3? Madilla. None present. 2:30 Martin. It may not be proper to dismiss it now. Further hearing, adala madhyana 2:30. Arun Kumar, other 2:30. Yes, past our matters. Then Mohammed Sharif. Mohammed Sharif. Madhyana matter 2:30 no. Venkat Reddy, ಆಯ್ತು. ಸಂತೋಷ್ ಹೋಗಿ yes please. ಏನಾಯ್ತು ಇದು process? ಏನಮ್ಮ? No such person. ಡ್ರಗ್ ಪೆಡ್ಲರ್ ಎಲ್ಲ ಅಲ್ಲೇ ಸಿಗ್ತಾರೆ ಏನ್ರಿ ನೀವು ಸರಿ See, your memo is dated 26/1/2022. You sought for 15 days time. We are in March. That was over long back, no? 26/1 ಇಂದ 15 days ಅಂತಂದ್ರೆ ಏನ್ ಮಾಡೋದು ಮತ್ತೆ? ನೀವು ಕನ್ನಡ ಮೀಡಿಯಮ್ ಇಂಗ್ಲಿಷ್ ಮೀಡಿಯಮ್ ಓದಿದ್ ಇಂಗ್ಲಿಷ್ ಮೀಡಿಯಮ್ ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಅಲ್ಲಿ ವರ್ಣಮಾಲೆ ಅಂತಿತ್ತು, ಕ ಕ ಅಂತೆಲ್ಲ ಇರುತ್ತಲ್ಲ, ಅದೆಲ್ಲ ಇರುತ್ತೆ. ಆ ಅರಸ ಆ ಆನೆ ಅಂತ, ಅದ್ರಲ್ಲಿ ಟ ಟಗರು ಆದ್ಮೇಲೆ ಠ ಅಂತ ಇದೆ ದೊಡ್ಡ ಅಕ್ಷರ, ಗೊತ್ತಾ? ಠ ಅಂದ್ರೆ ಠಕ್ಕ ಅಂತ. ಅದ್ರ ಕೆಳಗಡೆ ಒಂದು ನಾಡ್ ನೋಡಿ ಗಾದೆ ಬರ್ದಿರ್ತಿದ್ರು, ಠಕ್ಕ ಬಿಟ್ಟರೆ ಸಿಕ್ಕ ಅಂತ. That is the only line one has to remember while ordering the bail. Silver line that is to be considered in bail jurisdiction is I go back to first standard where my madam has told this, thakka bittare sikka. Even today that is the only thing that is there. So ನೀವು ಅಲ್ಲಿ ಅಪೋಸ್ ಮಾಡ್ದಲ್ನೇ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಿ. ಇದ್ರೆ ಅಲ್ಲಿ NBW ಆಗುತ್ತೆ. 439(2) ಯಾಕೆ? Correct, madam. Please understand. Wait. If you are not able to get him there, then why 439(2)? See, when once the NBW is ordered, and if your investigation agency is able to produce him before the court, there is an automatic cancellation of the bond. You follow me? I need not now declare that the bail is cancelled. Look at the judgment of this court way back in 1987. ಇಲ್ಲಿ ಯಾವ್ದು ನೀವು ನೋಡಿರಲ್ಲ, ನಿಧಾನಕ್ಕೆ ಹೋಗಿ ಲೈಬ್ರರಿನಲ್ಲಿ ನೋಡಿ. 87ನೇ ಇಸ್ವಿನಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. ನೇಸರ್ಗಿ ಸಾಹೇಬ್ರದೊಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ, ಗೊತ್ತಾಯ್ತಲ್ಲ. PA ಕುಲಕರ್ಣಿ ಅವ್ರದೊಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ. When once the non-bailable warrant is issued and surety notice issued, it is automatic cancellation of the bond. When once it is automatically cancelled, I need not again say under 439(2) that the bail is cancelled. This is a surplus age. Time kodtini 10 ದಿವಸನ 15 ದಿವಸನ, that's a different issue. Examine that situation and come back if you want at a later point of time. If the special court again grants him the bail, with that liberty you can close the matter. Why it should be kept pending? Seek instructions. In the meantime, ಮಧ್ಯಾಹ್ನ ಹೋಗಿ ತಗೊಂಡ್ ಬನ್ನಿ ಅವೆರಡನ್ನು. ನನ್ನ ಹತ್ರ ಇದೆ, ಎಲ್ಲೋ ಯಾರೋ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಅವ್ರನ್ನ ತಿರ್ಗಾ ಕೇಳ್ಬೇಕು, ಅದನ್ನ ಕಳಿಸ್ರಪ್ಪ ಅಂತ. At request of, on behalf of Madhukar Deshpande, time period released on 18/3, ಅವ್ರು ತಗೊಂಬನ್ನಿ, ಮೆಮೋನ ತರಬೇಕು, with a memo stating that this petition be dismissed if the need arises to revive the similar petition at a future point of time. ಎಲ್ಲ ಏನಾಗಿದೆ ಮೇಡಮ್, ಸಿ 21 ಅಂತ ತೋರಿಸುತ್ತೆ, 439 ಅಂತ ತೋರಿಸುತ್ತೆ, NJDG ಅಂತ ಇದೆ, ತಾವು ಗೊತ್ತಾ? ಅದು ನ್ಯಾಷನಲ್ ಜುಡಿಷಿಯಲ್ ಡಾಟಾ ಗ್ರಿಡ್ ಅಂತ. ಅಲ್ಲಿ ಮುಂದೆ ಅಲ್ಲಿ ಹಾಕಿದೀವಲ್ಲ ಕಬ್ಬನ್ ಫೋರ್ಕ್ ಅಲ್ಲಿ ಫೋಟೋ ಹಿಂಗ್ ತೋರಿಸುತ್ತಲ್ಲ ಎಷ್ಟೆಷ್ಟು ಕೇಸ್ ಇದೆ ಅಂತ, ಅದ್ರಲ್ಲಿ ತೋರಿಸುತ್ತೆ ದೇಶದಾದ್ಯಂತ ಎಷ್ಟು ಪ್ರಕರಣಗಳು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ. ಅದರಲ್ಲಿ ಫರ್ದರ್ ಡ್ರಿಲ್ ಡೌನ್ ಮಾಡಿದ್ರೆ ದೇಶದಾದ್ಯಂತ ವಿವಿಧ ಹೈಕೋರ್ಟ್ಗಳಲ್ಲಿ ಬೇಲ್ಗಾಗಿ ಇರುವ ಪ್ರಕರಣಗಳು ಎಷ್ಟು ಅಂತ. ಅಲ್ಲಿ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲ್ ಅಂತ ತೋರ್ಸಲ್ಲ, ಅದು ಸುಮ್ನೆ ಬೇಲ್ಗಾಗಿ ಇರೋ ಕೇಸ್ಗಳು ಎಷ್ಟು ಅಂತ ತೋರಿಸುತ್ತೆ. ಅದನ್ನ ತೋರಿಸಿದಾಗ 2021 ಪೆಂಡಿಂಗ್ ಇದೆ, ಅದು ಗೊತ್ತಾಯ್ತಲ್ಲ. 825 ಅಂದ್ರೆ ಇಟ್ ಮಸ್ಟ್ ಬಿ ಸಮ್ವೇರ್ ಇನ್ ಫೆಬ್ರವರಿ ಮಾರ್ಚ್, ವಾಟ್ ಎವರ್ ಇಟ್ ಈಸ್. ಸೆಪ್ಟೆಂಬರ್ ತನಕ ಬರೀ 825, ಅದೇ ಕೋವಿಡ್ಗೋಸ್ಕರ ಇತ್ತೇನದು. wait 10th September 2020 it has been filed. 10th September 2020 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕ್ಯೂರ್ ಆಗಿ ಅದು ನಂಬರ್ ಆಗಿದ್ದು 825 of 2021 ಅಂತ. So it is 1.5 years old. How does it reflect on the efficiency of this code? Please see. ಅರ್ಥ ಆಗತ್ತ ತಮ್ಗೆ? ಇದೆಲ್ಲ ಗೊತ್ತಿಲ್ಲದೆ ಇದ್ದವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ರಿಸರ್ಚ್ ಅಂತ ತಗೊಂಡ್ಬಿಟ್ಟು ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಬೇಲ್ ಅಪ್ಲಿಕೇಶನ್ ತೀರ್ಮಾನ ಆಗ್ಬೇಕಾದ್ರೆ 1.5 ವರ್ಷ ಆಗುತ್ತೆ ಅಂತ ಬರೀತಾರೆ. ಏನ್ ಮಾಡೋದಾಗ? Nobody knows what is happening here, and it goes in a different manner. But the public get an impression is something different. So you and I have got a onerous responsibility to see that whether it is allowed or rejected at the earliest point of time, irrespective of the other requirements that you have. ಯಾಕೋ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಅಡ್ರೆಸ್ ಸಿಕ್ತಿಲ್ಲ, ಅದೆಲ್ಲ ಆಮೇಲೆ. ಈ ಕಡೆಗೂ ಆ ಕಡೆಗೂ ಒಂದು ತೀರ್ಮಾನ ಆಗ್ಬೇಕು. ಕೇಸ್ ಮೆರಿಟ್ ಇದ್ದು ಕೊಡೋಂತ ಕೇಸ್ ಇದ್ರೆ ನಾವೇ ಕೊಡ್ತೀವಿ, ಇಲ್ಲದೆ ಹೋದ್ರೆ get a dismissal at the earliest. That's the point. There's no fun in keeping it pending, especially bail jurisdiction matters. It should be over. I am little bit touchy about this old matters of 2021. Bail jurisdiction should be very fast. I am there morning 10:30 to 5 o'clock, 4:45, 5 o'clock. Get listed as many cases. I have never rejected a single memo. ಎಲ್ಲ FR ಗಿಫಾರ್ ಇದ್ರೆ ಮಾತ್ರ ತಗೋಬೇಡಿ ಅಂತ ಹೇಳಿದ್ವಿ. ಇಲ್ಲದ್ರೆ 100 ಮೆಮೋಸ್ ಕೊಡಿ, 100 ಮೆಮೋಸ್ ತಗೋತೀನಿ, 100 ಕೇಸಸ್ ಲಿಸ್ಟ್ ಮಾಡೋಣ. We'll dispose of as much as possible. I'll complete the list, and without completing the list, I don't go home. So cooperate. ಇದು ಲೆಕ್ಕಕ್ಕೆ ಮಾತ್ರ ಇದೆ, ಇದರಲ್ಲಿ ಏನು ಉಪಯೋಗ ಆಗೋದಿಲ್ಲ, ನಿಮಗೂ ಆಗಲ್ಲ, ನನಗೂ ಆಗಲ್ಲ. ಸುಮ್ಮನೆ ಕೆಪ್ ಪೆಂಡಿಂಗ್. That should not be the spirit. If you want, if the need arises, you renew. With that liberty, I'll close the matter. Come out with that memo on the next date of hearing, 18th of March. Afreed, ಏನಾಯ್ತಮ್ಮ ಇದು? Release this matter on 14th of March, awaiting the service of notice to the petitioner. BT Venkatesh.
I am appearing for petitioner in this case, Your Honor. Your Honor, the petitioner is the complainant in this case, Your Honor. The prosecution case is that, Your Honor, the petitioner has lodged false complaint, and to help the accused number 1 to 5, he has lodged false complaint. That is the allegation against the petitioner, Your Lordship. The charge sheet has been filed in this case, Your Lordship. Investigation is completed and charge sheet has been filed, Your Lordship. I have furnished the copy of the charge sheet in the court hall, Your Lordship. In petition, page number 10, Your Lordship. Petitioner is the complainant in this case, Your Lordship.
Petitioner complainant ಅಂತ ಮೂರನೇ ಸತಿ ಹೇಳ್ತಾ ಇದ್ರಿ. Petitioner not complainant, is accused number 6.
Yes, Your Lordship.
ಮತ್ತೆ ಕಂಪ್ಲೇನೆಂಟ್ ಅಂತೀರಿ. ಸ್ವಲ್ಪ ನಾನು ಹೇಳ್ತೀನಿ, ಕ್ಲಾರಿಫೈ ಮಾಡೋಣ. ಮೊದಲಿಗೆ ನೀವೇ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು ಕ್ರಿಮಿನಲ್ ಲಾನ ತಂದಿದ್ದು, ನಂತರದಲ್ಲಿ ನೀವು ಕೂಡ ಕೃತ್ಯದಲ್ಲಿ ಭಾಗಿಯಾಗಿದ್ದೀರಿ ಅಂತ ಹೇಳಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆದ್ಮೇಲೆ ಅಕ್ಯೂಸ್ಡ್ ನಂಬರ್ 6 ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Yes, Your
Don't
Lordship.
repeat, keep on saying that I am the complainant, I am the complainant. No doubt, you put the criminal law into motion,
Yes,
but that
Lord.
doesn't mean that you are innocent.
Yes, Your Lordship.
ಮತ್ತೆ 302 ಇರೋದು.
Your Lordship, but 302 is not.
ನಮ್ಮೇಲೆ ತೂಫಾನ್ ಬರಬಾರ್ದು ಅಂತ ನೀವೇ ಹೋಗಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರಿ. ಪೊಲೀಸ್ನವರು ಎಲ್ಲ ನೋಡಿದ್ಮೇಲೆ ನೀವು ಕೂಡ ಕೊಲೆಯಲ್ಲಿ ಭಾಗಿಯಾಗಿದ್ದೀರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದೇ ಕೇಸ್ ಇದು 2021ರಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. ಸಾಕಷ್ಟು ಸರ್ತಿ ಸಮಯ ಕೇಳಿ ಕೊಟ್ಟು ನನ್ ಮುಂದೆ ಬಂದಿದೆ. ಹೋದ್ ಸರ್ತಿನೂ ನಾನು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಈಗ ಹೇಳಿ.
Yes, Your Lordship. The charge sheet copy was not furnished, Your Lordship. That's the reason, Your Lordship. Charge sheet copy has been not furnished, Your Lordship, last date of hearing.
ಈಗ ಇದೆಯಲ್ಲ, ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ.
Yes, Your Lordship.
ಮತ್ತೆ ಹೇಳಿ ಆರ್ಗ್ಯುಮೆಂಟ್. ನಿಮ್ ರೋಲ್ ಏನು ಅಕ್ಯೂಸ್ಡ್ ನಂಬರ್ 6?
Lordship, kindly come to page number 77 of the charge sheet, Your Lordship. I have
Yes, please.
Yes, Your Lordship.
Yes, please.
Lordship, the CW2 here in Your Lordship, and 164 statement is recorded. ದಿನಾಂಕ 29/7/2021 ಬೆಳಗಿನ ಜಾವ ಸಲ್ಮಾ ಶಿವಣ್ಣನವರಿಗೆ ಕರೆ ಮಾಡಿ ಸಿದ್ಧಾರ್ಥ್ ನಗರಕ್ಕೆ ಬರಲು ಹೇಳಿದರು. ಆಗ ನಾನು ಮತ್ತು ಶಿವಣ್ಣ ಅಲ್ಲಿಗೆ ಹೋದೆವು. ಅಲ್ಲಿ 5 ಜನ ಇದ್ದರು. ಅವರಲ್ಲಿ ಸಲ್ಮಾ ಎನ್ನುವವರು ಸೌಟಿನಲ್ಲಿ ದೋಸೆ ಸೌಟು ಮೊದಲೇ ಮೃತ ಹೊಂದಿದ ಅಲಿನಾ ಕೈಗೆ ಸುಡುತ್ತಿದ್ದರು. So at the time of this occurring incident, I was not present, Your Lordship. ಆಗ ಸಲ್ಮಾ ನನಗೆ ಅಲಿನಾಳನ್ನು ಯಾರೋ ಹೊಡೆದು ಹಾಕಿದ್ದಾಳೆ, ತಾನಿಗೆ ದೂರು ಕೊಡು ಎಂದು ಹೇಳಿದಳು. ಆಗ ನಾನು ನನಗೆ ಅದು ಆಗುವುದಿಲ್ಲ, ನಾನು ಸುಳ್ಳು ಹೇಳುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿದ್ದೆ. ಆಗ ಸಲ್ಮಾ ಶಿವಣ್ಣನವರಿಗೆ ದೂರು ಕೊಡಲು ಹೇಳಿದಳು. ಅದರಂತೆ ಶಿವಣ್ಣ ಠಾಣೆಗೆ ದೂರು ಕೊಟ್ಟಳು. ನಂತರ ರಾತ್ರಿ ಜಾವದಲ್ಲಿ ಸಿ.ವಿ. ರಾಮನ್ ಆಸ್ಪತ್ರೆಗೆ ಅಲ್ಲಿನವರನ್ನು ಕರೆದುಕೊಂಡು ಹೋದರು. ಜೊತೆಯಲ್ಲಿ ಏನು ಮಾಡುತ್ತಾರೆ ಎಂದು ನೋಡಲು ನಾನು ಸಹ ಹೋಗಿದ್ದೆ. ಸಿ.ವಿ. ರಾಮನ್ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಸಲ್ಮಾರವರಿಗೆ ಪರಿಚಯವಿದ್ದ ವೈದ್ಯರು ಇಲ್ಲದ ಕಾರಣ ಪುನಃ ಹೊಸಕೋಟೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದರು. ಅವರು ನನಗೆ ವಿಚಾರವನ್ನು ಯಾರಿಗೂ ಹೇಳಬಾರದು ಎಂದು ಬೆದರಿಕೆ ಹಾಕಿದರು. ನಂತರ ನಾನು ಮನೆಗೆ ಬಂದೆ. ನಂತರ ಶಿವಣ್ಣ ದಿನಾಂಕ 37/2021 ಸೋಲೆಬೆಲೆಗೆ ದೂರು ನೀಡಿರುತ್ತಾರೆ. ನಂತರ ಪೊಲೀಸರು ನನ್ನನ್ನು ಸಾಕ್ಷಿಯಾಗಿ ವಿಚಾರಿಸಿದಾಗ ಅವರ ಮುಂದೆ ನಡೆದ ಕೃತ್ಯವನ್ನು ಹೇಳಿರುತ್ತೇನೆ. ನನ್ನ ಅಲಿನ ಕೊಲೆಗೂ ಯಾವುದೇ ಸಂಬಂಧ ಇರುವುದಿಲ್ಲ. Your Lordship, here the petitioner is the innocent of the offense, Your Lordship.
How do you say that you are innocent from this? You are ನಿಮ್ಮ ಹೆಸರೇ ಇಲ್ವಲ್ಲ ಇಲ್ಲೆಲ್ಲನೂ.
Yes, Your Lordship. I am not there. My name is not there, Your Lordship. Kindly come to page number 69 of the charge sheet, Your Lordship. ಆರೋಪಿಯ ಹೇಳಿಕೆ, Your Lordship. Page number 70, Your Lordship, last paragraph, Your Lordship. ಮೃತ ಮಂಗಳಮುಖಿ ಅನಿನಳನ್ನು ಯಾರು ಕೊಲೆ ಮಾಡಿದ್ದಾರೆಂದು ಬಿಂಬಿಸಲು ಅಪರಿಚಿತ
ಯಾರೋ ಕೊಲೆ ಮಾಡಿರುತ್ತಾರೆಂದು ಬಿಂಬಿಸಲು
ಸ್ವಾಮಿ
to make it appear that she has been killed by somebody else ಅಂತ.
Yes, Your Lordship. ಯಾರೋ ಎಲ್ಲೂ ಕೊಲೆ ಮಾಡಿ ಸಾಯಿಸಿ ಮೃತ ದೇಹವನ್ನು ಹೊಸಕೋಟೆ ಜಂಗಮಕೋಟೆ ರಸ್ತೆ ತೆನೆಯೂರು ಬಳಿ ಕೆರೆ ಮೇಲಿನ ಚಿಕ್ಕದಾದ ದೇವಸ್ಥಾನ ಬಳಿ ರಸ್ತೆ ಅಂಚಿನಲ್ಲಿ ಬಿಸಾಡಿ ಹೋಗಿರುತ್ತಾರೆ. ಈ ವಿಚಾರಕ್ಕೆ ನಮಗೆ ಯಾರು ತಿಳಿಸಿಲ್ಲ. ನಾನು ಮತ್ತೆ ನಂದಿನಿ, ಕಾವ್ಯ, ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ಮೃತ ದೇಹವನ್ನು ಹೊಸಕೋಟೆ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಸಾಗಿಸಿರುತ್ತೇವೆ. ಅಪರಿಚಿತ ಮಂಗಳಮುಖಿಯನ್ನು ಯಾರೋ ಎಲ್ಲಿಯೂ ಕೊಲೆ ಮಾಡಿ ಸಾಯಿಸಿ ಮೃತ ದೇಹವನ್ನು ಹೊಸಕೋಟೆ ಜಂಗಮಕೋಟೆ ರಸ್ತೆ ತೆನೆಯೂರು ಬಳಿ ಕೆರೆ ಬಳಿಯಲ್ಲಿ ಸಾಕ್ಷಿ ನಾಶಪಡಿಸಿರುವ ಆರೋಪಿಗಳನ್ನು ಪತ್ತೆ ಮಾಡಿ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಲು ದಿನಾಂಕ 29/7/2021 ನಾನು ಸೂಲಿಬೆಲೆ ಠಾಣೆಗೆ ಸುಳ್ಳು ಕೊಟ್ಟಿರುತ್ತೇನೆ. So this is the allegation against the petitioner, your lordship.
No. Kindly read the entire statement. You will come to know. She has turned herself into a transgender. Later on, she was with the Salma. And on the date of incident on 28/7 at about 10:30, 10 o'clock, the altercation started.
Yes, sir.
So
Yes,
she
your lordship.
visited the Salma.
Yes, your lordship.
And then she inquired Salma, who is the head for them,
Yes, your lordship.
both for Alina and this lady and others.
Yes,
She
your
is the
lordship.
head. So she inquired what happened.
Yes, your
At
lordship.
that juncture, this lady was consuming some liquor, the
Yes,
deceased.
your lordship.
Then she asked, ಏನಾಯ್ತು ಅಂತ ಕೇಳ್ತಾರೆ. ಆಗ that Alina, the deceased,
Yes, your lordship.
abuses the entire group of people there
Yes, your lordship.
in a filthy language, in a high voice. At
Yes,
that
sir.
juncture, she has assaulted, slapped Alina.
That is A1, your lordship.
No, you,
No, your lordship.
you.
No, your lordship. I am
ಓದ್ರಿ. ನೋ ಅಂತಲ್ಲ, ಅಲ್ಲಿ ಓದಿ ಅದನ್ನ. ಏನೋ ಸುಮ್ನೆ ಇಲ್ಲೇ ಇವ್ರದನ್ನೇ ಕಾಮೆಂಟ್ರಿ ಹೇಳ್ತಾರೆ. 70ನೇ ಪೇಜ್ ಓದಿ. ನೀವೆಲ್ಲ ಕಚಡ ಇಂಥವ್ರು ಎಂದು ಏರು ಧ್ವನಿಯಲ್ಲಿ ಬೈಯುತ್ತಿದ್ದರು, ಬೈಯೋದನ್ನು ಮಾಡುತ್ತಿದ್ದಳು. ಅಲ್ಲಿಂದ ಓದಿ. Page number 70.
Page number
first
69,
line.
paragraph.
Page number
Yes, your
70.
lordship.
ನೀವೆಲ್ಲ
Yes,
ಕಚಡ.
your lordship. ನೀವೆಲ್ಲ Yes, your lordship. Reading, your lordship. ನೀವೆಲ್ಲ ಕಚಡ ಬೇವರ್ಸಿ ಮುಂಡೆಗಳು ಎಂದು ಏರು ಧ್ವನಿಯಲ್ಲಿ ಬೈಯುವುದನ್ನು ಮಾಡುತ್ತಿದ್ದಳು. ನಾನು ಏಕೆ ಈ ರೀತಿ ನಮ್ಮನ್ನು ಬೈಯುತ್ತೀಯಾ ಎಂದು ಅಲಿನಾಳನ್ನು ಕಪಾಳಕ್ಕೆ ಒಂದು ಏಟು ಹೊಡೆದೆನು.
ಅಲಿನಾಳನ್ನು ಅಲ್ಲ,
ಅವಳು
ಅಲಿನಾಳ ಕಪಾಳಕ್ಕೆ ಒಂದು ಏಟು ಹೊಡೆದನು. This is
ಏಟು
the
ಹೊಡೆದೆನು.
statement of you.
But
This is your statement, and you are not Shivanna. You are Malavika alias Shivanya, not Shivanna. And now
Yes,
you
sir.
see this. Now you see the
Yes, sir.
statement there. You read the statement, no? ನಾನು ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಅಂತ
Yes,
ಓದಿದ್ರಲ್ಲ.
yes, your lordship.
ಮೌನ ಅಲಿಯಾಸ್ ಅನಿತಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 77 ಅಲ್ಲಿ.
Yes, your lordship.
ಅದ್ರಲ್ಲಿ ಓದಿ, ನೀವು ಇದ್ದೀರಿ ಅಲ್ಲಿ ಶಿವಣ್ಯ ಅಂತ. ಇದಿರೋ ಇಲ್ಲೋ?
Further ಮುಂದೆ ಓದ್ತೇನೆ ಸ್ವಾಮಿ.
ಫಸ್ಟ್
ಮುಂದೆ
ಇದನ್ನ
ಮುಂದೆ
ಇದನ್ನ ಹೇಳಿ,
ಓದ್ತೀನಿ
ಇದ್ರೋ
ಸ್ವಾಮಿ,
ಇಲ್ವಾ
ಮುಂದೆ
ಅಂತ ಅನ್ನೋದನ್ನ ಫರ್ದರ್ ಓದುವಂತೀರಿ. ಇವಾಗ ಇದ್ರೋ ಇಲ್ವಾ ಅದನ್ನ ಹೇಳಿ. Are you present
ಹಾ.
as per the statement
Yes,
of
your lordship.
Mauna, and you wanted to say
Yes,
that it
yes,
is Shivanna? It is not Shivanna.
Yes, your lordship.
It is Shivanya, and Shivanya is none other than the another name of alias name of you. Malavika alias Shivanya is you.
Yes, your lordship.
ಹೇಳ್ತಾರೆ ಸುಮ್ನೆ ಏನೋ ಹೇಳ್ತಾರೆ, ಇರ್ಲಿಲ್ಲ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ. ಓದಲ್ಲ ಪೇಪರ್ನ. You have read it as Shivanna. It is not Shivanna. It is Shivanya. You. ಬರ್ಕೊಮ್ಮ. ಶ್ರೀ, ತಮ್ಮ ಹೆಸರೇನು? ನವೀನ್ ಜೆ. ನವೀನ್ ಜೆ, JAY ಜೆ ಆಯ್ತಮ್ಮ. ಆಮೇಲೆ ಜೆ ಅಂತ ಬರ್ಕೊಂಬೋಬೇಡ ನೀನು. ನವೀನ್ ಜೆ, ಜೈ. ಓಕೆ, ಗೊತ್ತಾಯ್ತಲ್ಲ? ನವೀನ್ ಜೈ. On behalf of Sri PT Venkatesh. PT Venkatesh. Yes. And learned HCGP. Present petition is filed under section. ನಾವು ಎಲ್ಲ ಪೇಪರ್ನ ಚೆನ್ನಾಗಿ ಓದ್ಬೇಕು. You got misled the entire thing because you read it as Shivanna, a male person. It is not Shivanna. It is Malavika alias Shivanya. Shivanya. Okay. Are you a Keralite?
Okay, lordship. No, your lordship.
Then why were you not able to read Shivanya as Shivanna?
Some difficulty, Your Lordship.
No, I can. Accent is like that. Therefore, I asked you, are you a Keralite for any reason? Okay, no
No, Your
problem. ಶಿವಣ್ಣ ಅಂತಂದ್ರೆ ನಾಗೆ ನಾವತ್ತು ಕೊಡ್ಬೇಕು.
Okay.
ಗೊತ್ತಾಯ್ತಲ್ಲ, ನಾಗೆ ಕೆಳಗಡೆ ಇನ್ನೊಂದು ನಾವತ್ತು ಕೊಡ್ಬೇಕು. ಅವಾಗ ಶಿವಣ್ಣ ಆಗುತ್ತದು. That becomes a male. ಶಿವ ಪ್ಲಸ್ ಅಣ್ಣ ಶಿವಣ್ಣ.
Yes, Your Lordship.
Okay. Now it is not Shivanna. Shivanya.
Shivanya.
Shivanya. Malavika alias Shivanya. These transgenders will have all these alias names very much. You see the statement that lady has recorded. Mauni alias Anita.
Yes, Your Lordship.
Okay. So even the deceased, she had the nickname. Alina. She had the nickname. Okay. ಬಿಡಿ ಎಲ್ಲ ಅವ್ರವ್ರೇ ಕಿತ್ತಾಡ್ಕೊಂಡು ಹೊಡ್ಕೊಂಡು ಸಾಯಿಸ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ಆಮೇಲೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ ಅಂತ ಅಚ್ಚೆ ಇತ್ತು ಯಾರು ಅಂತ ಗೊತ್ತಾಗ್ಬಿಡ್ತಾರೆ ಅಂತ. ಅದನ್ನ ಅಳಿಸೋದಕ್ಕೆ ದೇ ಯೂಸ್ಡ್ ದಿ ಮೊಚ್ಚಕಾಯಿ ಇರುತ್ತಲ್ಲ, ದೋಸೆಕಾಯಿ, ಅದ್ ತಕೊಂಡು ಸುಟ್ಬಿಟ್ಟು ಎಲ್ಲ ಕೆರೆಸ್ತಾ ಇದ್ದಾರೆ ಡೆಡ್ ಬಾಡಿಗೆ. ಸೊ ಇಟ್ ಅಮೌಂಟ್ ಟು 201. 201. ಓಕೆ, ಹೇಳಿ. Present petitioner, accused number 6. Present petition is filed under section 439. The following prayer. First, petitioner is made as accused number, is arraigned as accused number 6 in the charge sheet. The brief facts of the case are as under. The complaint came to the Lord. The complaint Lord initially by the petitioner herein, who has a alias name as Shivanya, Shivanya. Nama Shivanya. The complaint is contended that on 29/7/2021, 28/7/2021 at about 3:30 a.m. three unknown persons came and informed them that a transgender has been done to death and her body is found near a small temple on Jangamakote Road, here between Teneyuru and Bendiganahalli villages. They visited there and found that it is Alina. Based on the said complaint, Alina, another transgender. Based on the said complaint, police registered the case. Paskote police registered the case in crime number 283 of 2021 for the offence under section 302, 201, section 34 IPC. Thereafter, they investigated the matter and on collection of the material on record, the present petitioner has been arraigned as accused number 6 while filing the charge sheet. The attempt made by the petitioner to seek grant of bail in series number 1359 of 2021 is turned down by the learned additional district and session judge, Petro district, by order dated 9 September 2021. Thereafter, petitioner is before this court. Land counsel for the petitioner vehemently contended that petitioner is the complainant who set the criminal law into motion and police by improper investigation, arraigned the present petitioner as accused number 6. He also contended that the petitioner is totally innocent of the offences against the petitioner, and in order to substantiate the same, he has referred to the statement given by one of the witnesses under section 164 CRPC before the magistrate of This court perused the statement recorded by the magistrate of Mauna alias Anita, another transgender. First, in the said statement, name of Shivanya is found and not the Malavika, and therefore, the petitioner submits that she was not present at the time of incident and she has been falsely implicated in the incident. First, however, it is to be noted that the alias name of the petitioner is another than Malavika. In other words, Malavika and Shivanya are one and the same person. First, therefore, first, next para. His name is not substantiated. He has referred to the statement of Mauna alias Anita and sought for grant of bail. Per contra, and HCGP opposes the bail petition, contending that material collected by the investigation agency clearly establishes the role played by the present petitioner also, and in that direction, he has pointed out the voluntary statement of the accused petitioner before the investigation agency. First, next para. This court perused the material on record meticulously in of the rival contents. The first place, there is no dispute that the petitioner alias name is Shivanya. She is the person who set the criminal law into motion. First, however, after thorough investigation and the police were also able, the investigation agency record the statement of the voluntary statement of the accused petitioner after arrest. First, no doubt at this stage, this court cannot place much reliance on the voluntary statement of the accused. First, nevertheless, the role played by the present petitioner in the homicide and death of Alia cannot be lost sight of by this court. First, it is settled principles of law that this court at the stage of deciding the bail petition, cannot hold a mini trial so as to find out the merits and demerits of the case, as the same applies the case of the parties to the trial. First, the materials on record collected by the investigation agency prima facie establishes the role played by the present petitioner in the incident. The postmortem report and other materials on record prima facie establishes that Alina died a homicidal death. The slap made by the petitioner is also from the record made by the petitioner. Slap, according to the prosecution, this present petitioner has slapped the Alina, so and so, and she fell down. Thereafter, she was done to death. First, this court is taking note of these as this prima facie on record. This court is of the considered opinion that no grounds are made out by the petitioner to admit the petitioner on bail by resorting to the special powers vested in this court section 439 CRPC. Next para. The statement of the Mauna alias Anita, no doubt does not mention the name of the petitioner as Malavika. However, the statement clearly mentions that it is Shivanya who was present. First, it is pertinent to note that Shivanya and Malavika are one and the same persons. Accordingly, this court is that the next, accordingly, ಇದನ್ನ ಈಗ ತಗೊಂಡು ಮೇಲ್ ಆಮೇಲೆ ನೋ ಗ್ರೌಂಡ್ಸ್ ಆರ್ ಮೇಡ್ ಹೆನ್ಸ್ ಫಾಲೋಯಿಂಗ್ ಆರ್ಡರ್ ಕ್ವೆಶ್ಚನ್ ಡಿಸ್ಕಷನ್. ಇದೆಲ್ಲ ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ, 1:30 ಆಗಿದೆಯಲ್ಲ. ಮಧ್ಯಾಹ್ನ ಅದ್ ಮಾಡ್ಬೇಕದು SPPದು ಬರ್ತಾರಲ್ಲ. Those 3 matters are passed over and few other passed over matters are there. ಅದು ಮುಗಿಸ್ಬಿಟ್ಟು ಬಿಡೋಣ. Kalburgi matter is a mana. SPP can come around 2:45, 3 o'clock, around that time. Because ಬೇರೆ ಏನಾರು ಇದ್ರೆ ಅದು ಮುಗಿಸ್ಕೊಂಡು ಬರ್ಲಿ. Past hour matters ಮತ್ತೆ ಕಲಬುರ್ಗಿ ಮ್ಯಾಟರ್ ಮುಗಿಯೋಷ್ಟೊತ್ತಿಗೆ could be roughly around 3 o'clock.
Hello, court officer. Court officer.
ಸರ್ ಏನ್ ಹೇಳಿ?
Serial number 18 ಏನಾಗಿದೆ?
18.
ಹಾ 18. 22.
ಯಾವ್ದು
ಅಬ್ದುಲ್ ರಜಾಕ್.
serial number?
22 ಅಬ್ದುಲ್ ರಜಾಕ್.
ಅದು 18/3 ಗೆ ಡೇಟ್ ಇದೆ.
22 ಅಲ್ಲ ಅಬ್ದುಲ್ ರಜಾಕ್ ಅಲ್ಲ?
ಹಾ
ಓಕೆ ಓಕೆ ಓಕೆ.
ಓಕೆ ಸರ್.
Password 821.
Kalburgi matter.
Beg to prefer appellate notes. My lords, I am for yes, lords. My lords,
Why this matter before me? It should go before roster bench.
it was maybe part heard ಅಂತ ಅದಕ್ಕೇನೆ ಬಂದ್ರು ಸ್ವಾಮಿ.
ಈಗೆಲ್ಲ ಆಗುತ್ತೆ ಇದನ್ನ ಪಾರ್ಟ್ ಔಟ್ ಮಾಡ್ಕೊಂಡು.
ಇಲ್ಲ our objection they had to file, we have already filed our written arguments, not let the other side file their objection.
No, let them do it. ಬರ್ಕೊಳ್ಳಿ. ಬರ್ಲಿ. Let the roster bench decide. It's a 13(1)(e) matter ಅಲ್ಲ ಇದು.
Yes, Lord. Yes, Lord. Considerable amount of time matter was there. Yes, Lord.
ಅದು ಎಲ್ಲ ಬೆಂಗಳೂರಿಂದೆಲ್ಲ ಮಾಡೋದು ಕಷ್ಟ ಆಗುತ್ತೆ ಲಗಳಿ ಅವರೇ. ನೋಡೋಣ ಬಿಡಿ. If the time permits, let us see. God willing.
God. ಅದು ತಾವೇ ಹೇಗಂದ್ರೆ ಆಯ್ತು.
No, it's always pleasure. It's not as if that I am trying to avoid you people and all.
No, certainly not.
But when once you missed the bus narrowly, what to do? ಅವರು ಅದನ್ನ ಬರವಣಿಗೆನಲ್ಲಿ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಮಲ್ಲಾಪುರ ಅವರು. ನೀವು ಒಂದು ಸ್ಟೆಪ್ ಕಂಪೈಲೇಷನ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ರಿ, ಅವ್ರು ಕೊಡ್ತಾರೆ ನೋಡ್ಲಿ, ಮಲ್ಲಾಪುರ ಮಾಡ್ಲಿ.
I'll file the statement, my lords, within 2 days. Thereafter, your lordship may decide.
No. ನಾನ್ ಮುಂದೆ ಬೇಡ ಮಲ್ಲಾಪುರ್. It may not be proper. Sitting in Bangalore, taking Kalburgi bench and heavy matter. Why unnecessarily calling for all those things? Let it go before the roster bench. Barkoli heard. Say R.S. Lagli and say Subhash Mallapur. First, this matter was heard by this court sitting at Kalburgi bench having the roster of single judge criminal matters. First, no doubt by order dated on so, this court has noted that the matter was heard in part. First, however, having regard to the magnitude of the matter, sitting at Bangalore bench, this matter cannot be disposed of on merits. First, accordingly, the matter requests regular roster bench at Kalburgi. In the meantime, Shri Subhash Mallapur seeks 2 days time to file compilation statement, reply to the statement filed on behalf of the appellant. Time granted. Release this matter before the roster bench. Yavat beko?
ಇಲ್ಲ ಸ್ವಾಮಿ, we'll only move lots. Let them file and
2 days time is granted. Office to release this matter before the roster bench. Andru ಏನು ತೊಂದ್ರೆ ಇಲ್ವಲ್ಲ? Now that some arrangement has been made.
Yes, my lords.
So things can move fast. Let us.
Yes, my lords.
yes, lords. Grateful, my lords. Grateful.
Yes, please. Yes.
Number 10. Warrant, sorry.
Enna. Of subjections not complied even after granting sufficient time. In the interest of justice, 2 days time is granted. Released on 15/3. Finally.
Number 36. Kumari Gowda.
Kodi. The present bail petition came to be filed on 12th November 2021. POCSO. Sufficient time is spent in curing the subjections. Later on 9th February, matter was listed before the court and time was granted to file objections. POCSO. Further on 17th February, again time was granted by this court, noting the noting that there is no representation on behalf of the petitioner. POCSO. Thereafter, again time was granted at request of the counsel for petitioner. POCSO. Accused is in custody. Case called thrice. There is no representation on behalf of the petitioner. In the interest of justice, release this matter on 18th. Finally.
Number 37. Rangnath Reddy.
Lord, appeal to the appellant, sorry, petitioner on behalf of Sri Rangnath Reddy, my lord.
Yes, please.
Lord, offences under section 4 and 6 of POCSO Act ಇದೆ. Liberty may be reserved.
Yes. Memo filed. Memo reads as under. In view of the memo, petition is dismissed as withdrawn and with liberty as prayed for.
Number 38. Harish Kumar SC.
The present bail petition came to be filed on 24th of November 2021. Accused petitioner is in custody. POCSO. Sufficient time is spent in curing the subjections. POCSO. Thereafter, sufficient time in bada. The matter was listed before the court on 1/12, wherein High Court Government Period took notice and matter was adjourned to 1st February. On 1st February, time prayed by HCGP as well as counsel for petitioner. Again on 9th February, time prayed by HCGP. On 18th February, matter could not be reached on account of paucity of time. On 25th February, there was no representation on behalf of the petitioner. Taking note of these aspects of the matter, list this matter finally on 18th February for addressing the arguments on bail petition. 18th March.
Number 14.
Memo filed. Memo application filed. Application. Approve the application. The proposed amendment is formal in nature, hence permitted. And hence application is allowed and counsel permitted to carry out the amendment. Release this matter for consideration on 18th of March. 18th of March. In the meantime, counsel permitted to serve the copy of the petition on the counsel who represents the Narcotic Control Bureau
Number 41, Lakshmi Narayana Sritti.
And file amended petition and Parity. And file amended petition. Lakshmi Narayana Shetty. Put case called twice. None present on behalf of the petitioner. Case called thrice. None petitioner on behalf of the petitioner. Poster. The present bail petition came to be filed on 15th December 2021. Accused is in custody. Petitioner on behalf of the petitioner. Time was granted twice. Poster. Taking note of the above aspects, release this matter on 18th March finally.
Number 42, Vikram.
I appear for the petitioner's counsel, my lord. Offense under POCSO originally, a complaint came to be registered on 29/9/2021, a missing complaint.
Yes, please.
The age of the victim is 17 years, 9 months. She has, my lord, in her 164 statement admitted that the victim and accused were in love with each other. The parents were against their marriage. Hence, my lord, they eloped. And hence the FIR has been registered. The petitioner is in custody since 2010-2021.
Yes. Yes.
Charge sheet has been filed, my lord. May I invite your lordship's attention to the 164 statement.
Yes, please.
Before that, my lord, with your lordship's kind permission, the FIR is at page 17 of the petition papers.
Yes, please.
And the complaint, my lord, that is the written information, is at page 22. That is the typed copy, dated 29/9/2021. This is lodged by the mother of the victim, saying that on from 25/9/2021, the victim is missing. She is around 17 years of age, and the accused would have taken her. Accused would have kidnapped her. Based on this, my lord, the FIR came to be registered, and thereafter the girl is found, and then on 2010 the accused is arrested. Now the 164 statement, my lord, is in the compilation, that is the charge sheet papers filed yesterday.
Yes, please.
May I invite your lordship's attention to page 70.
Yes, please.
This is the 164 statement. May I read, my lord?
Yes.
Harshita H, 17 varsha. Please, I will skip that.
21, para 2.
Please, Sadri Shashikumaರ್ ನನ್ನನ್ನು ಅದೇ ದಿನ ಸಂಜೆ 5 ಗಂಟೆಗೆ ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಚನ್ನಪಟ್ಟಣದವರ ಸ್ನೇಹಿತರ ಮನೆಗೆ ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಹೋದರು. ಒಂದು ದಿನ ಅಲ್ಲೇ ಉಳಿದಿದ್ದು ಮಾರನೇ ದಿನ ಶಶಿಕುಮಾರ್ ಸ್ನೇಹಿತ ಪತ್ನಿಯ ಮನೆಗೆ, ಅಂದರೆ ಬೆಂಗಳೂರಿನ ಸೋ ಬಂದೆವು. ನಮ್ಮ ತಂದೆ ತಾಯಿ ನಮಗೆ ಫೋನ್ ಮಾಡಿ ಇಬ್ಬರಿಗೂ ಮದುವೆ ಮಾಡುವುದಾಗಿ ಒಪ್ಪಿ ಊರಿಗೆ ಬರಲು ಕರೆದರು. ನನ್ನನ್ನು ಅಲ್ಲೇ ಬಿಟ್ಟು ಸೋಮವಾರ ಶಶಿಕುಮಾರ್ ಮದುವೆ ಮಾತುಕತೆ ಮಾಡಲು ಊರಿಗೆ ಹೋದರು. ಮದುವೆ
71 ಪ್ಯಾರಾದಲ್ಲಿ ಮೇಲ್ಗಡೆಯಿಂದ 3ನೇ ಲೈನು. ಹೀಗೆ ಸುಮಾರು 3 ತಿಂಗಳ ಹಿಂದೆ
ಶಶಿಕುಮಾರ್ ನಮ್ಮ ಮನೆಗೆ ಬಂದು ಹೋಗುತ್ತಿದ್ದಾಗ ನನ್ನ ಹಾಗೂ ಶಶಿಕುಮಾರ್ ನಡುವೆ ದೈಹಿಕ ಸಂಪರ್ಕ ಆಗಿದ್ದು ನಾನೀಗ 3 ತಿಂಗಳ ಗರ್ಭಿಣಿ. ಪ್ಲೀಸ್.
That's all.
She is aged 17 years.
What can be done? Look at 375 6th.
Please, my lord.
Section 375 6th. Kindly read it. IPC.
Please, my lord, they have in fact got married because what
Kindly read. What Murthy?
that I am aware, my lord. I am not disputing that.
Kindly read. Kindly read.
Please, please.
$375 sixthly.
With or without her consent when she is under 18 years of age. Please,
That's all. That's all. Now, if you, I think you are aware of the judgment of the Honorable Apex Court in independent thought. Judgment by Honorable Apex Court in independent thought versus union. If you have with you, well and good. 2017, 10 SEC, page 800. Independent thought versus Union of India.
Please, my lord.
Their lordships have said similar case. They're also wife. Under the age, it attracts POCSO 6. What can be done? Consent is immaterial.
Please. And now she is of 18, she is 18 years of age.
There also, sir, she was the wife.
Please.
Having a sexual intercourse with the wife who is under the age of 18 is what is not contemplated under the POCSO Act, and therefore POCSO gets attracted, and such people must be brought to books under section 6. In complementary with the section 4 and 6, 3 and 5 of the POCSO Act, the amendment is also taken out, carried out in favor in section 60 of 375, which was earlier 16 years. So the set of the decisions of this court as well as the various other honorable high courts and honorable Supreme Court, which were proceeding on the premises that there was the age of discretion above 16 years, will have no significance when we apply the POCSO Act.
Please.
This is my understanding.
Please,
so,
Lord.
a need has arisen now. Probably in a given case, as a test case, people should approach and knock the doors of the Supreme Court to have a real relook into independent thought, and then Union of India may be directed to consider such of the cases where the love affair and marriage, etc., are there, should stand on a different footing. Unless such a thing comes out, we are bound by what the Honorable Supreme Court says in such circumstances, and that there is no other go. See, two things would arise. One is age of marriage. There are some differences with regard to the Muslim marriage. With Hindus, there is no problem. Earlier, if you go by the Hindu Marriage Act, the eligibility criteria for a Hindu girl to get married was 15 years, 1-5. But there was an embargo not to have the physical relationships till 16 years. It would not be considered as a void ab initio. The marriage would not be considered void ab initio.
Please.
It was at the instance of the wife that it's a viable marriage at the instance of the wife. So 16 was the age. Then this Child Marriage Act came, the age is now fixed 18 and 21.
Please, my lord.
Therefore, when the Supreme Court had to apply all these aspects of the matter, they said that Child Marriage Act is a special enactment and it will prevail over the other provisions of the Hindu Marriage Act. But that did not happen in respect of the Muslim community. There, according to the Quran, the eligibility criteria for a girl to get married is attaining the age of puberty. Now, Muslim girls are attaining the age of puberty at 12, 13. So the issue came up. Now there is a problem. In that event of the matter, Supreme Court had an occasion to deal with all these aspects of the matter in the independent thought. You can go through all those things. Their lordships are of the opinion, irrespective of the personal laws. When the POCSO Act has been enacted, the POCSO Act the provisions of the POCSO Act will prevail over all other aspects of the matter, including the personal laws belonging to Christians, the Mohammedans, and the Hindus.
Please.
So therefore, when POCSO Act should prevail, all other things that are available defenses would get into insignificance.
Please.
Therefore, a need has arisen. Take this case itself to the Honorable Apex Court, if your client is willing.
Maybe some other case, my lord. This case is
All
an
right.
this-
I am not saying any of those things. At least 12 of the cases I have decided in this roster itself about this aspect of the matter earlier also.
Please.
This is the consistent view. See, the whole idea is to see that definition of child in the POCSO Act is up to 18 years.
Please.
Even if it is 17 years, 11 months, 30 days, you can't help it.
Please.
So people will have to. I had an occasion to deal with similar situation when I was the district judge at Haveri. It was a very peculiar case. Boy is 17 years, 11 months or so. Girl is 17 years, some 9 months or so. They have a child of 6 months. What to do?
Please.
What to do?
And here, my lord, in this case.
And you see, the girl, there will be considered as child. Boy is also considered as child. But since he is the aggressor party, even as per the JJB Act, if he has committed an act of forcible sexual intercourse, he should be tried as an adult with the amendment.
Please. But here the boy, my lord, the accused is 31.
It makes no difference for
Yes.
me. I'm only trying to say
Please.
that the victim girl, if she is under 18, because of the words and the object of POCSO Act, I'm afraid that this court can exercise any discretion under 439, following that set of judgments where age of discretion was to be taken into account. This is the enactment. We have accepted it.
Please, my lord. Henceforth, the boys will have to be careful.
Scope of 439 is narrowed down. Further, you see, a person charged with 302 IPC will have a label of innocent on his forehead. See section 29 of the POCSO Act. Kindly read it. Kindly read it.
Presumption as to certain offences. Where a person is prosecuted for committing or abetting or attempting to commit any offence under section 3, 5, 7 and 9 of this act, the special court shall presume that such person has committed or abetted.
Why are you going so speed?
I'm sorry.
It's not Konkan Express. Shall presume is the word.
Please.
And I need not tell Murthy as to what is the difference between may presume and shall presume. Is it not?
Please,
so there is no option left over for this court. The wordings are so strong. And that is for the set of offences only. When the punishment sections are told there, 5, 7 and 9.
Yes, 3, 5, 7 and 9.
Sections are 3, 4 and 8. If you see this section 29.
Yes.
They have mentioned a category of offences.
Yes, 3, 5, 7 and 9.
Correct. Now what will happen? 3 is the punishment, 3 is the offence section, 4 is the punishment, 5, 6, 8 and 9. These are the situations. So they have given for set of offences, a presumption is made under the act itself. That court shall presume, you can now continue. Shall presume what?
Shall presume that such person has committed or abetted or attempted to commit the offence, as the case may be, unless the contrary is proved.
Now you see what the label says. You are guilty is the label, not the you are innocent. You will have to remove this label, no?
Please, my lord.
Placing something on record, and from the other material, including the 164, the material that is available is, it's a case of a law affair. Independent thought says, no, you can't, that could not be a defense at all. And we are at the bail stage. What is it that I should do?
My lord, in fact, if I may persuade your lordships, as far as bail is...
Then also on 30. 30 you can see it's a twin presumption. It's a twin presumption.
Please. Please, my lord,
It's
but
a twin
as far as,
presumption which is complementary to section 29.
please,
Mental condition is that you committed an offense under 29. I mean, in the POCSO Act, mental condition to be looked into. Just because she is my wife, we had an affair, therefore I had the physical relationship would not be of much relevance when considering the aspect of the matter. Again, you can see 30. For all offenses under the POCSO Act, 29 is restricted to set of offenses.
please,
So far as 30 is concerned, the mens rea, actus reus, the sine qua non for the completing the offense. One aspect is straight away made us presume to be present, that is mens rea. Actus reus is there because she is 3 months pregnant as on the date of giving the state.
please. In fact, my lord, if he is granted bail, then because they have not, my instructions are she has not aborted the child.
What to do? What to do? See, those are all the considerations maybe in the trial. There
But-
again, Honorable Supreme Court has cautioned many times, the question of marriage, etc., will not take away, efface the criminality.
Please, my lord, but
I leave it at that because this is not the stage for this court to express any opinion on mental.
please,
You have two options. One is you withdraw this petition and then pursue with the trial and then take whatever the defenses. Otherwise, I may have to observe few things while deciding the bail
please,
itself.
my lord,
It's up to you. Talk to your briefing counsel. I'll release it on Monday.
please. I was about to make that request.
Is also very much here. This is the situation. In fact, last occasion, I adjourned one matter of Mr. Tigri. This morning memo was there.
Please, my lord, I will.
That is the only solace that this court can give you at this stage.
I will get instructions, my lord. And
After hearing for some time, learned senior counsel Shri Murthy Nayak, representing the counsel for petitioner, seeks time to have some more instructions from the petitioner. Release this matter on Monday.
grateful.
ಕೊಡಿ 43 ಅದೇ ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಮೆಮೋ ಫಾರ್ ವಿಡ್ರಾಯಲ್ ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ರೀ? ಮೆಮೋ ಫಾರ್ ವಿಡ್ರಾಯಲ್ ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ರೀ? ಎಲ್ಲಿದೆ ಮೆಮೋ? ಅದೇನ್ ಬರ್ದಿದ್ದಾರೆ ನೋಡಿ. ಅಬ್ಜೆಕ್ಷನ್ ಏನ್ ನೋಡಿ. Memo for withdrawal is filed on 4/1/2020. Is not signed by learned counsel for the petitioner. Therefore, office has raised objection on the memo for withdrawal. First, counsel for petitioner absent. First, issue a court notice to the petitioner through the jail superintendent and release this matter on 28th of March. ಅವ್ರಿಗೆ ಗೊತ್ತೇ ಇಲ್ವೋ? ಅವ್ರ ಸೈನ್ ಮಾಕಾಯ್ತು, ನಾನು ಯಾಕೆ ಬರ್ಲಿ ಅಂತ ಅವ್ರು ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ, ಸೈನ್ ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ. ಕೊಡಿ. Case called twice, none present on behalf of the petitioner. In fact, this court adjourned the matter on 8th of March, noting the non-appearance, noting no representation on behalf of the petitioner. Office objects the matter, the present bail application came to be filed on 3rd January 2022. Despite granting sufficient time, the office objections are not complete. The petition is under section 438 of the Code of Criminal Procedure. First, since the office objections are not complete till today, comma, the apprehension, if any, apprehension of the arrest, if any, would have diluted by now. Accordingly, the petition is dismissed for non-prosecution. First, our dismissal of the present petition would not come in the way of petitioner filing successive bail application if the apprehension still exists.
So the court is it, it is
40, case called twice, none present on behalf of the petitioner. Shiva Prasad, the matter was adjourned from previous date at the request of the counsel for petitioner. Accused is in custody. Taking note of the same, comma, release this matter finally on 18/3. ಎರಡು ಒಂದನೇ. All right. ಹೇಳಿ. ನೀವ್ಯಾರು? ಪಂಚನಾಮೆ ಕಾಲಕ್ಕೆ ರೈಡ್ ಆದಾಗ ಅವರಿಂದ ತಪ್ಪಿಸಿಕೊಂಡು ಓಡಿ ಹೋದವರು. ನಿಮ್ಮ ಮೇಲೆ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಏನಿದೆ? ನೀವ್ ಹೇಳ್ಬೇಕು. ಮತ್ತಿಲ್ಲ ಅಂತ ಹೆಂಗ್ ಬರೀತಾರ ಅವರು? Why you have suppressed all those materials in your list?
My instruction is that I have no basis.
20 cases are there. ಬರ್ಕೊಳ್ಳಿ, ಮೆಮೊ ಹಾಕಿ ಕೇಸ್ ನಂಬರ್ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಬಿಟ್ಟು ಹಾಕ್ತೀರಾ ಇವತ್ತೇನೆ? ಅದನ್ನ ಬರ್ದು ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ. Nothing doing. If you willfully, knowing fully well that you are party there and then say that your instructions are there, I am a law-abiding citizen, no cases are pending. That itself is suppression of material facts, which would disentitle you from obtaining an order. Nothing doing. 20 ಕೇಸ್ ಇಟ್ಕೊಂಡ ನಂತರ ಏನು ಇಲ್ಲ ಅಂತ ಯಾವ ಬಾಯಲ್ಲಿ ಹೇಳ್ತೀರಿ? Keep your party present on Monday. We will see whether he has instructed you or not. Keep your party present. ಕರೆದು ಇಲ್ಲಿಂದಾನೆ ಕೊಟ್ಟು ಕಳಿಸ್ತೀವಿ. ಇಲ್ಲಿಂದಾನೆ ಕರೆದು 50 ಕರೆದು ತಗೊಂಡೋಗಿ ಅಂತ ಹೇಳ್ಬೇಕಾಗತ್ತೆ. 20 ಕೇಸಲ್ಲಿ ಇದ್ಕೊಂಡು ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ, ನಾನು ಬಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಬೇರೆ ಪ್ರಶ್ನೆ. 20 ಕೇಸು ಸ್ವಾಮಿ FIR ಇದೆ, ಬೇಕಂತಕ್ಕೆ ನನ್ನ ಮೇಲೆಲ್ಲ ಹಾಕ್ತಾರೆ, ಅದು ಬೇರೆ ಪ್ರಶ್ನೆ. ಕೇಸ್ ಇದ್ಕೊಂಡು ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗಿ ನಿಂತ್ಕೊಂಡು ಟ್ರಯಲ್ ಫೇಸ್ ಮಾಡಿ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ ಅಂತ ಬರೀತೀವಿ ಅಂತಂದ್ರೆ ಇಟ್ ನಾಟ್ ಓನ್ಲಿ ಅಮೌಂಟ್ ಟು ಸಪ್ರೆಷನ್ ಆಫ್ ಮೆಟೀರಿಯಲ್ ಫ್ಯಾಕ್ಟ್ಸ್, ಕೀಪಿಂಗ್ ಅವೇ ಸರ್ಟನ್ ಥಿಂಗ್ಸ್ ಅಂಡ್ ಟ್ರೈಂಗ್ ಟು ಮಿಸ್ಲೀಡ್ ದಿ ಕೋರ್ಟ್ ಅಂತ ಬರ್ದಿಟ್ಟು 1 ಲಕ್ಷ ಕಾಸ್ಟ್ ಆಗ್ತದೆ. ಯು ಡಿಸೈಡ್ ವಾಟ್ ಯು ವಾಂಟ್ ಟು ಡು. ಡೋಂಟ್ ಟೆಲ್ ಮಿ ಆಲ್ ದೋಸ್ ಥಿಂಗ್ಸ್. ಮೈ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಆರ್ ನಾಟ್ ದೇರ್. ಕೀಪ್ ಯುವರ್ ಪಾರ್ಟಿ ಪ್ರೆಸೆಂಟ್. If he is not able to come, then I will impose the cost. I'll impose the cost. Sir, read 438 subclass 2, subclass 1 and subclass 2. ಏನ್ ನನ್ಗೆಲ್ಲ ಹೇಳ್ಬೇಡಿ ಇದನ್ನ. ಇದು ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಪ್ರಾಕ್ಟೀಸ್. ಬಾಂಬೆಲಿ ಇಂಟ್ರೀಮ್ ಬೇಲ್ ಕೊಡೋದು, ಅಲ್ಲಿ ಬಾ ಅಂತ ಕೂಡಿಸ್ಕೊಳ್ಳೋದು, ಮಾರನೇ ದಿನ IO ಕೊಡೋದು, ಆ ಕಡೆಯಿಂದ ಬಿಟ್ಟು ಕಳಿಸ್ಬಿಡೋದು, ತಗೊಂಡೋಗಪ್ಪ ನಾನು. While granting the interim bail, presence of the petitioner be made available before the court and the oath.
The court grants the interim order under subsection 1, which for which was a notice being not evidence together with a copy of such order to the minister of the public prosecutor of police. Is able to give the public prosecutor a reasonable opportunity of being heard. The application shall be finally heard by the court. 2. When the High Court or the Court of Appeal makes a disposition on subsection 1, it may include such condition in such direction in the light of the facts of a particular case, as it may be including the condition that the person make himself available for interrogation by a police officer as and when required. The condition that the police shall not directly or indirectly make any inducement, threat or promise to you.
ಅದೆಲ್ಲ ಆಯ್ತು ಬಿಡಿ, ಸಾಕಲ್ಲ. ಬನ್ನಿ ಅಂತ ಹೇಳ್ಬೋದಲ್ಲ, ಅಲ್ಲ ಹೇಳ್ಬೋದಲ್ವಾ ಅಂತ ಕೇಳ್ದೆ ಅಷ್ಟೇ ನಾನು. ಇಲ್ವಾ? ಏನ್ ಓದಿದ್ರಿ ಮತ್ತೆ ನೀವು? ಅದಕ್ಕೆ ಮುಂಚಿಂದ ಓದ್ರಿ. ಎಲ್ಲಾರು ಕೇಳಿಸ್ಕೊಂಡಿದ್ದಾರೆ, ಇನ್ನೊಂದ್ಸತಿ ಕೇಳಿಸ್ಕೊಳ್ಳಿ.
The High Court or Court of Session makes a direction under subsection 1. It may include such condition in such direction in the light of the facts of the particular.
ಓದಿ. ಅದಲ್ಲ ರೀ, ಇವಾಗ ಓದಿದ್ದನ್ನ ಓದ್ರಿ.
When the court or the Court of Session makes a direction under subsection 1.
It may include.
Grant
It may include.
It may include such condition in such direction in the light of the facts of the particular case as it may include.
ಎಲ್ಲ ಅರ್ಧಂಬರ್ಧ ಓದಿದ್ರೆ ನನ್ಗೇನ್ ಓದಕ್ ಬರಲ್ವಾ? This is not the way to make a submission before the court. It can direct that he should be present, made available to the investigation agency, including appearance before the court. ಬನ್ನಿ, ನಾನು ಬರೀತೀನಿ ಈಗ ಆರ್ಡರ್. ಕೀಪ್ ದಿ ಪೆಟಿಷನರ್ ಪ್ರೆಸೆಂಟ್. ಬರೀಲ್ಲ, ಬೇಡ ಅಂದ್ರೆ ಬಿಟ್ಬಿಡ್ತೀನಿ. 20 ಕೇಸ್ ಇಟ್ಕೊಂಡು ತಾವು ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ ಅಂತ ಬರೀತೀರಿ. ಬರ್ಕೊಳ್ಳಿ. ಹರ್ಡ್ ಶ್ರೀ ಭರತ್ ಕುಮಾರ್, ಲ್ಯಾಂಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ petitioner. HCGP submits that the petitioner is having criminal antecedents. He is involved in as many as 20 cases. First, petition is silent about the petitioner being an accused in 20 cases. First, counsel for petitioner submits that he has no instructions about the antecedents of the petitioner. In order to ascertain the correctness of the statement made by the land counsel for the petitioner, petitioner is directed to be present before this court on 15th of March at 2:30. ಇರ್ಲಾ ಅಥವಾ ಸುಮ್ಮನೆ ಒಂದು ಮೆಮಾ ಕ್ಲೋಸ್ ಮಾಡ್ಕೊತೀರಾ? ಈಗಲೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಕೇಳಿ, ಅಲ್ಲಿದೆ ಅವ್ರ ಹತ್ರ ಮೆಟೀರಿಯಲ್. ಇದು ಆರ್ಡರ್ ಸೈನ್ ಮಾಡ್ಬಿಟ್ಮೇಲೆ ನಾನು ಚೇಂಜ್ ಮಾಡಲ್ಲ. ನಾವು ನೋಡಿ, ಅಲ್ಲಿ ನೋಡಿ, ತಾವು ಪೆಟಿಷನ್ ಬರೆಯುವಾಗ ಕೇಳ್ಬೇಕು, ಇದನ್ನ ಕೇಳ್ತಾರೆ ಅಂತ ಕೇಳ್ಬೇಕು. ಎಲ್ಲ ತೆಗೆದ್ಬಿಟ್ಟು ಕೌನ್ಸಿಲ್ ಪ್ರೆಸ್ ಟೈಮ್ ರಿಲೀಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 16th of March. ಹಾಗೆಲ್ಲ ಯು ಕಾಂಟ್ ಟೇಕ್ ದಿ ಹೆಡ್ ಆನ್ ದಿ ಕೋರ್ಟ್. ಕೋರ್ಟ್ ನೋಸ್ ಮೆನಿ ಆಫ್ ದೀಸ್ ಥಿಂಗ್ಸ್, ಹೌ ಟು ಹ್ಯಾಂಡಲ್. ಏನಾಯ್ತು ಇವ್ರೆ, PP ಅವರೇ? ಯಾವಾಗ ಹಾಕಿದಾರಾ? ಬರ್ಕೊಳ್ಳಿ. wait. I'll pass order, suitable orders. Order Shri Hasmat Pasha, learned senior counsel on behalf of the petitioner. When the case was taken up in the morning session, Shri Hasmat Pasha submitted that today is the 61st day from the date of arrest, that is being 10th January 2022, and she has definite information that the prosecution has not filed the charge sheet against the petitioner herein, and therefore, without expecting a formal application under section 167(2) CRPC, submission on behalf of the counsel for petitioner be placed on record that he is ready to furnish a suitable bond for his appearance and enlarge him on the bail by resorting to the powers vested in this in the trial court as well as this court under section 167(2) CRPC. First, next para. In order to ascertain the said aspect of the matter was passed over for the afternoon session. Learned HCGP on verification submits that charge sheet is not filed. First, however, HCGP also submits that application under section 167(2) CRPC has been filed by the petitioner before the trial court. First, if the petitioner has already approached the trial court which has sent the accused to judicial custody, the trial court is directed to consider the application filed by the petitioner under 167(2) CRPC today itself and dispose of the same in accordance with law. With the above observation, petition stands disposed of. ನೀವು ಹೋಗಿ ಹೇಳಿ ಅವ್ರು ಯಾರು ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಬಂದು ಅಫಿಡವಿಟ್ ಹಾಕಿ ನಾ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ ತಾವು ಅಫಿಡವಿಟ್ ಹಾಕಿ, ಮಾಡಲ್ಲ ಅಂದ್ರೆ ನೋಡೋಣ. ನಾವು ಕೆಲಸ ಕಳ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ಓರಲ್ಲಿ ತಾವ್ ಹೇಳಿ ಕೋರ್ಟ್ ನಲ್ಲಿ ನಾನಿದ್ದೆ, ನನ್ನ ಎದುರಿಗೆ ಈ ತರ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. HCGP, you communicate your counterpart. When the investigation agency has failed, it is your duty. You should go fairly and then say they are entitled for 167. Sir, allow. You tell your counterpart, ಯಾರಿದ್ದಾರೆ PP ನೋಡಿ, ನೀವು ಯಾರು ಮಾತಾಡಿದ್ರಿ ಅಯ್ಯೋ ಹೇಳಿ ಹೋಗಿದ್ದು ಮಾಡ್ಲಿ. ಇನ್ ನಾಳೆ ಏನಾದ್ರು ಕಂಪ್ಲೇಂಟ್ ಬಂದ್ರೆ ನಾನು ಸುಮ್ಮನೆ ಇರೋದಿಲ್ಲ. Not only against you, but also against the concerned judge. It is the indefeasible right. Honorable Supreme Court in the Constitution bench, Uday Mohanlal Acharya way back has ruled it that when you fail to make a charge sheet, the person should walk out. 60 ದಿವಸ ನಿಮಗೆ ಸಮಯ ಇದೆ, ನೀವು ಮಾಡಿಲ್ಲ, ಏನ್ ಮಾಡಕ್ ಬರುತ್ತೆ? ಅಲ್ಲಿ ಇನ್ನೂ ಇದೆ ಬರೀವಾಗ, ಅಂತವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ ಅಂತ ನಾವು ಹೇಳ್ಬೇಕು ಅಂತ. ನಿಮ್ಮ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ನಮ್ಗೆ ಹೇಳಿ, ಯಾರ ಮೇಲಾರು ಒಬ್ಬರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡಿದ್ದು ಉಂಟಾ ಅಂತ. ಇದ್ರೆ ಅಂತದ್ ಯಾವ್ದಾದ್ರು ಕೊಟ್ರೆ ಆರ್ಡರ್ ಇಟ್ಕೊಂಡು ನಾವು ಕಟ್ಟಾಕ್ಸಿ ಆ ಊದ್ಕಡ್ಡಿ ಬೆಳಗ್ತೀವಿ. Of course, Honorable Justice S.B. Sinha in that Anupam Kulkarni's case has held that you may, after filing the charge sheet, seek for cancellation of 167(2). That is subsequently impliedly overruled in other cases. I myself saying impliedly overruled, if not in so many words, because that is the bail under the chapter 32. So therefore, only remedy is 439(2). ಏನ್ ಮಾಡ್ತಿದ್ರಿ 61 ದಿವಸ ನೀವು? ಒಬ್ಬ ಮನುಷ್ಯನ ಸ್ವಾತಂತ್ರ್ಯವನ್ನ ಹರಣ ಮಾಡಿದ್ಮೇಲೆ, ಕಾನೂನು ನಿಮ್ಗೆ 60 ದಿವಸ ಟೈಮ್ ಕೊಟ್ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕೋದಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ? Concerned IO should go and explain. ಅವ್ರ ಮೇಲೆಲ್ಲ ಇದಾರೆ ಸೂಪರ್ವೈಸರಿ ಅಥಾರಿಟೀಸ್, SP ಇದಾರೆ. ಕ್ರೈಮ್ ಮೀಟಿಂಗ್ ನಡೆಯುತ್ತೆ, ಪ್ರತಿ ತಿಂಗಳು ನಡೆಯುತ್ತೆ. SPP ಅವರೇ ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲಿ ಕೇಳ್ಬೇಕಲ್ಲ ಅವರು. SP ಅವರು ಕ್ರೈಮ್ ಮೀಟಿಂಗ್ ತೆಗೆದುಕೊಂಡಾಗ ಕೇಳ್ಬೇಕು, ಇನ್ ಹೌ ಮೆನಿ ಕೇಸಸ್ ಇನ್ ಮೈ ಡಿಸ್ಟ್ರಿಕ್ಟ್ people have been enlarged on bail by resorting to 167(2) ಅಂತ ಕೇಳಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ ಉತ್ತರ. ಅದಕ್ಕಿತ್ತು ಅಂತಂದ್ರೆ ಅವರ ಇಮಿಡಿಯೇಟ್ಲಿ ಅವ್ರ ACR ಬರಿಬೇಕು. ಈ ಮನುಷ್ಯ ತನಿಖೆಯನ್ನ ಮಾಡೋದ್ ಬಿಟ್ಟು ವೃಥಾ ಕಾಲಕ್ಷೇಪ ಮಾಡಿದ್ರಿಂದ ಒಬ್ಬ ಆರೋಪಿ ಕಾನೂನಿನ ಕುಣಿಕೆಯಿಂದ ಸುಲಭವಾಗಿ ತಪ್ಪಿಸಿಕೊಂಡರು ಅಂತ. There are hundreds of cases which say that the bail under 167(2) is a backdoor method. ಆ ಕಡೆ ಬಾಗ್ಲಿಂದ ಇಟ್ಕೊಳ್ಳೋದು, ಈ ಕಡೆ ಬಾಗ್ಲಿಂದ ಕಳಿಸೋದು. ಏನ್ ಉಪಯೋಗ? Now you see from that angle, what about the de facto complainant's right? ನಾಳೆ ಬೆಳಗ್ಗೆ ಅವ್ನ ಮನೆ ಹತ್ರ ಗಲಾಟೆ ಮಾಡ್ತಾನೆ. ಇಲ್ಲಾದ್ರೂ ನೀವು ಬೇರೆ ಕಂಡೀಷನ್ಸ್ ಹಾಕ್ಬೋದು. 167(2) ನಲ್ಲಿ ಏನ್ ಕಂಡೀಷನ್? 167(2) ನಲ್ಲಿ ಏನ್ ಕಂಡೀಷನ್? If I execute a bond for my appearance before the court, that's enough. That's the wordings used is like that. There need not be any formal application. ಹಾಗಾಗಿ if you see the remand 14 ದಿವಸ ಅಂತ ಕೊಡ್ತಾರಲ್ಲ, ಅದರ ಉದ್ದೇಶವೇ ಅದು. So that ಆತನ ಸಂದರ್ಭದಲ್ಲಿ ಮೊದಲನೇ ದಿವಸ ಆಯ್ತು, 14 ದಿವಸ ಕೊಟ್ರ ನೀವು 60 ದಿವಸದಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕುವಂತ ಕೇಸ್ ಇದ್ರೆ 5ನೇ ರಿಮಾಂಡ್ 14 ದಿವಸಕ್ಕೆ ಇರಬಾರ್ದು. ಮ್ಯಾಕ್ಸಿಮಮ್ 14 ಡೇಸ್ ಇರೋದು. ಗೊತ್ತಾಯ್ತಲ್ಲ? 14 56. 5ನೇ ರಿಮಾಂಡ್ ಮಾಡುವಾಗ 4 ದಿನಕ್ಕೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕು. ನಾನ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ಯಾಕಂದ್ರೆ ಅವ್ನು ಬಂದ್ರೆ ಇವತ್ತು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ವಾ, ಏನಪ್ಪ ಬಾಂಡ್ ಕೊಡಕ್ ರೆಡಿ ಆಗಿದ್ಯಾ, ಬಾ ಹೋಗು. 90 ದಿವಸದಿತ್ತು ಅಂತಂದ್ರೆ 14 84. 7ನೇ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೊಡುವಾಗ 6 ದಿವಸಕ್ಕೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕು. So that on the day of 91st day or 61st day, whenever the accused is there before the court, he should be physically present before me, and I must educate him that you are entitled for the enlarging on bail provided you give the bond. This is the duty cast on the trial magistrate or the trial special judge. ಎಲ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ? ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಟೈಮ್ ಕೊಡೋದು, ವಾರಗಟ್ಲೆ ಮುಂದೆ ಹಾಕೋದು, ಅದಕ್ಕೆ ಅವ್ರ ಅಪ್ರಹೆನ್ಷನ್ ಅದು. ನಾ ಅದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ, ಅವ್ರ ಅಫಿಡವಿಟ್ ಹಾಕ್ತಾರೆ, ನಿಮ್ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಕೇಳಿ. ನಾನು ನೋಡಿದ್ದೀನಿ ಇವೆಲ್ಲ ಮಾಡೋದು. 167(2)ಗೂ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಟೈಮ್ ಕೊಡೋದು, ವಾರಗಟ್ಲೆ ಕೊಡೋದು. Indefeasible right has accrued moment you failed to file the charge sheet. So much so that the application is earlier, 167(2), and the charge sheet is later. Then also it is not the compliance of section 167. ನಾವು ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ವಿ, ಚಾರ್ಜ್ ಶೀಟ್ ಬಂದ್ರೆ ಸಮಯ ಕೂಡ ನೋಟ್ ಮಾಡ್ತಾ ಇದ್ವಿ, ಎಷ್ಟೊತ್ತಿಗೆ ಹಾಕಿದ್ರು ಅಂತ, ಅಪ್ಲಿಕೇಶನ್ ನ ಎಷ್ಟೊತ್ತಿಗೆ ಹಾಕಿದ್ರು ಅಂತ. ಇಂತಹ ಸಂದರ್ಭಗಳಲ್ಲಿ ಇನ್ನೂ ಒಂದ್ ಹೇಳಿರ್ತೀನಿ, ತಿಳ್ಕೊಂಡ್ಬಿಟ್ಟಿರಿ. ಚಾರ್ಜ್ ಶೀಟ್ ನ ತಗೊಂಬಂದು ಚೇಂಬರ್ ಕೊಡಕ್ ಬರ್ತಾರೆ, ನಥಿಂಗ್ ಡೂಯಿಂಗ್, ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಡುವ ಒಂದೇ ಗ್ರೇ ಏರಿಯಾ ಇದೆ. If the charge sheet and 167 are simultaneously produced before the court, what will happen? Then 167 should fail because charge sheet is there. Suresh become Chan. Simultaneously ಈ ಕಡೆಯಿಂದ ಐಒ ನಿಂತಿದ್ದಾರೆ, ಅವ್ರು ಚಾರ್ಜ್ ಶೀಟ್ ಹಿಂಗ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ, ಈ ಕಡೆಯಿಂದ ಡಿಫೆನ್ಸ್ ನವ್ರು ನಿಂತಾರೆ, 167(2) ಕೊಡ್ತಾರೆ. ಇದೆರಡರ ಮಧ್ಯೆ 1 ನಿಮಿಷ ವ್ಯತ್ಯಾಸ ಆಯ್ತು ಅಂತಂದ್ರೆ ಕೂಡ ನನ್ನ ಯಾವ್ದು ಮುಂಚೆ ಇರುತ್ತೋ ಅದಕ್ಕೆ ಹೋಗುತ್ತೆ. This is the position. It is as good as playing the chess. After the moment, I put the clock. Tick, 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 tick. Time is over. You have not made the moment. You lost the game. You lost the game. Simple. That's the point. ನಿಮ್ಮನ್ನ ಹಾಕಿಲ್ಲ, ಇವತ್ತು ಹೋಗಿ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಕೇಳಿ, ಈಗಲೇ ಫೋನ್ ಮಾಡಿ ಹೊರಗಡೆ ಹೇಳಿ, ಕೋರ್ಟ್ನವ್ರು ಈ ತರ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ, ಬಿ ಕೇರ್ಫುಲ್, ಡೋಂಟ್ ಗೆಟ್ ಇನ್ ಟು ಎನಿ ಅದರ್ ಕಾಂಪ್ಲಿಕೇಶನ್ಸ್. You failed to prove. You failed to prove that he should be continued in the custody any longer. That's the point. ನಿಮ್ಗೆ 60 ದಿವಸ ಕೊಟ್ಟಿದ್ದೀವಿ, ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? 10ನೇ ತಾರೀಕು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರಿ, ಆಕ್ಚುಲ್ ಆಗಿ 8ನೇ ತಾರೀಕು ಕಸ್ಟಡಿಗೆ ತಗೊಂಡಿದ್ದೀರಿ. ಅವ್ರು ಅದನ್ನ ಹೇಳಿಲ್ಲ, ಬಿಕಾಸ್ senior counsel knows that the court position that custody need not be arrest and whenever the remand, that is the date 10. ಇದು ಡೀಟೇಲ್ ಆಗಿ ಆರ್ಡರ್ ಬರ್ತಿದ್ದೀವಿ ಅವ್ರದ್ದೇನೆ. ಅವರು ಹನುಮಂತರಾಯರು, ಶ್ಯಾಮ್ ಸುಂದರ್ರು, ಅಷ್ಟೇ ಪೆಕ್ಯುಲರ್ ಕೇಸ್, ಯಶೋದಮ್ಮ ಇಂದ ಹಿಡಿದು ಎಲ್ಲ ತೆಗೆದುಕೊಂಡಿದ್ದಾರೆ. ಉದಯ್ ಮೋಹನ್ ಲಾಲ್ ಆಚಾರ್ಯ, ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್ ಡಿಸ್ಕಸ್, ಅನುಪಮ್ ಕುಲಕರ್ಣಿ, ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್ ವರ್ ಡಿಸ್ಕಸ್ಡ್ ಇನ್ ಲೆಂತ್. ಬೋತ್ ಆಲ್ ದಿ 3, ಇನ್ಫ್ಯಾಕ್ಟ್ ಪಾಷಾ ಅವರು ಮತ್ತೆ ಹನುಮಂತರಾಯರು, they sufficiently argued. We were able to find out what is the charge sheet. ಯಾಕಂದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ CRPC ಡಿಫೈನ್ ಆಗಿಲ್ಲ. ಕ್ರಿಮಿನಲ್ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್ ಕರ್ನಾಟಕದಲ್ಲಿ ಡಿಫೈನ್ ಆಗಿದೆ. ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಇಸ್ ವಾಟ್ ಇಸ್ ಟೋಲ್ಡ್. ಚಾರ್ಜ್ ಶೀಟ್ ಅನ್ನೋ ಪದ ಇರ್ಲಿಲ್ಲ, ಅದನ್ನೆಲ್ಲ ಬರೆದು ಏನಾಗುತ್ತೆ ಅಂತ ಹೇಳಿ, ಅಫ್ಕೋರ್ಸ್ ಅದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರು, ಒಂದ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಬರ್ದ್ಬಿಟ್ಟಿದ್ರು, 24, 25, we need further investigation ಅಂತ. So the argument that was put forth was, it is a skeleton charge sheet only to deny my right under 167(2), a stopgap or ad hoc charge sheet. Therefore, it is not a charge sheet in the eye of law, and further you have not taken cognizance. Therefore, you don't have the power of remand. Detail order ಬಂದು ನೋಡ್ಕೊಳ್ಳಿ ಇದೆ, ಗೊತ್ತಾಯ್ತಲ್ಲ. So this court has spent sufficient time on 167(2). ಅವ್ರಿಗೆ ಇಂಡಿಫೀಸಿಯಬಲ್ ರೈಟ್ ಅನ್ನೋದು ಎರಡು ಮಾತಿಲ್ಲ, ಅದನ್ನ ಒಪ್ಕೋಬೇಕು. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇವತ್ತಿಗೂ ಇಟ್ ಹೋಲ್ಡ್ಸ್ ದಿ ಫೀಲ್ಡ್ ಅಂಡ್ ಇಟ್ ಮಸ್ಟ್ ಬಿ ರೆಸ್ಪೆಕ್ಟೆಡ್ ಇನ್ ಲೆಟರ್ ಅಂಡ್ ಸ್ಪಿರಿಟ್ ಬೈ ಆಲ್ ಕನ್ಸರ್ನ್. ಸೊ ಕೋರ್ಟ್ ಇಸ್ ನಾಟ್, ಅವರು ಹೇಳ್ಬಿಡಿ ಮುಗಿಸ್ಕೊಳ್ಳಿ. ಇಫ್ ಎನಿಥಿಂಗ್ ಈಸ್ ದೇರ್, ಕೈಂಡ್ಲಿ ಮೂವ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಈವನ್ ಅಟ್ 4:45 or 5 o'clock ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್. ಐ ಡೋಂಟ್ ಥಿಂಕ್ ದಟ್ ಇಷ್ಟೆಲ್ಲ ಹೇಳಿದ್ಮೇಲೆ ಏನ್ ತೊಂದರೆ ಆಗಲ್ಲ. You can say so. 60 days is ಅದರಲ್ಲೇನು ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. 60, 90 ಏನಿಲ್ಲ, ಕ್ಲಿಯರ್ ಆಗಿದೆ. ನೇಚರ್ ಆಫ್ ಅಫೆನ್ಸ್ ಗೆ 60 days. Yes, all those things, sir. Yes, please. ಏನಪ್ಪ ಇದೇನಾಯ್ತು? ಎಷ್ಟ್ ದಿನ ಇರ್ಬೇಕ್ರಿ? ಆಕೆ ಮೊದ್ಲು ಕೇಸ್ ಹಾಕಿದ್ದಾಳಲ್ರಿ. ನಾನು ಆಕೆ ವೆರಿ ಸಿಂಪಲ್ ಪಾಯಿಂಟ್. ನಮ್ಮ ಒಂದ್ ನಿಮಿಷ ಕೇಳಿ PP ಅವರೇ, ಮೊದಲು ನಾನ್ ಕೇಸ್ ಹಾಕ್ತೀನಿ, ನಮ್ಮಿಬ್ಬರ ಮಧ್ಯ ಸಾಮರಸ್ಯ ಇಲ್ಲ, ಕಾನೂನಾತ್ಮಕವಾಗಿ ನಮ್ಗೇನ್ ಬೇಕೋ ಬಗೆಹರಿಸ್ಕೊಡಿ ಅಂತ ಡ್ಯೂಲಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಕೋರ್ಟ್ ಹೋಗಿ ಒಂದು ಅರ್ಜಿ ಹಾಕ್ತೀನಿ. ಅಲ್ಲಿ ಬಂದು ಅದಕ್ಕೆ ಉತ್ತರ ಹೇಳಿ ಆ ಪೆಟಿಷನ್ ನ ಕಾನೂನಾತ್ಮಕವಾಗಿ ಕಂಟೆಸ್ಟ್ ಮಾಡ್ಬೇಕು. ಅದು ಮಾಡ್ರಿ ಅಂತಂದ್ರೆ ಹೋಗ್ಬಿಟ್ಟು ನನ್ ಗಂಡನ್ ಜೈಲಿಗೆ ಕಳಿಸ್ತೀನಿ ಅಂದ್ರೆ ಏನ್ ಲೆಕ್ಕ? ಮತ್ತೆ ಆಫ್ಟರ್ ಕಂಪ್ಲೇಂಟ್ ಇದ್ರೆ After all, ಕೇಳ್ತಿರ್ತಕ್ಕಂಥದ್ದು 438. Arnish Kumar also comes in the way. Oh, later we will allow the petition. Barkadri. Heard. Srimati Nagamani and learned HGP. Present petition is filed under section 438 CRPC with the following prayer. First, the brief facts of the case are as under. Upon a complaint lodged by Sultana, the HL police station registered a case in crime number 294 of 2021 for the offences punishable under section 3 and 4 of the Dowry Prohibition Act, 506, 498A, 392, 394, 307, 316, 323, 324 of the IPC, reduced section 34 IPC against the petitioner herein. First, petitioner is the husband and you. Petitioner is the husband of the complainant. First, the police after registering the case are investigating the matter. First, in the meantime, there is a real apprehension of arrest according to the petitioner, arrest by the respondent police expressed by the petitioner, and therefore he approached the district court for grant of bail under anticipatory bail in CMIS number 700/2022. First, learned district judge by order dated 24 January 2022 turned down the request made by the petitioner, even therefore the petitioner is before this court. Next para. Reiterating the grounds urged in the petition, Srimati Nagamani vehemently contended that the petitioner has no role whatsoever in the alleged offences, and entire case, entire complaint is false and fabricated. First, she also drew the attention of this court that the petitioner has approached the jurisdictional civil court, family court, seeking relief of divorce in OS number 221 of 2020. Thereafter, with ulterior motives, present complaint came to be filed on 22/12/2021 belatedly with an intention to coerce and harass the petitioner, and therefore sought for allowing the petition. First, per contra, learned HGP opposes that the petitioner, being the husband, is responsible for the cruelty, and the prosecution has also invoked offense under section 307 IPC, and therefore custodial investigation of the petitioner is very much necessary for the effective investigation, and thus sought for dismissal of the petition. First, we also pointed out that even after the dismissal of the anticipatory bail request made by the petitioner, petitioner is not available to the investigation agency, and therefore investigation has crippled to a considerable extent, and sought for dismissal of the petition. First, in view of the rival contentions, this court perused the matter on record. First, next para. It is admitted fact that there are serious differences in the matrimonial relationship between the petitioner and the complainant. First, complainant which resulted in filing a petition before the family court Bangalore in OS number 221 of 2020, wherein the petitioner herein sought for grant of divorce. First, the complainant appeared before the court and engaged the services of the advocate and is contesting the said matter. Thereafter, belatedly on 22/12/2021, complaint came to be filed before the HL police. First, admittedly, when there are serious dispute and the matrimonial relationship has been strained, the continuation of the petitioner in the house of the continuation of the complainant in the house of the petitioner is doubtful. First, nevertheless, this court at this stage cannot express any opinion on the merits of the matter by holding the mini trial, as the same may prejudice the case of the parties during the trial. First, suffice to say, following the dictum of the Honorable Apex Court in the case of Arnish Kumar versus so and so, the right of the petitioner to be protected. First, at the same time, the need of the custodial investigation of the investigation agency cannot be lost sight of. First, therefore, need has arisen to balance to strike a harmonious balance between the right of the petitioner and the need of the investigation agency. Accordingly, following order is passed. Petition allowed. Petitioner directed to join the investigation on 23/3/2022 by appearing before the investigation officer in HL police station in respect of crime number 294 of 2021. First, the investigation officer is at liberty to take the petitioner to custody and complete the custodial investigation on the same day before 6 p.m. and thereafter enlarge the accused on bail on taking the bond in a sum of rupees 1 lakh with 2 sureties for the like sum. First, a petitioner shall not directly or indirectly interfere with the investigation process, nor tamper the prosecution witnesses. First, petitioner shall appear before the investigation officer, shall mark his attendance before the investigation officer between 10 and 2 p.m. every alternate Sunday till the final report is filed. First, a petitioner shall attend the court regularly. First, a petitioner shall not leave the jurisdiction of Bangalore district without prior permission. Violation of any one of the conditions would entitle the prosecution to seek for cancellation of the bail. Order according. ಇವ್ರದೇನಾಯ್ತ್ರಿ ಬರೇ ಇದೇ ಆಗೋದ್ರಿ ಏನ್ ಮಾಡೋದ್ರಿ ನೀವೇನೋ ಅದೇನೋ ರಿಪೋರ್ಟ್ ನೋಡ್ತೀನಿ ಎಷ್ಟ್ ಜನಕ್ಕೆ ಮೋಸ ಆಗಿದೆ ಅಂತ ನೋಡ್ತೀನಿ ಅಂತ ಅವರು ಅಪೇರ್ ಆಗ್ಲಿ ಬಿಡಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏಜೆಂಟ್ ಬರ್ಕಮ್ಮ petition under section 438 CRPC with the following prayer. Three facts of the case are as under. A complaint came to be filed. Yaar ivaru? By Nagaraja Lakshmamma. By Nagaraja and Lakshmamma, contending that the petitioner and others have joined their hands to cheat the general public, and they have created a app called Just Money app.
It's not created. 2015 established
ಏನಂತ created an app on the our company.
Actually, that is Just Money app.
By created an app, created an app by a company called Just, JEST, Just Money. ZEST, Just Money app, whereby people can apply for loan online, and after completion of after furnishing all relevant materials, loan would be granted. First, the complainants contend that even after completing all formalities, they were not able to get the loan, and therefore they have filed a complaint against the petitioner and others. First, the same came to be registered by Badrahalli Police in crime number 30/2022 for the offences punishable under section 406, 420, 504, 506, that is section 34 IPC. First, the petitioner is you would then roll according to complaint to. First, allegation against the petitioner is that they collected the bank details of the petitioners, of the complainants, and for the purpose of getting them loan. First, after registering the case, police are investigating the matter inter alia, trying to apprehend the petitioner. First, based on the apprehension expressed by the petitioner, petitioner approached the district court for grant of anticipatory bail in CMIS number 187 of 2022. First, the said matter was contested, and by order dated 3rd February 2022, additional district and session judge Bangalore Rural District rejected the prayer made by the petitioner, and thereafter petitioner is before this court. First, Joint Counsel for the petitioner, Sri Kumar, vehemently contended that in fact the petitioner is also a person who is a victim in the whole incident, and unnecessarily his name has been shown as an accused in the case, and he is ready to cooperate with the investigation agency, and therefore sought for grant of anticipatory bail. First, per contra, learned HCGP opposes the bail petition. First, the time was granted by this court for the learned HCGP to place before this court all necessary materials including the quantum of alleged fraud. First, however, despite granting sufficient time, no written objections are placed on record. First, learned HCGP, however, submits that huge quantum of money has been misused, siphoned away by the company, and petitioner has a role in it, and therefore sought for dismissal of the petition. First, next para, in view of the rival contentions, this court perused the material on record. First, admittedly, comma, a complaint came to be lodged by two persons based on which the petition, the police have registered a case. First, according to petitioner, comma, he is also a victim. First, if at all, if he is a victim, comma, it is always open for him to say so before the investigation agency. First, at the same time, comma, the real apprehension of arrest cannot be lost. Arrest by the petitioner cannot be real apprehension of arrest expressed by the petitioner cannot be lost sight of by this court. First, at the same time, comma, custodial investigation, need of custodial investigation in order to unearth the truth in the incident cannot also be lost sight of. Accordingly, this court is required to strike a harmonious balance between the need of the custodial investigation and right of the petitioner. Accordingly, following order, ಇದೆಲ್ಲ ಸೇಮ್ ಬರ್ಕೋ 23 ಬೆಳಗ್ಗೆ ಹೋಗ್ಲಿ ಅಷ್ಟೊತ್ತಿಗೆ ಅದೇ ಆಗುತ್ತೆ. Case called twice. None present on behalf of the petitioner. Release this matter on 18/3 in the interest of justice. None present on behalf of the petitioner. First, IA3 of 2021 is filed seeking extension of the time. First, admittedly, the order passed by this court is not complied by the petitioner. Hence, there is no merit in the application. Accordingly, IA3 of 2021 is hereby dismissed. ಎಲ್ಲೋದ್ರು ಚರಮಗೋಳ ಬನ್ರಿ. ಏನಾಯ್ತು SPP ಅವರೇ? ಆಲ್ ರೈಟ್, ಇವ್ರದಲ್ಲನಾ? ಯಾರ್ದಲ್ಲಿ? ಎಲ್ಲ ಇವ್ರದ್ದು ಇವಾಗ 1396 1445 ಅಲ್ಲಿ ಬಿಟ್ಬಿಟ್ಟಿದಾರ, ನಿಮ್ಮವ್ರನ್ನ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸೊ ಅಕಾಡೆಮಿಕ್ ಉಳ್ಕೊಳ್ಳುತ್ತೆ. ಅಕಾಡೆಮಿಕ್ ಮಾಡ್ಬೇಡ, ಬ್ರೀಫ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳ್ಬಿಟ್ಟು ಅಕಾಡೆಮಿಕ್ ಇದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡೋಣ. ಅರುಣ್ ಕುಮಾರ್ದು ಅವ್ರು ಬಂದಿಲ್ಲ, ಅದ್ರಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಆಗುತ್ತೋ ಅದ್ರಲ್ಲಿ ಅದಾಗ್ಲಿ. ಬೆಳಗ್ಗೆನೂ ಅರುಣ್ ಕುಮಾರ್ ಅವ್ರು ಕಂಡಿಲ್ಲ. ಸೊ ಆ ಕೇಸಲ್ಲಿ ಏನಿದೆಯೋ ನಿಮ್ದು ಎಕ್ಸ್ಪ್ರೆಷನ್ ಮಾಡ್ತಾ ಅದನ್ನ ಬರ್ಕೊಳ್ಳೋಣ. ಮೊದ್ಲು ಇದನ್ನ ಮುಗಿಸ್ಕೊಂಡು ವೆರಿ ಗುಡ್. Wonderful. This is what I expected from you, and it has happened. Most happy. This will be placed on record. Yes. SPP ಅವರೇ, ನಿಮ್ಮ ಕ್ರಮಕ್ಕೆ ಶ್ಲಾಘನೆ ಆಯ್ತಾ. ಶ್ಲಾಘಿಸೋದ್ರ ಜೊತೆಗೆ ಇದೇ ರೀತಿಯಾಗಿ ಸರ್ಕಾರ ಈ ಎಲ್ಲ ಮ್ಯಾಟರ್ಗಳಿಗೆ ಉತ್ತಮವಾದ ರೀತಿಯಲ್ಲಿ ಸ್ಪಂದನೆ ಕೊಟ್ಬಿಟ್ರೆ ಐ ಥಿಂಕ್ ಕೋರ್ಟ್ಗಳಲ್ಲಿ ಆದಷ್ಟು ಹೊರೆ ಕಡಿಮೆ ಆಗುತ್ತೆ. ದಿಸ್ ಇಸ್ ವಾಟ್ ಇಸ್ ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್. ಫೈನ್. Overnight things have happened. In fact, overnight alla, within few hours after the conclusion of the hearing, things have happened. Wonderful. This is what is expected. Best in the circumstances. In fact, it requires all kudos and applause. We'll have appreciation. No, it's duty one aspect. At the same time, the officials, the government, the concerned department, the higher ups, whomsoever, decision-making authorities have raised to the situation and reacted fast. That's the point. Each one of it's the duty of the court and duty of all concerned to obey it. I owe it as a duty because at the end of the day, why people come here is only for that. If they are able to get the relief without the intervention of the court, by the authorities acting in accordance with law, that's the best result that any petition can do. Allah. Wonderful. Barkolima. App. Kodi. Yes. No. We'll see. I have noted in fact, I have noted. This I may not say. This is doctrine of endowment. I will remark, I'll make an observation in my order that a suitable mechanism may be avoided. That would take care of you. Otherwise, court will take into the lean interest. Yes, purple. ಇದು ಒಂದ್ರಲ್ಲಿ ಬರೀರಿ, ಇನ್ ಮಿಕ್ಕಿದ್ದಕ್ಕೆ ಆಗೋಗ್ಬಿಡುತ್ತೆ ಅಷ್ಟೇ. ಒಂದ್ರಲ್ಲಿ ಬರೀರಿ, ಯಾವ್ದಲ್ಲ 1396 ಅಲ್ಲಿ ಬರೀರಿ. ನೆನ್ನೆ ತಗೊಂಡ್ರೆ 1396 ಏನಪ್ಪಾ, ಅದ್ರಲ್ಲಿ ತಾನೇ ಕ್ರೈಮ್ ನಂಬರ್ 87 20 ಅದೊಂದನ್ನ ಫ್ಯಾಕ್ಟ್ಸ್ ಬರ್ದ್ ಬಿಡ್ತೀನಿ. ಇನ್ನೊಂದ್ರಲ್ಲಿ ಅವ್ರು ಮೆಮೊ ಹಾಕ್ಬಿಡ್ತಾರೆ. ಎರಡನೇ ಕೇಸಲ್ಲಿ ಮೆಮೊ ಹಾಕ್ಬಿಡ್ತಾರೆ, ಮೆಮೊ ಮೇಲೆ ತಗೊಂಡು ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡಿ. ಮೆಮೊ ಫೈಲ್ಡ್ ಎರಡನೇದು 1445 ಅಲ್ಲಿ ಮೆಮೊ ಫೈಲ್ಡ್, ಮೆಮೊ ರೀಡ್ಸ್ as sender. In view of the memo, petition has become infructuous, hence disposed of. ಅಷ್ಟೇ ಸರ್, ಡಿಸ್ಮಿಸ್ ಬೇಡ, hence disposed of. ಇದು ಎರಡನೇ ಕೇಸ್ ಆಯ್ತು. ಮೊದಲನೇ ಕೇಸಲ್ಲಿ ಡೀಟೇಲ್ ಆಗಿ ಬರೆಯೋಣ. ಬರೆದಿದ್ದಕ್ಕೆ that will be helpful for other cases. The present petition is filed under section 439 CRPC with following prayer. First, next para. Brief facts of the case are as under. Petitioner herein was arrested by the police by New Extension Police Station, Police Tumkur, New Extension Police Tumkur on 18/1/2020 on 6/12/2021 in respect of crime number 87 of 2021. First, he was in custody. First, he was sent to judicial custody. First, thereafter, Jayanagar Police Tumkur registered a case in crime number 20/21 against the petitioner. First, since the custodial investigation of the petitioner was necessary in crime number 20/21, Jayanagar Police filed an application before the jurisdictional magistrate in crime number 87/21 seeking custody of the petitioner as is contemplated under section 267 CRPC on 8/12/2021. First, said application was allowed by the jurisdictional magistrate by order dated 27/12/2021, and thereafter the custody of the petitioner was granted to Jayanagar Police Station for the period of 29/12/2021 and 30/12/2021. First, admittedly, the said order would be in consonance with section 260. By said order came to be passed by exercising the power vested in the trial magistrate in crime who was seized of crime number 87 of 2021 as is contemplated under section 267 CRPC. First, the order of handing over the custody of the petitioner to Jayanagar Police in respect of investigation in crime number 20/21 from custody in crime number 87 of 2021 will be in the as per forum number 36 of the CRPC as is found in the appendix. First, in order to appreciate first, next para. Thereafter, the petitioner was given back to the custody in crime number 87/2021. First, next para. The petitioner was enlarged on bail by order dated 18/1/2022 in crime number 87/2021. First, however, the petitioner was not released from the jail, though he had the benefit of grant of bail in crime number 87/2021 purportedly on the ground that there is a body warrant issued by the learned magistrate in crime number 2021. First, therefore, petitioner approached the district court for grant of bail under section 439 CRPC. First, in CMIS number 66/2022. First, learned third additional district Judge, District and Session Judge Tumkuru, after hearing the public prosecutor, on merits dismissed the application filed under section 439 CRPC, full stop. Thereafter, petitioner is before this court with the aforesaid prayer. Full stop. Next para. Land counsel for the petitioner vehemently contended that the petitioner is entitled to be enlarged on bail. In view of the fact that he has been enlarged on bail in crime number 87/2021 in respect of crime by 87/2021 by order dated 18/1/2022, and petitioner is continued in custody on the basis of the body warrant issued in crime number 2021. Next para. The same is opposed by the learned HCGP, stating that petitioner is a known criminal. Apart from the merits of the matter, while hearing the parties, this court raised a technical point to be satisfied on behalf of the petitioner, in as much as the petitioner was not at all arrested and sent to custody in respect of crime number 2021. Land counsel for the petitioner, in reply to the same, contended that though he is not arrested, bail authorities are not releasing the petitioner on bail, releasing the petitioner by mentioning that there is a body warrant issued in crime number 2021. In order to appreciate the said aspect of the matter, it is necessary for this court to call out the provisions of section 439 CRPC and section 267 CRPC, which reads as under. Next para. It is also necessary for this court to find out whether at all an order passed under section 267 CRPC could be termed as a warrant or not. Warrant or not, and also to find out whether an order passed under section 267 CRPC authorize any jail authorities to detain a person in the prison. Therefore, it is necessary for this court to call out the forums prescribed under the CRPC for directing a person to be produced before another court when he is already in custody in a given case. The relevant forums are forum number 36 and forum number 37 in appendix 1. For ready reference, forum number 36 and forum number 37 of CRPC are called out here under. On careful and conjoined reading of section 439 CRPC, section 267 CRPC, and also the contents of forum number 36 and forum number 37 of the CRPC, the following aspects would emerge. Bullet points actually. A person can be in custody at any given point of time only in one case. If at all, if the same person is required to be produced before the investigation agency, before the court, as is found in the different contingencies in section 267 CRPC, he can be temporarily taken out from that custody and produced before the investigation agency or before the court, as the case may be, in order to satisfy one of the conditions found in section 267 CRPC. Next para. Therefore, to meet such contingencies, different forums have also been provided under the CRPC, as is referred to supra in forum number 36 and forum number 37. Forum number 36 deals with the purpose of investigation processes, and forum number 37 deals with for leading the evidence by the first person who is in custody. Next para. Further, the person who has been brought before the investigation agency, accused stroke under trial prisoner who has been brought before the investigation agency or before the court of law, would not cease to remain in custody in a where he has been sent to, but he has been temporarily taken out of that custody by orders of the court passed under section 267 CRPC. Except this mechanism, there is no other method where a person in custody cannot be taken out from the custody for any other for any purposes. First, next para. Therefore, from the above discussion, it is crystal clear that the petitioner who was in custody in crime number 87 of 2021, was brought before the court in crime number was given to the custody of the investigation officer in respect of investigation in crime number 20/21 of Jayanagar Police by virtue of the order passed by the learned magistrate in crime number 87/21 dated 27/12/2021, and he was given to custody on 29/12/2021 and 30/12/2021. First, after the investigation is completed in respect of crime number 20/21, it is pertinent to note that the petitioner has been sent back to the judicial custody in crime number 87 of 2021. First, the ordering of body warrant in crime number 20/2021, therefore, did not authorize the jail authorities to detain him in custody any longer, especially when the petitioner had the benefit of grant of bail by order dated 18th January 2022. First, next part. Therefore, what emerges from the above is a warrant issued under section ididella notes ಹಾಕೊಳ್ಳಿ. Next part. ಆಯ್ತಲ್ಲ, notes ಹಾಕೊಳ್ಳಿ. ಹಾಕೊಂಡ್ಬಿಟ್ಟು ಮಾಡ್ಕೊಳ್ಳಿ. First, the issue on the point is no longer res integra. The honorable the division bench of this court had an occasion, ILR 2015, had an occasion to deal with a similar situation in a habeas corpus petition. In the case of Gaurav Jiol versus State of Karnataka, represented by so and so, reported in ILR 2015, Karnataka 4675. First, the honorable division bench took note of the decision principles of law enunciated in 1987 supplementary within brackets 1 SCC 143 while passing the said while allowing the while passing the order in the above case. First, the relevant portion of the said order reads as under. Pencil mark. First, next para. However, during the course of hearing, learned SPP ali ಮೇಲ್ಗಡೆ ಒಂದು para ಬರ್ಕೋಬೇಕು. Having regard to the gravity and importance of the matter, this court by order dated so and so requested that learned SPP be present to address the arguments in the case in the present case. Accordingly, our SPP ಬಂದಿದ್ದು ಅಂತ ಬರ್ಕೊಂಡು. ನೀವು SPP 1 or 2 na? SPP 2 present. ಆಯ್ತಲ್ಲ? Next, during the course of hearing, learned SPP, however, brought to the notice of this court few unreported judgments of the division benches of this court. First, wherein the division bench, the other division bench has taken note of the fact that the body warrant can be got recalled by filing an application, and therefore the prayer of the petitioners who had approached the court in habeas corpus petition cannot be granted. First, this court perused the orders passed by the division benches in WPHC ಇದನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಬಿಡಿ. Next para meticulously. First, in all such petitions, it is pertinent to note that they have not referred to the division bench order of this court in Jiol's case supra. First, next para. It is pertinent to note that the division benches have not bestowed their attention to the order of the Honorable Apex Court which the Jiol's case referred to. First, next para. Therefore, a necessity has arisen for this court to consider the principles of law enunciated in Jiol's case vis-a-vis the other orders in the above referred division bench cases. First, next para. On such perusal, this court is of the considered opinion that the order passed by this court or division bench in Jiol's case supra, refers to the principles of law enunciated in Supreme Court, enunciated by the Honorable Supreme Court in the case of Ramdas Ram Supra, and had discussed in detail. Ramdas Ram Supra, and discussed in detail the interplay of the relevant provisions of the CRPC, and also discussed in detail about the authorization of the jail authorities to detain a person, and in the pretext of issue of a body warrant under section 267 CRPC. First, it is pertinent to note that in the state of Karnataka, the order passed by the court in proceeding under section 267 CRPC is popularly called as body warrant, and in the rest of the part of the country, it is called as production and transit order. First, therefore, of course, in some cases, it is also, in some states, it is also called as production and transit warrant. First, the word the usage of the word warrant in such type of orders is, in the considered opinion of this court, is misnomer, having regard to the contents of the forums in forum number 36 and 37 referred to supra. First, on careful consideration of the contents of the above forums, it is crystal clear that there is no warrant to the jail authority to detain a person while passing an order under section 267 CRPC. Therefore, the framers of legislation have carefully used in the heading of the forums that it is an order and not warrant. First, maybe colloquially, the word warrant has been attached to the above orders, and it should not have any other effect, as the contents of the forum are important to be seen and not the nomenclature. First, therefore, the question of the jail authorities detaining the petitioner in the prison in respect of the body warrant issued in crime number 20/2021 is incorrect and without authority. First, next part. At this stage, it is submitted by learned SVP that the after the argument, after this court heard the parties yesterday, the jail authorities have released the petitioner from the prison, and therefore the petition relief has become infructuous. This court places his submission on record, and for the academic purpose, further discussion is carried out. Full stop. Next para. At the same full stop. Next para. Having said this, the prosecution expressed few apprehensions. Full stop. It is common practice that the trial magistrates, in some time, the trial judges, the district judiciary, the magistrates and the district judges who are seized of the criminal trial, often use the word body warrant extended, and in some cases body warrant is extended, reissue body warrant, and JC extended, JC extended. First, it is pertinent to note that while exercising the power under section 267 CRPC, the court before whom a person who is already in custody is produced will not have any authority to extend the body warrant or give him to the custody in the subsequent case. First, as could be seen from the contents of forum, when once the purpose is served for a particular day or days, the body warrant, the authorization, the order passed under section 267 CRPC cease to exist, and the accused who has been produced before the court or the investigation agency, as the case may be, will have to return to the judicial custody, wherein he is originally sent to judicial custody by the orders of the court in the first case, in the original case. First, Therefore, it is crystal clear that the learned magistrate and district judges, as the case may be, will not have the power to order for body warrant extended stroke JC extended in case where an accused is produced before that court under the orders passed under section 267 CRPC, and such practice must be discontinued henceforth. First, further, it is also expressed by the prosecution that the same person may be necessary for investigation in several other cases, especially when the accused is a known criminal, and by virtue of the order granting the bail in the original case, to re-arrest or re-apprehend the person will be a Herculean task, and therefore the state machinery would be put to unnecessary peril. First, taking note of the said submission, this court can only say that a suitable mechanism needs to be evolved by the Home Department to protect their interest. First, it is submitted by learned SPP too that an app is developed by National Information Center, NIC, National Information Center, called e-prison app. First, it is always possible. It is always open for the Home Department to make a necessary provision in the said app to track the person who is already in custody as to the number of body warrants issued, in number of cases where he is required. All those details can be furnished in the said app, whereby there would be a possible mechanism by the jail authorities to communicate with the concerned investigation officer about the release of the accused in a given case. First, that would probably sufficient enough to safeguard the interest apprehension expressed by the prosecution department. First, at any rate, such apprehensions would not permit the jail authorities to detain a person who has the benefit of grant of bail by a duly constituted court, even for a minute under the pretext of body warrant. First, with these observations, I think this will cover everything. With these observations, in view of the fact that the petitioner is already released by the jail authorities Tumkuru, no further orders needs to be passed in this case. Accordingly, petition stands disposed of. Next. First, next para. Today, next para. Having said this, learned SPP 2 during the course of hearing with a memo, produces the copy of the circular issued by the Office of the Director General of Police, Prisons and Correctional Services, dated 10th March 2022, bearing number J2CR05-2022, with a memo. First, the circular reads as under. First, the circular would meet all apprehensions of the persons like petitioner at large in the state. First, this court with appreciation places the circular on record and made it as part of this order. First, with this, the said circular may also be circulated among all prosecutors across the state by the prosecution department. First, the order. First, next para. Therefore, following order is passed. This is verbally. In view of the fact that the petitioner is already released from the prison at Tumkuru, no further orders in this petition is necessary with regard to the petition prayer. First, accordingly, petition stand disposed of. First, the cooperation rendered by the SPP2 and the office and the officials of Prisons Department and Home Secretary is is placed on record with appreciation, not only for their cooperation, but also for their prompt action in passing in issuing a circular dated 10th March 2022, referred to Supra. Next para. Copy of this order be made available to the all the judicial officers in the district judiciary through Judicial Academy. Learned Registrar General shall take necessary steps in this regard. ಇನ್ನೇನಾದ್ರು ಸಣ್ಣ ಪುಟ್ಟದ್ ನಿಮ್ಗೆ ಏನಾದ್ರು ಮನ್ಸಿಗೆ ಬಂದ್ರೆ ಹೇಳಿ, 1 or 2 days ನಲ್ಲಿ ಕರೆಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಎನಿ ಅದರ್ ಥಿಂಗ್ ದಟ್ ಯು ವಾಂಟ್ ಮಾಡ್ತಾರೆ. My powers in that regard is limited. So that's why I said learned Registrar General shall take necessary. It is the prerogative of the Honorable Chief Justice. I'll be usurping my power if I speak a single word extra in my order. It is always for the persons to take it. Yes, please. Yes, please. Two circulars ಅಂತ ಬರ್ಬಿಡಿ. ಎರಡು ರೆಫರ್ ಮಾಡಿ. ಎರಡು ಇದೆ ಅದರಲ್ಲಿ ನಮ್ದು. Two circulars ಅಂತ. Two circulars ಅಂತ. ನಾನಲ್ಲ I will incorporate in this suitable place. Don't worry. I'll go through that. See, the whole idea is to see that, yesterday's my premium has yielded some dividend at least today. Premium is dividend. Across the state, ತುಂಬಾ ಜನ ಇದ್ದಾರೆ. ಅವ್ರನ್ನೆಲ್ಲ ಬಿಟ್ಬಿಡಿ. No, the idea is to see that, those who have the benefit of bail, their personal liberty is to be protected. That is the paramount consideration. If you have authority, jolly well you keep them. Nobody comes in the way. In fact, that is your duty. Nobody can say you should not do that. But if there is no authority, stay away. Our ಹೆಸರು ಹೇಳಿದ್ರೆ ಅದನ್ನೇ ಬರೀತಾರೆ. Yes, we have met earlier. Because of mask, I could not identify you. Sorry. See, Alok Mohan, Director General, so and so, present. We have met earlier. We had interactions in different capacity. Registrar General iddaga we had a meeting. We had a detailed meeting. Honorable Justice Walk was there. We had all that. Because of mask, yesterday I was trying to place him, but I could not because of the mask. So it's all right. Very nice. Things have happened. ತಮಗೂ ಗೊತ್ತಾಗಿದೆ ಈಗ ಮನುಷ್ಯರಿಗೆ ನೀವು ಎಷ್ಟು ಸಾಧ್ಯವಾಗುತ್ತೋ, ಮನುಷ್ಯರು ಅಂತಲ್ಲ, ಪ್ರತಿಯೊಬ್ಬ ಪ್ರಜೆಗೆ ಸಂವಿಧಾನ ದತ್ತವಾಗಿರ್ತಕ್ಕಂಥ ಹಕ್ಕುಗಳೇನಿದೆ ಅದನ್ನ ಕೊಡಮಾಡಿಸಲ್ಪಡೋದೇ ಮುಖ್ಯ ಉದ್ದೇಶ ಈ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಕೋರ್ಟ್ ಇಂದು. Especially in criminal matters, day in and day out, people are suffering for one reason or the other. ಇದೇ ಕೇಸ್ ತೆಗೆದುಕೊಳ್ಳೋಣ. ಈತ ಏನೋ ಒಂದು ಕೇಸ್ ಸಿಕ್ತು, ಮಾಡಿದ್ದಾರೆ, ಬಂದಿದ್ದಾರೆ ಕೋರ್ಟ್ಗೆ, ಆಯ್ತು. ನಾನು ಯು ಕ್ಯಾನ್ ಗೋ ಫಾರ್ ದಿ ರೀಕಾಲ್ ಆಫ್ ಬಾಡಿ ವಾರೆಂಟ್ ಅಂತ ಒಂದು ಲೈನ್ ಬರ್ದಿಟ್ಟಿದ್ರೆ, he would have gone there again, made an application. Why cumbersome process when it could be easily dealt with? Therefore, this necessity arose to take this matter, trouble the SPP, trouble you all, to call them. Understand, let us understand the rules of the game and play in accordance with the rules of the game. Nothing more than. No other issue. This was one which is haunting me when I was a district judge myself. In fact, I passed a detailed order in the rural court. This order I passed in 2008 itself in Kalburgi. Somehow it did not have the occasion to reach up to this stage. Now that the occasion has come, so therefore I thought that it should be done in this fashion. Ide tara ಒಂದು. ಎರಡನೇದು, it may not be out of place here to mention. SPP ಅವರು ಇದ್ದಾರೆ, ನಿಮಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ. ಆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಮುಂದ್ಗಡೆ ಕೊಳಿತಾ ಬಿದ್ದಿದೆಯಲ್ಲ ಗಾಡಿಗಳು, ಅದಕ್ಕೂ ಒಂದು ದಾರಿ ತೋರಿಸ್ತೀನಿ. ನೀವು ಒಂದ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಬನ್ನಿ, ಇದೇ ತರದ್ ಒಂದು ಆರ್ಡರ್ ಬರೀತೀನಿ, ಅದಕ್ಕೂ ಇದೇ ತರನೇ ಪರಿಕರಗಳನ್ನೆಲ್ಲ ತಯಾರಿ ಮಾಡಿ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ. ಪವರ್ಸು, ರಿಕ್ವೈರ್ಮೆಂಟು, ವೇರಿಯಸ್ ಡಿಸಿಷನ್ಸ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟು, ಸುಪ್ರೀಂ ಕೋರ್ಟು, hours of 451 and 457, ಅದಕ್ಕೂ ಒಂದು ದಾರಿ ಮಾಡ್ಬೇಕು. ಪ್ರತಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಮುಂದೆ ಅವೆಲ್ಲ ಅನಿಷ್ಟ ನಿಂತಂಗ್ ನಿಂತ್ಬಿಟ್ಟಿದ್ದಾರೆ. Not only that, giving scope for further problems. On the day when we direct that the particular seized vehicle to be produced for the court, again it is a Herculean task for the investigation officer. Our station ಅಲ್ಲಿ ಇರಲ್ಲ, ಬೇರೆ ಯಾವ್ದೋ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ. ಅವರು ಆ ಸ್ಟೇಷನ್ ಆಫೀಸರ್ ನ ಲೆಕ್ಕ ಹಾಕೋಬೇಕು. ಯಾವ್ದೋ ಟೆಂಪೋನ ಟ್ರಾಫಿಕ್ ನಲ್ಲಿ ಹಿಡಿಬೇಕು, ಆಮೇಲಿಂದ ಅವನ್ದ್ರಲ್ಲಿ ಹಾಕೊಂಡ್ ಬರ್ಬೇಕು. ಅದಕ್ಕೆ ಪೆಟ್ರೋಲ್ ಇಲ್ಲ, ಟೈರ್ ಇಲ್ಲ, ಚೇನ್ ಇಲ್ಲ. ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಏನ್ ಮಾಡ್ಬೇಕು ಇದನ್ನ? ಅದು ನಿಜವಾದ ಸ್ಕೆಲಿಟನ್ ಆಗಿರುತ್ತೆ. ಅದ್ರಲ್ಲಿ ಏನು ಇರೋದಿಲ್ಲ ಬೇಕಾದಂಥದ್ದು. ಸುಮ್ನೆ ಜಸ್ಟ್ ಲೈಕ್ ದಟ್ when you have an occasion, you just look at it. There is one tempo or ಒಂದು ಟೆಂಪೋನೋ ಅಥವಾ ಒಂದು ಪಾಲಿಸೋ ಒಂದು ಯಾವ್ದೋ ಮಾರುತಿ ಆಮ್ನಿ ಕಾರೋ ಯಾವ್ದೋ ನನ್ಗೆ ಸರಿಯಾಗಿ ನೆನಪಾಗ್ತಾ ಇಲ್ಲ. ಅದೊಂದಿದೆ ವಿಜಯನಗರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹಿಂಭಾಗದಲ್ಲಿ. ಅದ್ ನೋಡಿ, ಇಟ್ ಹ್ಯಾಸ್ ಬಿಕಮ್ ಪ್ರಾಕ್ಟಿಕಲಿ ಎ ಡಸ್ಟ್ಬಿನ್. Tomorrow, if you are asked to produce that vehicle before the court, what are you to do? ಏನಾದ್ರು ಒಂದು ದಾರಿ ಮಾಡ್ಬಿಡಿ, ಅದೊಂದು ಮಾಡ್ಬೇಕು. ಆಮೇಲೆ repeatedly we have said that after demonetization, the police department has to take note of the old currency which is now not in circulation to be taken off from the court. ಅದಾಗಿಲ್ಲ. ಪ್ರತಿ ಕೋರ್ಟಿನ ಟ್ರೆಷರಿ ಬಾಕ್ಸ್ ಒಳಗಡೆಗೆ ಆ ನೋಟ್ಗಳಿವೆ. ಏನ್ ಮಾಡೋದು? ಅದೊಂದನ್ನು ಗಮನ ವಹಿಸಿ. ಈ ತರ ಒಂದು 10 ಗುರ್ತಾಕೊಂಡು ಇಟ್ಕೊಂಡಿದ್ದೀನಿ, which I felt during the course of my district judgeship that these are all the matters to be corrected. One by one we will take it up as the case arises. ಯಾವಾಗ ಬರುತ್ತೋ ಅವಾಗ ಹೇಳ್ಕೊಳ್ಳಿ. ಅದಕ್ಕೊಂದು ಸೂಕ್ತವಾದ ನಿರ್ದೇಶನ ತೆಗೆದುಕೊಳ್ಳಿ. ತಮ್ಮ ಕಡೆಯಿಂದ ಏನ್ ಸಹಕಾರ ಬೇಕೋ ಅದ್ ನೀವು ಕೊಡಿ. ಕೋರ್ಟ್ನವರು ಜನಗಳ ಪ್ರಜೆಗಳ ಹಿತರಕ್ಷಣೆಗೆ ಹಾಗೂ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ನೀಡ್ಗೆ ಸಮಾಜ ಅಂತ ತೆಗೆದುಕೊಂಡಾಗ ಐ ಆಮ್ ನಾಟ್ ಐಸೋಲೇಟಿಂಗ್ ದಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಈಸ್ ಅವೇ ಫ್ರಮ್ ದಿ ಸೊಸೈಟಿ. ದೇ ಆರ್ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಸೊಸೈಟಿ. Even the court is part of the society. So we will rise to the occasion, pass such orders time and again, wherever it is necessary, irrespective of the whatever be the requirement. Rights of the parties must be protected, paramount interest. It should help the prosecution department protect the rights of the general citizen. This is the only point. ಅದನ್ನ ಮಾಡ್ತಾ ಹೋಗ್ಬಿಟ್ರೆ ಇನ್ನೊಂದ್ 2-3 ಈ ತರ ನಿಮ್ಮ ಪ್ರಾಕ್ಟಿಕಲ್ ಪ್ರಾಬ್ಲಮ್ಸ್ ಇದೆ. ನಮ್ಮ ಟೆನ್ಯೂರ್ ಬಂದಾಗ, ನನ್ನ ಟೆನ್ಯೂರ್ ನಲ್ಲಿ ಇದ್ದಾಗ ಆ ತರದಿದ್ರೆ this court is always ready to come out with such possible methodology where practical solutions can be found. All cannot be the part of CRPC was drafted long back. None of them envisaged those things at that point of time. Technology, so many things have come up. New types of crimes have been there. So many issues have cropped up. So adella nodi enen beko ella madona. Anyway, court is grateful to all of you for your time and cooperation. ಅದನ್ನ ಇನ್ನೊಂದಿನಮ್ಮ ನಿಮ್ದು ಅದೇನೇನೆ ಬರ್ಕೊಳ್ಳಿ. ನಿಮ್ದ್ರಲ್ಲೂ ಬಿಡ್ತಾರೆ, ಅದ್ರಲ್ಲೇನೋ ಇನ್ನೊಂದು ವಾರೆಂಟ್ ಅಂತ ಇಶ್ಯೂ ಆಗ್ಬಿಟ್ಟಿದ್ಯಂತೆ ನಿಮ್ದ್ರಲ್ಲಿ. ಸೊ ಅದನ್ನ ನೀವು ಆ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿರೋದಕ್ಕೆ ಮಾಡಬಾರ್ದು ಅಂತ ಬರೀತೀನಿ, ಬರ್ಕೊಳ್ಳಿ. This court by order dated so and so in 1396 of 2022, passed a detailed order. First, this is a similar petition where the petitioner is detained in the prison even after he obtained the bail in original case yavadappa? Original case ಹೇಳಿ ವಕೀಲ್ರೆ. ಅರೆಸ್ಟ್ ಆಗಿದ್ದ ಯಾವ್ದ್ರಲ್ಲಿ? Even though he has been enlarged on bail in crime number 298 of 21 of ಯಾವ ಪೊಲೀಸು? ಯಲಹಂಕ ಪೊಲೀಸ್. ಫಸ್ಟ್ ಆಯ್ತಾ? ಯಲಹಂಕ ಪೊಲೀಸ್. ಇದು ಯಾವ್ದು? ಓಲ್ಡ್ ಟೌನ್ ಪೊಲೀಸ್. ಫಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ಪರ present first petitioner herein is also secured his presence in respect of a crime number 449 of 2021, Rajgopal Nagar police station. First, the accused is continued in judicial custody even after he had the benefit of the bail order in crime number 298 of 2021. First, jail authorities not entitled to keep the accused in custody any longer in respect of crime number 449 of 2021 under the pretext of issue of body warrant by the learned judge issued in 449 of 2021. First, next para. Suffice to say that the jail authorities, first, however, learned SPP submits that when the petitioner was produced in crime number 449 of 2021, the learned judge has authorized the jail authorities by remanding the present petitioner in the said case. First, when there is no arrest at all, the learned judge who is seized of crime number 449 of 2021 would not have ordered for the remand of the accused in the judicial custody. First, according more so when he is brought before the court in the body warrant. First, it is always open for the investigation officer of crime number 449 of 2021 to arrest him in the said case and if necessary, he be dealt with in accordance with law. At any rate, jail authorities cannot retain the petitioner who has been sent to the judicial custody in crime number 298 of 2021 as he has the benefit of order of bail in respect of the said case. Observing first, with the above observation, following order is passed. Petition be immediately released by the Parapanagarara, jail superintendent Parapanagarara, who is in custody in respect of crime number 298 bar 2021, as the petitioner is having the benefit of bail by order dated 298 al 21/2022. First, however, this order shall not come in the way of the investigation officer of Rajgopal Nagar Police Station who is investigating the matter in crime number 449 of 2021. First, next para. Necessary first, the jail authorities. First, next para. The registrar judicial shall issue shall communicate this order to the jail superintendent Parapanagrahara with the operative portion. First, operative portion on ಮಾಡ್ಕೊಡ್ತೀರಿ ಮುಗಿಸ್ತಾರೆ. ನೀವು ಹೋಗಿ ಅರೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. ನೀವು ಅದರಲ್ಲಿ ಅರೆಸ್ಟ್ ಆದ್ರೆ ಮತ್ತೆ ರೆಗ್ಯುಲರ್ ಬೇಲ್ ತಗೋಬೇಕು. ನಾನೇನು ಮಾಡ್ತಾ ಇಲ್ಲ, ಬಿಟ್ಬಿಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ನೀವು ಇನ್ನೂ 4 ಕೇಸ್ ಇದ್ರೆ ಅದಕ್ಕೆಲ್ಲ ಇಲ್ಲ ಅವ್ರಿಗೆ ಗೊತ್ತಾಯ್ತು, ನನ್ಗೆ ಅರ್ಥ ಆಗತ್ತದು. ಅಣ್ಣಯ್ಯ, ವೆರಿ ಸಿಂಪಲ್ ಪಾಯಿಂಟ್. ನಿಮ್ಗೆ 220 ಅಲ್ಲಿ ನಿಮಗೆ ಬೇಲ್ ಆಗಿದೆ, ಅದ್ರಲ್ಲಿ ಬಿಡ್ಬೇಕು. ಅವರು ಈ 449 ಇಟ್ಕೊಂಡು ಉಳಿಸ್ಕೊಂಡಿದ್ದಾರೆ. 449 ಅಲ್ಲಿ ಉಳಿಸ್ಕೊಳಕ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿ ಬರ್ದಿದ್ದೀನಿ. ಬಿಡ್ತಾರೆ. ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ಅವರು ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಆರ್ಡರ್ನ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತಾರೆ. ಗೊತ್ತಾಯ್ತಲ್ಲ, ಇವತ್ತು ಸಾಯಂಕಾಲನೇ ನಾನು ಅದನ್ನ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಮಾಡ್ಕೊಟ್ಬಿಡ್ತೀನಿ. ಅದನ್ನ ತಗೊಂಡ್ಬಿಟ್ಟು ನೀವು ಕಮ್ಯುನಿಕೇಟ್ ಆಗುತ್ತೆ, ನೀವು ಅದನ್ನ ಜೈಲ್ ಅಥಾರಿಟಿಗೆ ಫ್ಯಾಕ್ಸ್ ಮಾಡಿರ್ತೀವಿ ನಾವು. ನಿಮ್ಮವನ್ ಹೊರಗಡೆ ಬರ್ತಾನೆ. ರಾಜಗೋಪಾಲ್ ನಗರದವರು ಇವತ್ತು ನಾಳೆನೋ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಹೋಗಿ ರೆಗ್ಯುಲರ್ ಆಗಿ ಬೇಲ್ ತಗೊಳ್ಳಿ. 449 ಅಲ್ಲಿ ಕೊಡ್ಲಿಲ್ವಾ, ಮುಂದೆ ಇದ್ದಿದ್ದೇ ಇದೆ. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ನಾನೇನು ಹೇಳಲ್ಲ. 449 ಆದ್ಮೇಲೆ 549 ಇದ್ರೆ ನಾನೇನು ಮಾಡಕ್ಕಾಗ ಇರುತ್ತದು, ನೋನ್ ಕ್ರಿಮಿನಲ್. ಇನ್ಫ್ಯಾಕ್ಟ್ ಅದನ್ನೇ ನಾವು ಬರ್ದಿದ್ದು. ಯಾವ್ದು ಬೋತು ಇರೋದೇ ಒಂದು, ಕನೆಕ್ಟ್ ಯಾವ್ದು ಇಲ್ಲ, ಒಂದೇ ತರದ್ದಿರ್ಲಿ ಅಂತ ಹಾಕೊಂಡಿದ್ದು ಅಷ್ಟೇನೆ. 1488 ಇಸ್ ನಾಟ್ ಕನೆಕ್ಟೆಡ್. ಇನ್ಫ್ಯಾಕ್ಟ್ ಅದ್ರಲ್ಲಿ ಅವ್ರು ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಮತ್ತೆ ಅವರೇ ಒಂದು ಸರ್ಕ್ಯುಲರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆ ಸರ್ಕ್ಯುಲರ್ ಆದ್ಮೇಲೆ ಇವತ್ತು ನಿಮ್ಮನ್ನ ಬಿಟ್ಬಿಡ್ತಾರೆ. ಆದ್ರೂ ಕೂಡ ನಾವು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತಾ ಇದ್ವಿ. ಹಾಗಂತ ಅಂದ್ಬಿಟ್ಟು ನೀವು ರಾಜಗೋಪಾಲ್ ನನ್ಗೆ ಅರೆಸ್ಟ್ ಮಾಡ್ಬೇಡ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ರಾಜಗೋಪಾಲ್ ಐವೋ ಹೋಗಿ ಜೈಲ್ ಹತ್ರನೇ ಅರೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ನನ್ನನ್ನು ಕೇಳ್ತೀವಿ. ಗೊತ್ತಾಯ್ತಲ್ಲ, ಯು ಆರ್ ಬೌಂಡ್ ಟು ಬಿ ದೇರ್. ನೀವೇ ಹೋಗಿ ಅಪಿಯರ್ ಆದ್ರೂ ಮುಗ್ದೋಯ್ತು ಅಷ್ಟೇ. ಏನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಕೊಳ್ಳಿದ್ರೆ ಟೈಮ್ ಉಳಿಯುತ್ತೆ ಅಲ್ವಾ? ವೆರಿ ಸಿಂಪಲ್. ಇನ್ನೊಂದು ಪಾಯಿಂಟ್ ಇತ್ತು, ಅಫ್ಕೋರ್ಸ್ ಐ ಡಿಡ್ ನಾಟ್ ಡೀಲ್ ವಿತ್ ಇಟ್. ವಾಟ್ ಇಫ್ ಐ ಆಸ್ ಫಾರ್ ಎ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್? ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ತಗೋಬೋದಲ್ಲ. ಇಫ್ ಇಟ್ ಇಸ್ ಎ heinous offense, may definitely obtain anticipatory bail and join in it. ಬರೀ ಅಂದ್ರೆ ಒಂದ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಸೇರಿಸಿದ್ರು. ಸರಿ, ಅದಕ್ಕೆ ಇಟ್ಸ್ ಆಲ್ ರೈಟ್. ಸಿ ಪಾಯಿಂಟ್ ಈಸ್ ದೇರ್, ನೋ?
That is the right given under there.
Yes.
That is the right given. They are not like that. We need not even tell us. Otherwise also they can do it.
ಏನಾಯ್ತು? ಏನಂತಾರೆ ರಾಘವೇಂದ್ರ ಅವರು?
ರಾಹುಲ್ ರೈ.
ಯಾರ ಹೆಸರು? ರಾಹುಲ್ ಅಂತನಾ? ಮತ್ ರಾಘವೇಂದ್ರ ಅಂದ್ರೆ 3 ದಿನದಿಂದ ಸುಮ್ನೆ ಇದ್ದಾರೆ, ಹೋಗ್ಲಿ ಬಿಡಿ, ಗುರುವಾರನೋ ಶುಕ್ರವಾರನೋ. ಎಷ್ಟತಿ ರಾಘವೇಂದ್ರ ಅಂದ್ರೂ ಪರವಾಗಿಲ್ಲ, ರಾಹುಲ್ ರೈಯ ನೀವು? ವಿಶ್ವಮೂರ್ತಿ ಅವ್ರನ್ನ ವಿಶ್ವಕರ್ಮ ಅಂತಿದ್ದೆ. ಆಯ್ತು, ವಿಶ್ವಮೂರ್ತಿ, ನೀವು ರಾಹುಲ್ ರೈಯ? ರಾಹುಲ್ ರೈ, ನೀವು ಮಂಗಳೂರಿನವ್ರ? ವೆರಿ ಗುಡ್. ರಾಘವೇಂದ್ರ ಅಂತ ಒಬ್ರು CGP ಆಫೀಸಲ್ಲಿ ಇರ್ಬೇಕೇನೋ ಅಲ್ವಾ? ಇದ್ರೇನೋ. ಎನಿವೆ, ರಾಹುಲ್ ರೈ, ಹೆನ್ಸ್ಫೋರ್ತ್ ಐ ವಿಲ್ ಕರೆಕ್ಟ್ ಇಟ್. ಅಲ್ಲೆಲ್ಲಾರು ಬಂದ್ಬಿಟ್ಟಿದೆ ಆರ್ಡರ್ ರಾಘವೇಂದ್ರ ಅಂತ, ಎಲ್ಲ ತಾನೆ? ಸರಿ ಸರಿ ಸರಿ. ಇಲ್ಲ, ನಾನು ಇನ್ಮೇಲೆ ತಿಳ್ಕೊತೀನಪ್ಪ, ಅದಕ್ಕೆ. ಅಲ್ಲ, ಕರೆಕ್ಟ್ ಆಗಿ ಅವ್ರ ಹೆಸರನ್ನ ಕರೆದ್ರೆ ಅವ್ರ ಪ್ರೀತಿ ಜಾಸ್ತಿ. ನನ್ಗೆ ಒಂದ್ಸತಿ ಒಬ್ರು ಒಂದ್ ಹೆಸರು ಹೇಳ್ಬಿಟ್ರೆ ಮುಗ್ದೋಯ್ತು. ಇನ್ನ ನೀವು 20 ವರ್ಷ ಆಗಿ ಕೇಳಿದ್ರು ನಾನು ಹೇಳ್ತೀನಿ ಅವ್ರ ಹೆಸರು. ದಟ್ಸ್ ನಾಟ್ ಎ ಪ್ರಾಬ್ಲಮ್. ಆ ವ್ಯಕ್ತಿನ ಅವ್ರ ಹೆಸರಿಂದ ಕರೆದ್ರೆ ಆಗ ಸಿಗೋ ಆಪ್ಯಾಯತೆ ಹಾಗೆ ಸಿಕ್ಕೋದಿಲ್ಲ. ಅವ್ರ ಹೆಸರು ಹಿಡಿದು ಕರೆದ್ಬಿಡಿ ನೀವು, ಅವ್ರಿಗೆ ತುಂಬಾ ಆಪ್ಯಾಯಮಾನ ಅನ್ಸುತ್ತೆ. ರೀಸೆಂಟ್ಲಿ ಹ್ಯಾಡ್ ಇದು ಸಿಟಿಂಗ್ ಎಟ್ ಕಲಬುರ್ಗಿ ಅಲ್ಲ, ಪ್ರಾಕ್ಟಿಕಲಿ ಎವ್ರಿ ಅಡ್ವೊಕೇಟ್, ದಟ್ಸ್ ಅಬೌಟ್ 10 years that I left ಕಲಬುರ್ಗಿ. ಗಿಫ್ಟ್ ಆಸ್ಕರ್ ಫರ್ನಾಂಡಿಸ್ ಅವ್ರು ಹಾಗೆ ಇದ್ರು. ಆಸ್ಕರ್ ಫರ್ನಾಂಡಿಸ್ ಅಂತ ಇದ್ರಲ್ಲ, ಅವ್ರು ಹಾಗೆ ಇದ್ರು. ಅವ್ರಿಗೆ ಒಂದು 3000ದಿಂದ 4000 ಜನ ಕಾರ್ಯಕರ್ತರ ಹೆಸರು ಮತ್ತೆ ಅವರ ಅಡ್ರೆಸ್ರು, ಅವ್ರ ಮನೆ ಅಡ್ರೆಸ್ ಎಲ್ಲ ನೆನಪಲ್ಲಿತ್ತು. I had a client who knew not only the name but their landline telephone numbers also and their date of birth. ಯಾಕಂದ್ರೆ ಅವ್ರ LIC ಏಜೆಂಟ್. ಅಂಡ್ ಯಾರು ಮರ್ತಿರ್ಬೇಡ, ನಾವೇ ಮರ್ತ್ ಬಿಡ್ಬೋದು ನಮ್ ಬರ್ಡೇನ, ಅವ್ರು ಮರೆಯೋಂಗಿರ್ತಿರ್ಲಿಲ್ಲ. ಬಿಫೋರ್ 9 o'clock ಎಷ್ಟೊತ್ತಿಗೋ ಅವತ್ತು ಒಂದ್ ವಿಸಿಟ್ ಹಾಕಿ ಒಂದ್ ಸ್ವಲ್ಪ ಚಾಕ್ಲೇಟ್ ಕೊಟ್ಬಿಟ್ಟು ಹೋಗ್ಬೋದು. ಗ್ರೇಟ್ ಥಿಂಗ್. ಕೆಲವ್ರಿಗೆ ಅದೊಂದು ಇರುತ್ತೆ. ಅಲ್ಲ, ಒಂದು ನಿಜ ಏನು ಅಂತಂದ್ರೆ, ಮೊಬೈಲ್ ಬಂದು ನಮ್ಮ ಕೆಪಾಸಿಟಿನ ಕಡಿಮೆ ಮಾಡ್ಬಿಡ್ತು. ಈಗ ಕಿನ್ ಇರ್ತಾರಲ್ಲ, ನಮ್ಮ ಮನೆಯವ್ರದೇನೆ, ಸ್ಪೌಸ್ದು, ಚಿಲ್ಡ್ರನ್ದು ನಂಬರ್ ಹೇಳಲಿಕ್ಕೆ ಆಗುದಿಲ್ಲ ನಮ್ಗೆ. ಅದೇ ನಮ್ಮ ಆಫೀಸ್ದು ಓಲ್ಡ್ 5 digits ಟೆಲಿಫೋನ್ ನಂಬರ್ ಇತ್ತು. 5 digits ಟೆಲಿಫೋನ್ ನಂಬರ್ ಇತ್ತು ನಮ್ಗೆ. ಆಮೇಲೆ ಅದು 6 digits ಆಯ್ತು. ಅದೇ ತರನೇ ನಮ್ಮ ಮನೇದಿತ್ತು 5 digits ಟೆಲಿಫೋನ್ ನಂಬರು. ಅದೆಲ್ಲ ನನಗೆ ನೆನಪಿದೆ. ಈಗ ನನ್ನ ಮಗಂದು ಮೊಬೈಲ್ ನಂಬರ್ ಕೇಳಿದ್ರೆ ನಂಗೆ ನೆನಪಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಎಲ್ಲ ಹೆಸರಲ್ಲಿ ಸೇವ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀವಲ್ಲ. ಸೊ ದೇರ್ ಫಾರ್ ಇಟ್ಸ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್. ಈ ಮೆಮೊರಿ ಟೆಸ್ಟ್ ಹೋದ್ರೆ ಇದೆಲ್ಲ ಕೇಳ್ತಾರೆ. ಈ ಕಷ್ಟ. ಈಗ ಏನ್ ಬೇಕಾದ್ರೂ ಮೊಬೈಲ್ ತೆಗೆದ್ರಲ್ಲೇ ನಮ್ದು ಅಂಗಡಿ ತೆಗೆದಂಗೆ, ಇಲ್ದರೆ ಇಲ್ವೇ ಇಲ್ಲ. ಫಾರ್ಚುನೇಟ್ಲಿ ದಿಸ್ ಕೋರ್ಟ್ ಇವನ್ ಟುಡೇ ಕ್ಯಾಲ್ಕುಲೇಟ್ಸ್ ಓನ್ಲಿ ಬೈ ಮ್ಯಾನ್ಯುಯಲ್ ಮೆಥಡ್. ನಮ್ಗೆಲ್ಲ ಈ ಫಿಂಗರ್ ಟಿಪ್ಸ್ ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಹೆಂಗ್ ಲೆಕ್ಕ ಮಾಡೋದು ಅಂತ. ನಾನು ಸುಮಾರು ವರ್ಷಗಳ ಕಾಲ 21ರ ಮಗ್ಗಿ, 22ರ ಮಗ್ಗಿ, 25ರ ಮಗ್ಗಿ, 30ರ ಮಗ್ಗಿ ಎಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೆ. ಸಾಧಾರಣ 1ರಿಂದ 10ಕ್ಕೆ ಕಳಿಸ್ಕೊಡ್ತಾರೆ, 10ರಿಂದ 20ಕ್ಕೆ ಕಳಿಸ್ಕೊಡ್ತಾರೆ. 21ನೇ ಮಗ್ಗಿ, 22ನೇ ಮಗ್ಗಿ ಎಲ್ಲ ಕಳಿಸ್ಕೊಡ್ತಾರೆ. ನಮ್ಗೆಲ್ಲ ಕಳಿಸ್ಕೊಡೋರು ಸ್ಕುಡ್. ಹೌದೌದು, ಅದಿತ್ತು. ಅದು ಫ್ರಾಕ್ಷನ್ಗೆ ಅನುಕೂಲ ಆಗುತ್ತೆ. ಅದು ಆಣೆ ಇದ್ ಕಾಲಕ್ಕೆ ಹಂಗೆ ಇತ್ತು. 16 ಆಣೆ ಅಂತಂದ್ರೆ 1 ರೂಪಾಯಿ, 4 ಆಣೆ ಅಂತ ಹಂಗೆ ಬಂದಿದ್ದು 25 ಪೈಸೆ. 25 ಪೈಸೆ 16 ಆಣೆ 1 ರೂಪಾಯಿ ಇತ್ತಲ್ಲ, ಅವಾಗ ಅದೇ ತರನೇ ಇತ್ತು. ಇಫ್ ಯು ಸಿ ಸೆಂಟಿಮೀಟರ್ಸ್ ಬರೋದಕ್ಕೆ ಮುಂಚೆ ಇಂಚಸ್ ಇದ್ದಾಗ ಹಾಗೆ ಇತ್ತು. ಇವಾಗೂನು ನಮ್ಮ ಈ ಕರಕುಶಲ ಕರ್ಮಿಗಳು, ಬಡಗಿ ಅವರು ಎಲ್ಲ ಮಾಡ್ತಾರಲ್ಲ, ಅವರೆಲ್ಲ ಲೆಕ್ಕ ಹಾಕೋದು 1 ನೂಲು 2 ನೂಲು ಅಂತಲೇ ಲೆಕ್ಕ ಹಾಕ್ತಾರೆ. ನೂಲು ಅಂತಂದ್ರೆ ಅದ್ರೊಳಗಡೆಗೆ 1/12 of an inch ಒಂದ್ ನೂಲು. ಸೊ ಅಲ್ಲಿ ಲೇತ್ ಕೆಲಸ ಮಾಡೋರ್ಗೆ 1/8 1/4 ಅಂತಂದು ಅಂದು ಅದೇ ಅಭ್ಯಾಸ ಆಗೋದು. ಈಗ ಅದು ಹೋಗ್ತಾ ಇದೆ ನೋಡಿ, ಬಿಕಾಸ್ ಆಫ್ ದಿ CNC ಲೇತ್ಸ್ ಅಂಡ್ ಅದರ್ ಥಿಂಗ್ಸ್ ಕಮಿಂಗ್ ಅಪ್ ಅಗೇನ್ ಇದು ಹೊಟ್ಟೋಗ್ತಾ ಇದೆ ಆ ಗುಣ. ಮಾಡ್ಕೊಳ್ಳುತ್ತೆ, ಪ್ರಿಸಿಷನ್ ಚೆನ್ನಾಗಿದೆ ಒಂದ್ ಸೈಜ್ ಅಲ್ಲಿ, ಆದ್ರೆ ಮನುಷ್ಯನ ಕೆಪಾಸಿಟಿ ಜೀನ್ಸ್ ಅಲ್ಲೇನೆ ಮುಟ್ಟು ಹೋಗುತ್ತೇನೋ ಅನ್ಸುತ್ತೆ. ಇದು ನೆಕ್ಸ್ಟ್ ಜನರೇಷನ್ಗೆ ಅದನ್ನ ನೆನ್ಪಿಟ್ಕೊಳ್ಳೋ ಶಕ್ತಿನೇ ಕಡಿಮೆ ಆಗ್ಬಿಟ್ರೆ. It's always better to harmonize both. Take the technology to the extent, don't give up your instinct. ಬರೆಯೋದು ನಿಂತು ಹೋಗಿದೆ, ಕಾಗದ ಬರೆಯೋದು ನಿಂತು ಹೋಗಿದೆ. ಈಗ ಮಕ್ಕಳಿಗೆ ಸ್ಕೂಲಲ್ಲಿ 5 ನಂಬರ್ಗೋಸ್ಕರ ಕಾಗದ ಬರೆಯೋದು ಬಿಟ್ರೆ ಕಾಗದ ಬರೆಯೋದು ನಿಂತು ಹೋಗಿದೆ. ಹೌ ಟು ಕಮ್ಯುನಿಕೇಟ್ ಅಂತಂದ್ರೆ ಕೇಳ್ತಾರೆ ಮಕ್ಕಳು, ಯಾಕೆ ಬೇಕು, ಒಂದು SMS ಕಳ್ಸಿದ್ರೆ ಸಾಲದ ಅಂತ. So we are heading to somewhat different aspect. All right. ಮಾಡಿ 1 or 2 days ನಲ್ಲಿ ಫೈನಲ್ ಮಾಡ್ತೀನಿ. 1 or 2 days ನಲ್ಲಿ ಫೈನಲ್ ಮಾಡ್ತೀನಿ. ಬಿಕಾಸ್ ಇನ್ನೊಂದು ಹಳೇದೊಂದು ಮಾಡ್ತಾ ಇದೀನಿ. It may take some time. This weekend probably I will finalize both subject to other country. ಇದು ಅವ್ರದ್ದು ಆಗಿದೆ, ಅವ್ರದನ್ನ ಮಾಡ್ಬಿಡಕ್ಕೆ. ನಿಮ್ದು ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಇವತ್ತು ಹೋಗುತ್ತಪ್ಪ. ಅವ್ರ ಸರ್ಕ್ಯುಲರೇ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. They have issued a circular that is also applicable to the Parapanagra. ಹೇಳಿ ವಕೀಲ್ರೆ. ಈ ಆರ್ಡರ್ ಬೆನಿಫಿಟ್ ತಾವು ತೆಗೆದುಕೊಳ್ಳಿ.